The memos, no memos for 2:30 today. Give all the memos. Tomorrow 2:30 move ಮಾಡಬೇಕು ಅಂದ್ರೆ ನಾಳೆ ಬೆಳಗ್ಗೆ ಮೂವ್ ಮಾಡಿ. ಮಿಕ್ಕಿದೆಲ್ಲ ಕೊಟ್ಬಿಡಿ. ನಾಳೆ ಮೂವ್ ಮಾಡಿ ಅದು. ನಾಳೆ. Yes. Give all the memos. ನಾಳೆ ಬೆಳಗ್ಗೆ ಮೂವ್ ಮಾಡಿ. ಎಸ್ ಕೊಡಿ. being spoken to ಇದ್ರೆ ಕೊಡಿ. Give 257 253 okay yes ಕೊಡಿ. give it madam, give all the memos. ಎಲ್ಲ ಕೊಡಿ sir, ಎಲ್ಲ ಮೆಮೊ ಕೊಡಿ. give all the memos. It will come on designated days, whatever it is. Give all the memos. Give all the memos. I'm not stopping any memo. Please give. They will come only on the designated days. Please give. ಎಲ್ಲ ಕೊಡಿ. ಅಯ್ಯೋ ಪರವಾಗಿಲ್ಲ ಕೊಡಿ ಸರ್. ಟ್ಯಾಕ್ಸ್ ಮಾಡಿ ಟ್ಯಾಕ್ಸ್ ದಿನ ಬರುತ್ತೆ ಕೊಡಿ. ಪರವಾಗಿಲ್ಲ ಸರ್ ಬರುತ್ತೆ. ಇನ್ನು ಗುರುವಾರ ಇದೆ ಬರಿ. No problem sir. Let them attach. We'll detach. Yes. Give it. ಕೊಡಿ sir. No tomorrow sir. It will come on tax day, that is Thursday. Give it. Yes. ಎಲ್ಲ ಕೊಡಿ. ನಾಳೆ ಬೆಳಗ್ಗೆ ಮೂವ್ ಮಾಡಿ 2:30 ತಗೊಂತೀನಿ. No submissions. Please give the memos. No wasting time on 402 matters. Please give. Please give sir. Adjournment ಆಮೇಲೆ ಕೊಡಿ. ರಿಪೋರ್ಟಿಂಗ್ ಸೆಟಲ್ಮೆಂಟ್ ತಗೊಳ್ಳಿ. Yes, give all the memos. Yeah, threat of mandamus ಇದ್ರು ಪರಲ್ಲ ಕೊಡಿ ಸರ್. No sir. ಆಯ್ತು ಕೊಡಿ, ಮೆಮೊ ಕೊಡಿ, ಪರವಾಗಿಲ್ಲ ಕೊಡಿ ಸರ್. give the memos sir. 10 ಬಾರಿ ಮೂವ್ ಮಾಡಿದ್ರು ಪರವಾಗಿಲ್ಲ, ಅದು ಬರೋ ದಿನಾನೇ ಬರೋದು ಕೊಡಿ. ಈ 3 ಬಾರಿ 10 ಬಾರಿ ಅಂತ ತಗೊಳ್ಳೋದೇ ಇಲ್ಲ ಮೆಮೊ ನಾನು. ನಮಗೆ ಕೆಲಸ ಎಷ್ಟು ಕೆಪಾಸಿಟಿ ಇದೆ ಅಷ್ಟು ಮಾಡಕ್ಕಾಗತ್ತೆ. ಕೊಡಿ ಸರ್ ಎಲ್ಲ. ಡೆಲಿವರಿ ವಾರಂಟ್ ಇದ್ರೆ ನಾಳೆ ಬೆಳಗ್ಗೆ 2:30 ತಗೊಂತೀನಿ. ಬೆಳಗ್ಗೆ ಮೂವ್ ಮಾಡಿ. ಇವತ್ತು ಮೂವ್ ಮಾಡಿದ್ರೆ ಮೆಮೊ ಎಲ್ಲೋ ಹೋಗ್ಬಿಡುತ್ತೆ. No problem sir. On tax day it will come. Give it. It will come on tax day. Tax day is Thursday. Give it. Please give sir. ಎಲ್ಲ ಮೆಮೊ ಕೊಡಿ. Tomorrow you move. ಡೆಲಿವರಿ ವಾರಂಟ್ 2:30 ಬೇಕಾರಲ್ಲ ನಾಳೆ ಮೂವ್ ಮಾಡಿ. ಏನ್ ನೆಕ್ಸ್ಟ್ ಎಮರ್ಜೆನ್ಸಿ ಯಾವಾಗ ಆಗುತ್ತೆ ಸರ್? ಬಿಡಿ, ಅದು ನಾಳೆ ಕೊಡಿ. ಮತ್ತೆ 2:30 ಅಂತೂ ಇವತ್ತು ಆಗೋದೇ ಇಲ್ಲ. ಕೊಡಿ. No 2:30 matter. Please give sir. Give it madam. We'll see. Give it. GMCPC. Fresh matter.
That's one matter. Tomorrow.
Oh, you 11th of next month. No problem. Give it madam. It will come on Monday. Fresh matter. Pending. Pending CRP Friday. Pending CRP. No, Friday is the designated day. It will come. No madam, not at all. On Friday it will come. That's all. Give it. No specific date in any pending matter. Give it. Not next Friday. This Friday. You don't want this Friday? You want next Friday? No date then. Yes. Date not according to you. Yes. Give it madam. Fresh matter. Next Monday. Kodi.
Matter is.
Give it. Give. No problem. Give it. Yes. Fresh matter. Nade GMCPC ಉಳಿದಿದ್ರೆ ನಾಡಿದ್ದಕ್ಕೆ ಹಾಕಿ ಮಾಡಿ. Yes. No tomorrow madam. Not at all.
One matter for 2:30.
No sir.
I'll just.
No.
Just
Heavens are going to fall.
Tomorrow,
what is that? Tell me.
What has happened is an appeal before the IT is listed tomorrow.
All right.
Cause list was issued on 14. Earlier, my lords, a judgment came to be passed, my lords, on A generated judgment. So, my lords, we had requested for recusal of 2 judges. Then it was recalled because it was reported in the papers that it was A. There were no judgments which was referred to by the tribunal. Now, my lords, the one of the.
They will come tomorrow.
Tomorrow is the hearing. They want to pass.
Hearing ಅಲ್ಲಿ ಏನಾಗ್ಬಿಡುತ್ತೆ?
Pass ಮಾಡಿದ್ರೆ order.
ಮಾಡ್ಲಿ ಬಿಡಿ.
The entire thing.
Lock, stock, barrel. We will set it aside if it is that's the case.
Morning tomorrow.
Tomorrow you move it morning. I'll take it at 2:30.
because
I
it's,
assure whoever is moving at 2:30, if there is urgency, definitely I will take, but not today.
because only thing is it's the sixth matter in the list tomorrow before the IT, my lords. If they pass an order, this entire exercise.
No, if I take one, then I'll take many.
Hello,
Try to
we
understand.
have written a request to the president to, my lords, because of bias.
All right,
for
well,
transfer.
others, please give the memos. No, madam, call the cases. We'll see. Give the memo, we'll see. No, call the cases.
I may be pardoned for
Being
interrupting.
spoken to the Tagoli. Yes. Call the cases, please.
I may be pardoned.
Serial number 137, my lords.
No adjournments in the morning. Yes. Unless you want to withdraw.
My lord, serial number 265, my lords.
You want
The
to withdraw?
matter will be- Yes, my lords. And
You want to
liberty
withdraw?
may be given to, yes, my lords.
All right.
Liberty may be given
265
to
on
file
Barpadi.
a fresh appeal, my lords.
265. Yes.
ಅದು 7 rule 11 D ಮೇಲೆ
No, 230.
ಅಲೋ ಆಗಿರೋದು. Appeal,
ಕೊಡಿ, ಕೊಡಿ.
appeal ಹಾಕೋದಕ್ಕೆ liberty.
Memo kodi. Yes. Yes. Serial number 1.
Please, may please, my lords. This is the
No,
land,
sir.
my lord.
Nothing. No 230 matter at all. Yes. Next.
My lord, my case.
Please.
Serial number 1.
Please.
No, I'm not taking a 230.
No, my lord. My serial number 1.
Serial number 1 ga.
Please.
ಅದಕ್ಕೆ ಯಾಕೆ Christine? Yes.
Please. I am online, my lords. Please. My
Learned
lord,
counsel.
please. Subject matter is not the subject matter of.
Or the learned senior counsel
please.
appearing for the petitioner. BP Hegde appearing for the petitioner. Learned HCGP 1. All others. M. Ajay Kumar is directed to accept notice. The petitioner shall serve set of papers upon the aforesaid counsel forthwith. List the matter on 9th September.
Please, till then, let them not precipitate, my lords. Enter into the
What
land. because-
precipitate? Compensation.
ಅಲ್ಲಲ್ಲ ಇದ್ರೊಳಗೆ this is not the subject matter of the acquisition. Let them not use this land, my lords. If they use this land or enter the land, my lord, make any constructions.
The petitioners, if in possession today, their possession shall not be disturbed by any act of the respondent. Yes, next.
Please.
Serial number 2,
Great.
Learned counsel Vasant is directed to accept notice for the respondent. Sorry, Vasant, it's BBMP. For the second respondent, 1 HCGP, 3 and 4 emergent notice. Next.
3.
And does it survive 2018? There is no representation on behalf of the petitioner. List after 4 weeks. Registry is directed not to list the matter prior to the expiry of 4 weeks. The pendency of this petition will not come in the way of any further proceedings before the concerned court. Next.
4.
Hearing for the petitioner.
2022 order. Survive ಆಗತ್ತೆ ಇವತ್ತು?
It is pending.
Order 14 Rule 5.
Yes, your lord. It is pending before the trial court.
Let it be pending. Yes. 3 years ಆದ್ಮೇಲೆ will not grant any stay. The emergent notice to the respondents. Next.
5.
Lordship, on record counsel or mother hospitalized ಆಗಿದ್ದಾರೆ ನೋಟ್.
ಕೇಸಲ್ಲಿ ಏನ್ ತೊಂದರೆ ಇಲ್ಲ, ಅದು ಹಂಗೆ ಇದೆ. 24 ವರ್ಷ ಆದ್ಮೇಲೆ ಏನ್ ಮಾಡ್ತಾ ಇದೆ? List the matter after 8 weeks. Registry is directed not to list the matter prior to the expiry of 8 weeks. Pendency of this petition will not come in the way of further proceedings before the concerned court.
6.
The learned counsel for the petitioner seeks adjournment ಅಂತ ಮಾಡಿ ಇದು ಮಾಡಿ. Yes, next.
6.
Appearing for the petitioner, my lord.
Yes. What
Appearing for
survives,
the
sir?
petition.
4 years ಆಗಿದೆ.
The matter is still pending before the trial court.
Matter will be pending 39 1 and 2 ಆಗಿ 4 years ಆಗಿದೆ. ಇವಾಗ what are you doing?
Emergent notice may be issued.
Emergent notice. Yes.
Much.
7.
Petitioners, my lord, regarding the FDP proceedings, my lord, the honorable trial court is pleased to put certain
Report of the court commissioner is
clauses of-
23/10/23. It is already accepted and proceeded. What survives
No,
today?
not accepted, my lord.
Yes, sir.
Not accepted.
Emergent notice to the respondent.
I may be permitted to serve notice
Petitioner
on
to
the
serve on the counsel who represents the
Respondent.
respondent in the trial proceedings. Next.
8.
Notice. Yes. 8 RB Sadashivappa ಇಲ್ವಾ? ಎಲ್ಲಿದ್ದೀರಾ? Yes, notice. Next.
9.
No representation on behalf of the petitioner. The order rejecting the application order 1 rule 10 is 10/1/2024. Further proceedings are not indicated, nor the petitioner is present, counsel for the petitioner is present. 8 weeks not to list, same order. Yes, next.
10,
No representation by of the petitioner. The findings of rejection of application under 39(1) and 2 is concurrent. List the matter after 8 weeks. Yes, next.
11,
26(9) allowed in part.
Uh,
1/4/24 today
There is no survey sketch and survey number.
ಎಲ್ಲ ಆಗಿದೆ. ಮತ್ತೆ
It is,
ಮೆಮೊ ಆಫ್ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ ಆಗಿಲ್ವಾ? ಅದು ಆಗಿದೆ. What survives?
notes,
Huh?
notice.
You urge all the contentions there before the court. What's the use of notice? Nothing. I will say, not, ಇದು ಪೆಂಡಿಂಗ್ ಇರೋದಲ್ಲಿ ಏನು ಕೊಟ್ಟ ಬರಲ್ಲ. Virtually rejection.
They have filed the application for.
No, I will issue notice. Pendency of this will not come in the way of proceedings before the court. It is virtually rejection. I will permit you to urge all the contentions there. Everything is over now. Report is accepted.
There is no survey sketch and survey number.
All right.
It is very
Emergent
difficult
note.
to survey.
No, notice to the respondents. Yes, next. Same order. Not will not come in the way.
12,
39(1) and 2 concurrent.
Lord, issuing my lord, seeking time, my lord. Senior is not in town, my lord.
Oh, no problem. Same 8 weeks. List after 8 weeks at the request of the counsel appearing for the petitioner. Pendency of this petition. Next.
13,
Kindly pass or notes.
Passover. Passover.
Is in that.
Police protection. Order ಯಾವಾಗಿಂದು? 21/24. ಇವತ್ತೇನಿದೆ?
I am
Police,
not, I am not a regular.
Proxy counsel.
Proxy ಅಲ್ಲ sir.
ಮತ್ತೆ?
My friend, my lords. Yes.
Friend. What kind of friend?
He's on the.
Yes. List after 2 weeks. Pendency of this petition. Next.
14,
Yes, sir.
Petitioner is death, my lord. I will take proper steps.
What proper steps? Objection ಬಂದಿಲ್ಲ ಇದು. Proper answer ಹೇಳಿ sir. 617 application 2 ವರ್ಷದಿಂದ ಆಗಿರೋದು.
During pendency of the petition, petitioner was died, my lord. That's why we are taking.
ಅದು ಎಲ್ಲಿದೆ? Where is the indication?
ಇಲ್ಲ, we will file
ಏನು ಹಾಕಿದ್ದೀರಾ?
ಅಲ್ಲ, ಇನ್ನ ಹಾಕಿಲ್ಲ. We will file.
Apparent counsel for the petitioner submits during the pendency of the subject petition, petitioner is no more and would seek time to take steps. 8 weeks pendency of this petition will not come in the way of further proceedings before the concerned court. Next.
15,
Suit for specific performance, not to alienate, temporary injunction was sought for, that was not granted, against which
15/3/24, sir. Now they are represented. I will direct you go and appear there. ಅಂದ್ರೆ ಏನು?
my request, my lord, is
ಈಗ 39(1) and 2 ರಿಜೆಕ್ಟ್ ಮಾಡಿಲ್ಲ.
ಮಾಡಿಲ್ಲ.
ಬರೀ ನಾಟ್ ಟು ಎಲಿನೇಟ್ ಕೇಳಿದ್ರಿ ಅದು ಕೊಟ್ಟಿಲ್ಲ. ಅವತ್ತಿನ್ನು ರೆಪ್ರೆಸೆಂಟ್ ಮಾಡಿರಲಿಲ್ಲ. ಇವಾಗ ಪಾರ್ಟೀಸ್ ಆರ್ ದೇರ್. ಐ ವಿಲ್ ಡೈರೆಕ್ಟ್ ದಿ ಅಪ್ಲಿಕೇಶನ್ ಟು ಬಿ ಕನ್ಕ್ಲೂಡೆಡ್ ಆನ್ಸರ್ಡ್ ಇನ್ 4 weeks.
But they are not yet appeared, my lord, before the trial court.
1 ವರ್ಷ ಆದ್ರೂ
Oh, service.
ಆಯ್ತು. ಇನ್ ಅಕಾರ್ಡೆನ್ಸ್ ವಿತ್ ಲಾ 4 weeks ಅಷ್ಟೇ. Keeping this pending now for an answer under 39(1) and 2 after 1 year. No, sir.
Till now, they are not alienated, but to be on the.
I will not grant any order. I will direct you to appear before the court. Court will pass orders in accordance with law. The petitioner is before this court seeking grant of an order of temporary injunction which was declined to be granted, answering application IA-1 filed under order 39 rule 1 and 2. The stage at which the petitioner presented the petition on 15th April 2024 was at the time when the respondents had not yet represented and notice was issued. Today, it is 16 months. It is 16 months that the said action has taken. In the light of the said circumstance, I deem it appropriate to direct the concerned court to dispose the application filed under order 39 rule 1 and 2 in accordance with law after hearing the parties. In accordance with law with an outer limit of 4 weeks from the date of receipt of the copy of this order, ordered accordingly. ಏನು ಎಲಿನೇಟ್ ಮಾಡಿಲ್ಲ ಅಲ್ವಾ?
ಮಾಡಿಲ್ಲ.
ಅವ್ರಿಗೆ ಗೊತ್ತೇ ಇರಲಿಲ್ಲ, 4 ವಾರ ಮಾಡಲ್ಲ ಅವರು. ಎಸ್, ನೆಕ್ಸ್ಟ್.
16,
Same, no representation, 4 weeks. Next.
17,
Order 26 rule.
You want the agreement to be admitted, mat kodlebeku.
ಅಲ್ಲ, Order 26 rule 9 milord, local inspection.
ಯಾವ ಜೇಕರ್ ಶೆಟ್ಟಿ ಅವ್ರದಾ?
Please, 17.
Serial number 17. ಹೇಳಿ.
That milord, the injunction was also granted, but only because I have taken a risk, milord, even commissioner goes and suit for injunction. And it was granted also, milord. He is in upper level.
IA 8 is 26/9. Order 26 rule line application.
Please.
What happened to that?
That has been rejected without giving any reasoning, milord. Only collection of evidence ಅಂತ word ಅನ್ನು ಒಂದೇ ಹೇಳಿ.
ಅಷ್ಟೇ.
ಅಲ್ಲಲ್ಲ, ಅಲ್ಲಿ ಏನಾಗಿದೆ ಅಂದ್ರೆ there is a blast is going on, milord. Even
Anyway, we'll issue notice.
emergency notice.
Learned emergent notice to the respondents.
Please.
Returnable by the 10th of September. Yes.
18,
Reading for the petitioner, my lord. My lord, it is a defendant petition where plaintiff has filed the original suit 47 of 2022 for permanent injunction. So the IA for permanent injunction was allowed on the basis of revenue record, my lord. And the later MA 7 of 2022 was dismissed on 9/2/24. So hence this writ petition.
Concurrent finding. We'll issue notice. Emergent notice to the respondent.
Much hope.
19,
For petitioners. The defendants have filed the application for amendment of written statement, my lord. After 2 years, when I was not provided with enough opportunity.
Suit for partition, right?
Declaration, my lord. Suit for declaration.
Declaration or partition?
Declaration and injunction.
Issues ಯಾವಾಗ frame ಆಯ್ತು?
Issues not at frame, my lord.
Not yet framed?
Before issues.
617 allowed?
Yes, my lord.
What are you are aggrieved by that?
I was not given enough opportunity.
What
to contest the
enough
application.
opportunities?
2 dates, my lord. Immediately after 2.
Now you will have opportunities. So what? 6-7 before framing of issues.
My lord,
Liberal.
totally new defense has been taken in.
No problem, sir. Innu issues frame ಆಗಿರಲ್ಲ. Accordingly issues will
I'll
be
contest
framed.
the application in the trial court, my lord.
That's a better answer.
Because only
Instead
2
of
dates,
taking
my
an
lord,
order.
the
The
objections
learned
are-
counsel for the petitioner submits that he would withdraw the petition and contest the application before the concerned court, leaving open all the contentions. The petition stands disposed with the aforesaid liberty.
20,
Issues frame ಆಗಕ್ ಮುಂಚೆ should be liberal. ಆಮೇಲೆ ನೋಡೋಣ 10 ವರ್ಷ 15 ವರ್ಷ ಆದ್ಮೇಲೆ.
Appearing for petitioner.
Now the respondents are represented.
ಅಲ್ಲ ರೆಪ್ರೆಸೆಂಟ್ ಮಾಡಿದ್ದಾರೆ ಸ್ವಾಮಿ ಅದು.
Defendants ಬಂದಿದ್ದಾರೆ ಈಗ.
ಬಂದಿದ್ದಾರೆ.
ಸರಿ ಅಲ್ಲೇ I will direct the court to pass orders in 4 weeks.
The IA is rejected ಸ್ವಾಮಿ. Kindly.
Rejected.
ಹೌದು.
ಎಲ್ಲಿದೆ? Where is the order of rejection?
On 11.
Where is the order of rejection?
Page number 16, my lord. 18
Refusing to grant interim order, sir. Rejected ಅಲ್ಲ. Rejected ಆದ್ರೆ appeal ಹಾಕ್ಬೇಕು.
ಅಲ್ಲ ಇಲ್ಲಿ ಇಂಟ್ರಿ ಮಾಡರ್ ಇಟ್ ಇಸ್ ವೆರಿ ನೆಸೆಸರಿ ಸ್ವಾಮಿ.
ನೆಸೆಸರಿ 1 ವರ್ಷ ಆಗಿದೆ ಅದು. ನೆಸೆಸಿಟಿ ಬಂದು 1 ವರ್ಷ ಆಗಿದೆ. ಪೆಟಿಷನ್ 1 ವರ್ಷದಿಂದ ಪೆಂಡಿಂಗ್ ಇದೆ.
ಅಲ್ಲ ಫಸ್ಟ್ ಟೈಮ್ ದಿಸ್ ಮ್ಯಾಟರ್ ಇಸ್ ಲಿಸ್ಟೆಡ್.
Correct, sir. You filed it when? 27th June 24. 14 months ಆಗಿದೆ. ಇಲ್ಲಿವರೆಗೂ ನೆಸೆಸಿಟಿ ಇರಲಿಲ್ಲ interim order.
Order may be granted.
No, sir. I will direct the court to pass orders in 4 weeks. Go back.
At least till then.
No, till then. ಅರ್ಜೆನ್ಸಿ ಇದ್ರೆ ತಕ್ಷಣ ಮಾಡ್ಬೇಕು. 14 ತಿಂಗಳಾದ್ಮೇಲೆ ಅಲ್ಲ. ಅದು ನಾನ್ ಪೋಸ್ಟ್ ಮಾಡಿರೋದು, ನೀವೇನ್ ಮೂವ್ ಮಾಡಿಲ್ಲ. ಎಲ್ಲ ಹಳೇದೆಲ್ಲ ತೆಗೆದು ಪೋಸ್ಟ್ ಮಾಡಿಸಿದೆ. No, till then. The petitioner is before this court calling in question the order dated 11/6/2024 passed in OS 493 of 2024, whereby the concerned court refuses to grant a temporary injunction under Order 39 Rule 1 and 2 of the CPC. The stage at which the petitioner presented the petition 14 months ago was that the defendants were not yet represented and the concerned court ought to have granted an order in their favor. Today, the defendants are represented. In that light, I deem it appropriate to dispose the petition and direct the concerned court to hear the parties and pass necessary orders in accordance with law, answering the application filed by the petitioner in Order 39 Rule 1 and 2 within an outer limit of 4 weeks. All contentions urged in the subject petition are kept open to be urged before the concerned court at the appropriate time, ordered accordingly. Next. Emergent notice to the respondent. Next.
22,
This is I-10 filed by the petitioner.
Correct, sir. FDP and OS.
Yes.
ಯಾವ್ದು stay ಬೇಕು ನಿಮ್ಗೆ?
Stay of further drawing of final decree in the FDP. The proceedings shall continue in FDP, drawing of final decree in the FDP.
FDP OS is 2023.
Yes.
ಅವು ಕಷ್ಟಪಟ್ಟು FDP ಸ್ಟೇಜ್ ಬಂದ್ಮೇಲೆ ನೀವು ಒಂದು OS ಹಾಕ್ತೀರಾ, ಅದಕ್ಕೆ ಸ್ಟೇ ಮಾಡ್ಬೇಕು. FDP ಸ್ಟೇ ಮಾಡ್ಬೇಕು.
ಇಲ್ಲ, ನಾವು ಹಾಕಿಲ್ಲ. The grandson of the original proposition.
253, 265.
Emergent notice to the respondents. Yes.
Suit.
ಬರ್ಲಿ ಬಿಡಿ ಅವ್ರು. Yes.
23,
Cross examination denied. We'll give one opportunity. ಆಯ್ತು ಒಂದು ಮುಂದೆ ಅಪೀಲ್ಗೆ ಹೋಗಿ ವಾಪಸ್ ಅದಕ್ಕೆ ಹೋಗುತ್ತೆ. ಅದ್ರ ಬದಲು ಈಗಲೇ ಕೊಟ್ಬಿಟ್ರೆ ಸರಿ ಹೋಗುತ್ತೆ. ಆಯ್ತು, ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಎಲ್ಲ ಮಾಡ್ಲಿ. It cannot be a case of no evidence. Whoever it is, application is rejected without any reason. We'll grant one opportunity. Avaru bandirtane. He's not come at all.
23,
Sangamesh.
23,
Why Sangamesh?
I'm sorry, I was thinking it was 24 months.
How can 23 go away without 24? And 24 come without 23? Yours is 23, right?
I was thinking mine is 24 months. I missed the list. I'm sorry.
ಆಯ್ತು, ಆನ್ಸರ್ ಹೇಳಿದ್ನಲ್ಲ. ಒನ್ ಆಪರ್ಚುನಿಟಿ ಇಲ್ಲ. ಎಕ್ಸಾಮಿನೇಷನ್ ಚೀಫ್ ಆಗಿಲ್ವಾ?
ಇಲ್ಲ, ಎಕ್ಸಾಮಿನೇಷನ್ ಚೀಫ್ ಅವ್ರು ಮಾಡ್ಸೇ ಇಲ್ಲ. ದಟ್ ವಿಟ್ನೆಸ್ ದೇ ಹ್ಯಾವ್ ನಾಟ್.
ಆಯ್ತು, will grant opportunity. Yes. Allowed. The petition allowed, order quashed. The matter is remitted. The application so filed by the petitioner stands allowed. The examination in chief and the cross examination that is not conducted today shall be conducted in accordance with law. It shall be seen by the concerned court that on the garb of the examination in chief and cross examination, the proceedings should not be dragged.
I'm yes, very well. I'm applying.
Yes.
Next.
24,
How are you claiming right over the properties?
Lord, impleading applications were filed.
Correct. How are you claiming right over the property?
We are filed suit for partition. Lord, my submission is the applications are rejected on the ground that sufficient particulars are not furnished and affidavit is barred. If a fresh opportunity is given for fresh applications.
The petitioner is before this court seeking the following prayer. The learned counsel for the petitioner submits that the reason rendered for rejection of the application is that the contents necessary for allowing an application in Order 1 Rule 10 is not put forth before the concerned court. The learned counsel for the petitioner submits that he has placed every material before this court in this subject petition and would seek leave of this court to withdraw the petition, reserving liberty to the petitioner to file an application, a fresh application under Order 1 Rule 10, enclosing all the particulars that are placed before this court, before the concerned court. Yes. In that light, the petition stands disposed, reserving liberty to the petitioner to, in that light, I deem it appropriate to grant an opportunity to the petitioner to submit those documents that are placed before this court, before the concerned court. Idin quash madbekanor bekala. Anyway, withdraw tane heಳು. In the light of the aforesaid submission, the petition stands withdrawn. We reserving said liberty to the petitioner to be reserving to liberty to the petitioner to liberty as afore mentioned. Ordered accordingly.
It may be considered without being influenced.
The concerned court shall consider the application without being influenced by the impugned order herein. Yes.
Has been filed by the respondent, your lordship, seeking for the modification of this thing in the.
Why do you need the other OS papers?
Your lordship, I have not filed
Why do they need the other OS papers?
Your lordship, now they want to modify the share of the respondent, your lord. For that
Petitioner
reason,
to serve on the counsel who represents the respondent in the trial proceedings. List the matter on 17th September. Further proceedings before the concerned court shall remain stayed till the next date.
26.
Filed application, suit for declaration and possession, Gudgere civil judge.
23 order, sir.
ಅಲ್ಲ, the
Order is 16/20/23 order.
annexure G page number 20.
ಹೌದು ಕರೆಕ್ಟ್.
ಅಲ್ಲ, ಇದೇನಾಗಿದೆ ಅಂದ್ರೆ 2009 ಅಲ್ಲಿ ನಾನು ಪರ್ಚೇಸ್ ಮಾಡಿದ ಕಾಫಿ ತೋಟನ ₹1 ಇದುವರೆಗೂ ನಾನು ಎಂಜಾಯ್ ಮಾಡ್ಲೇ ಇಲ್ಲ.
ಯಾಕೆ ಬೆಳಿಲೇ ಇಲ್ವಾ ಕಾಫಿ?
ಬೆಳೆದ್ರು ನನಗೆ ಕೊಡ್ತಾ ಇಲ್ಲ. I have executed a power of attorney in favor of my mother-in-law.
ಮತ್ತೆ ಅವರು ಕೊಟ್ರೆ ಹೆಂಗ್ ಸಿಗುತ್ತೆ ನಿಮಗೆ?
She is misusing the crop and she is not giving. And my ex-wife is also joined together and they are
Ex-wife?
ಹೌದು, divorced wife.
Ex-wife
She filed application for order 1 rule 10 for impleading my suit.
Ex-wife and ex-mother-in-law.
Maybe.
Lethal combination. ಏನು ಸಿಗಲ್ಲ.
Interim order ಕೊಡ್ಲಿಲ್ಲ ಅಂದ್ರೆ
ನಾನು ಕೊಡೋದೇ ಇಲ್ಲ. ಎರಡು ವರ್ಷದ ಆರ್ಡರ್ ಇವತ್ತು ಸ್ಟೇ ಮಾಡೋದಿಲ್ಲ ಸರ್.
ಅಲ್ಲ, I will take notice to the other side advocate.
Take sir.
Day after tomorrow it is fixed for evidence finally.
ಅದು ನಾನು ಪೋಸ್ಟ್ ಮಾಡಿಸಬೇಕಾಯ್ತು. ನೀವೇನ್ ಮೆಮೋ ಇಲ್ಲ?
I have filed 5 memos.
Memos sir.
My 5 memos.
I have dug up every pending matter and posted GMC.
5 memos. If you are
not before me anyway.
ಇಲ್ಲ, ಇಲ್ಲೇ ಹಾಕಿದ್ದೀನಿ ಸುಮ್ಮನೆ. ನಮ್ಮ ಮುಂದೆನೇ 3 ಮೆಮೋ ಹಾಕಿದ್ದೀನಿ last week.
ಆಯ್ತು. The petitioner to serve on the
I'll take notice.
serve on the counsel who represents the respondent in the trial proceedings and file an acknowledgement.
Interim stay ಕೊಟ್ಟರೆ
No. 2 ವರ್ಷದ ಆರ್ಡರ್ ಇವತ್ತು ಸ್ಟೇ ಮಾಡೋದಿಲ್ಲ.
ಅಲ್ಲ, anyway they are in abroad. That is why.
List the matter on 3rd September in preliminary hearing. Yes, next.
27.
I'm appearing for the petitioner, your lord.
In a suit for specific performance.
Not
Who is?
That executed a sale deed in my favor through a
What is the
GPS.
suit for, sir?
Cancellation of the
Sale
sale
deed.
deed.
ಅದ್ರಲ್ಲಿ ಆರ್ಡರ್ 1 ರೂಲ್ 10 ಯಾರಿಗೆ?
The defendant number 3 is transposed as the plaintiff now.
Transpose.
It's
The
a
petitioner
transposed
shall
application.
serve on the counsel who represents the respondent in the trial proceedings 10th September till such time further proceedings before the concerned court shall remain stayed.
28.
I appeal for the petitioner, please, my lords. I'm questioning Annexure A, an order dated 8/8/2023. Suit was filed against the respondent, my lord.
Attachment order?
ಇಲ್ಲ, ಅದ್ರಲ್ಲಿ ಏನಾಗಿದೆ ಸ್ವಾಮಿ, the property was attached before judgment in the during the trial. Then when I instituted execution and filed an application on 21 Rule 64
Sir,
for
serve on the respondent.
I will serve, my lords.
Petitioner to serve on the counsel representing the respondent in the trial proceedings 3rd September preliminary hearing. Next.
Grateful.
Next.
9.
The petitioner is before this court seeking the following prayer. The petitioner institutes a suit in OS 7107 of 2022, files an application in Order 39 Rule 1 and 2 and another analogous application. They said the petitioner is before this court in the year 2020, filing the subject petition 22nd July 2024 on the score that the applications IA 1 and 2 filed with this suit in 7107 of 2022 when the suit was instituted in the year 2022 have not yet been decided by the concerned court today. In the light of the prayer being innocuous and failure on the part of the concerned court to pass necessary orders on IA 1 and 2 filed along with the suit, I deem it appropriate to direct the concerned court to decide the applications IA 1 and 2 in accordance with law at any rate within 6 weeks from the date of receipt of the copy of this order. Ordered accordingly. Next.
30.
An application which is filed for deposit of arrears of rents. There was an earlier application which was made, which was rejected under IA number 3. Then subsequently they filed another. So there is basically a dispute as regards rental payment.
Partition suit?
No, it's a suit for ejectment.
Ejectment. Rent. You're a tenant.
I'm a tenant in the premise.
How long are you squatting on the property without paying rent?
The suit has been filed in the year 2023.
Maybe, sir.
And there is an application for payment of admitted rents from the date of the suit. Only request is because there is a dispute as regards arrears and deposits, some amount may be reduced, I'll deposit.
No, sir. What's the arrears?
No, total claim is about 62 lakhs.
What's the admitted rent?
In
the application we are only filed, my lord.
16 lakhs is as
16
per the
lakhs of
orders.
October.
Anything else, sir?
The date of the suit, my lord, that's all we are.
I'll leave it to your lordship.
What will leave? Renta?
Illa, not
Then-
rent.
Nothing.
In fact, there is an application to strike off the defense also, my lord.
That they have filed subsequently, they
the-
are pursuing that.
The petitioner is before this court calling in question an order of the concerned court in commercial OS 194 of 2023, which directs deposit of admitted rent from the date of filing of the suit, i.e. 6/2/2023 till 29/2/2024, the 29/2/2024, which would amount to 16,38,000 and continue to deposit the rent per month. The learned counsel for the petitioner seeks to project that there is dispute with regard to the rent. If the amount is reduced, he is ready and willing to pay. What the court has directed, the concerned court on the application passes the following order, page 18 to 21. The concerned court only directs deposit of admitted rent from the date of suit till 29/2/2024, not the disputed rent. In that light, there is no warrant for this court to interfere with the order so passed under established jurisdiction Article 227, finding no perversity in the order. Dismissed. Next.
31.
Compromise decree.
Compromise
ಯಾವಾಗಿಂದ sir?
Year 2016, the compromise petition has been filed, and in the year 2023, they filed the amendment application in the compromise decree, and they got the shares allotted. You may kindly see, out of 2 acres, 30-40 site has been allotted to the petitioner.
Ashte.
And the remaining properties have been allotted to the respondent number 1. Even 30-40 also is in dispute.
ಈಗ serve ಮಾಡಿ.
Serve ಮಾಡ್ತೀನಿ because now they are
One
going to.
the petitioner to serve on the counsel who represents the plaintiff and the other defendants before the concerned court. The learned counsel for the petitioner projects fraud in the compromise decree so arrived at as against 2 acres share that is to be allotted to the petitioner, only a 60-40 site is allotted. 30-40 site is allotted. In that light, further proceedings shall remain stayed before the concerned court till
Dispose ಆಗೋಗಿದೆ.
ಮತ್ತೆ ಏನ್ ಮಾಡಿದೆ?
Order has to be stayed. The compromise decree has to be stayed.
2016 ಗೆ stay ಮಾಡಿದೆ.
23 ಅಲ್ಲಿ again they made an application to amend the decree, and they got the compromise decree amended.
ಆ ಆರ್ಡರ್ ಸ್ಟೇ ಮಾಡೋಣ. 2016 you serve and come will see.
ಅಲ್ಲ ಅದಾದ್ರೂ ಸ್ಟೇ ಮಾಡಿದ್ರೆ, ಯಾಕಂದ್ರೆ they are going to alienate the property.
ಏನೋ ಒಂದು ಸ್ಟೇ ತಗೊಂಡೇ ಬರ್ತೀನಿ ಅಂತ ಹೇಳಿದಿರಾ?
ಅಲ್ಲ, ಇದರಲ್ಲಿ ಏನಾಗಿದೆ ಅಂದ್ರೆ
list the matter on 3rd September.
ಅಲ್ಲ, because in view of the
The
disposal.
status quo, the parties to the list shall not alienate the property till the next date. Yes.
In view of the disposal of the suit, I cannot serve the copy because the notice has to be issued.
ಹಾಗಾದ್ರೆ ಏನಿಲ್ಲ. Petitioner to serve on the plaintiff and the defendants before the concerned court by way of hand summons and file an acknowledgement of such service on or before the 28th of August. List the matter on 10th September.
Interior matter.
No. Yes.
ಅಲ್ಲ, let them not to alienate the property.
No. Yes. Yes, next. ಆ ರೀಸನ್ ಎಲ್ಲ ಅದೇ ಇರಲಿ, ಎಂಟ್ರಿ ಮಾಡೋ ಮಾತ್ರ ಬೇಡ. No representation. 4 weeks, not 2, same.
33.
Why civil prison?
I appeal for petitioners.
Why arrest ಯಾಕೆ?
My lords, they violated the interim order.
ಎಷ್ಟು ಸರ್ತಿ? How many times? What was the interim order?
Property, my lords. Not to alienate the property.
You have alienated?
The respondents are alienating and changing the nature of the suit.
Where is the interim order?
My lords, I seek for a short adjournment, my lords.
Why? You will get arrested. Learned counsel appearing for the petitioner seeks time. List the matter on 10th September. Yes. Next.
34.
Pendency of this petition will not come in the way of further proceedings before the concerned court. Next.
34.
For the petitioner, my lord. My lord, the petitioners are the impleading applicants, my lord. They filed the suit for declaration and permanent injunction, my lord.
Why do you want to get in?
My lord, the pleading applicants petitioners are the LRs of the original owner, my lord.
Original owner.
Yes, my lord.
ಸೇಲ್ ಯಾವಾಗ ಆಗಿದ್ದು?
My lord, my contention is that, my lord, my father has not sold the property.
When did your father die? What was the date of the alleged sale? ಓದಿಲ್ಲ ಅಂದ್ರೆ ಓದ್ಕೊಂಬನ್ನಿ. List next Monday. Yes. Next Monday ಅಲ್ಲ, ಯಾವುದು? 28th. 28th ಬೇಡ madam. List on 1st September. At the request of the council appearing for the petitioner.
35.
The petitioner is before this court seeking recall of a compromise decree that happened in the Lok Adalat on the score that the check that was presented for the purpose of paying the premium had been dishonored, and therefore there was no question of a compromise being arrived at, and the petitioner was not aware, or the respondent had not divulged the same at the time of the compromise. In that light, ಈಗ ರೀಕಾಲ್ ಆಗೋಗಿದೆ, ಇದಾಗ ರೀಕಾಲ್ ಮಾಡಿ ಈಗ ಸ್ಟೇ ಮಾಡಿ ಏನಾಗ್ಬೇಕಾಯ್ತು?
Annexure C has to be stayed.
What is that?
That is execution petition.
Execution ಹಾಕಿದ್ದಾರೆ.
want to file
In that light, the execution, notwithstanding the aforesaid fact, the petitioners, the claimants file execution to get the aforesaid decree executed. The petitioner files a review petition seeking review of the order which comes to be rejected by the impugned order. For all the aforesaid reasons, the order annexure C, another date? Date so and so shall, and all further proceedings taken thereto shall remain stayed till the next date of hearing. Yes, list the matter on 10th September. Emergent petitioner to serve on the counsel for the claimants in the execution proceedings and file an acknowledgement of such service before the court.
36.
The petitioner is before this court seeking the following prayer. The petitioner is the plaintiff.
Defense.
The petitioner is the plaintiff and the appellant before the concerned court. The saga of the legal proceedings began 28 years ago. Against the decree, the defendants have filed an appeal before the concerned court, which is 16 years ago. The appeal is said to be still pending without adjudication, and the order sheet appended to the petition would demonstrate adjournments being granted throughout for no rhyme or reason. In that light, in the light of the proceedings beginning 28 years ago and the appeal pending for the last 16 years, I deem it appropriate to direct the concerned court to dispose the appeal with an outer limit of 3 months from the date of receipt of the copy of the order recording.
37.
Partition suit, my lord.
For the same partition suit.
Which are the other two?
65 to 67.
ಎಲ್ಲದರಲ್ಲೂ objection ಹಾಕಿ. 35,
65 and 267.
35.
Sorry.
This is
37. 37, 65, 267. ಮೂರು ಟ್ಯಾಗ್ ಮಾಡಿ. List the matter on 3rd. Objections, if any, by the respondent K. Waiter by then. What's the next date?
But 5th, my lord. Next day in lower court.
5th September. 3rd September. Yes, next.
38.
Obliged.
Yes.
My lord, I am appearing for the petition.
FDP 2003 ವಿನೀತಾ ಶರ್ಮಾ ಅನ್ಬಿಟ್ಟು ಈಗ ಮಾಡ್ತಾ ಇದ್ದೀರಾ? ಎಲ್ಲ ಆಗೋಗಿರೋದನ್ನ ಎಕ್ಸ್ಯೂಮ್ ಮಾಡಕ್ಕೆ
My lord, respondents have filed the application.
We'll see.
And
Petitioner to serve on the counsel who represents the respondents.
And connected writ petition, my lord, 21-22-4/24.
ಗೊತ್ತಾಯ್ತಾ ಮೇಡಮ್?
21-22-4/21.
Yes.
There
Tag
is
the
also
petition
a-
along with so and so.
39.
My lord, I request you to kindly pass over, my lord. My senior is in the other court hall.
What's your name?
Srividya.
Heard the learned counsel Srividya appearing for the petitioner. What is called in question is an application filed by the respondents in a regular appeal filed by that is rejected. That's rejected.
I'm not sure, my lord. I've not read it. My apologies.
Allow the application rejected. Anyway, let your senior come. List on 1st September at the request of the council appearing for the petition. Next.
40.
Much obligement.
The application under section 151 was filed to restore and set aside the order of the court. But the court has said that it has no inherent power to do the same. So I have sought for.
Yes. Government. What instruction? Day after tomorrow in preliminary hearing, I'll dispose it. Yes. Copy serve ಮಾಡಿ ಒಂದವ್ರಿಗೆ. Copy ಇದೆಯಾ? ಒಂದು copy ಕೊಟ್ಕೊಡಿ.
Yes.
41.
I represent the petitioner, my lord. Lord, the suit for injunction was filed by the.
You are the husband.
I am the husband.
Correct. Your wife and children are residing there.
They are there,
let
but
them be there.
the property belongs to, the property
Oh,
belongs.
you no problem. Let the wife and child be there, sir.
No, the property is, no, the husband is prepared to accommodate elsewhere, my lord. He is prepared to accommodate. And at present, she is staying in her father-in-law's house. She is not staying in the.
Adala evidence,
husband.
matter of evidence.
But I have sought for position, but
No, sir.
that has been dismissed.
Correct dismiss ಆಗಿದೆ.
ಅದರಲ್ಲಿ the reason assigning is not correct.
Forget, I will assign reasons.
ಅಲ್ಲಲ್ಲ ಅದರಲ್ಲಿ father-in-law.
ಹೆಂಡತಿ ಮಗು, your wife and child are staying in there. You want to throw them out?
ಅಲ್ಲ, property belongs to the father.
So what? So what?
ನಾನು ಇಲ್ಲ ಅಂತ ಹೇಳಿಲ್ಲ, ಮೇಂಟೆನೆನ್ಸ್ ಆಗಿದೆ, ಮೇಂಟೆನೆನ್ಸ್ ಕೊಡ್ತಾ ಇದ್ದೀನಿ. ಇಲ್ಲಿ ಏನು ಅಂತಂದ್ರೆ she is creating problem.
ಏನು ಅಂದ್ರೆ husband and wife ego ಅಷ್ಟೇ.
ಅದು ಏನು ಮಾಡಕ್ಕಾಗಲ್ಲ.
ಅದು ಏನು ಮಾಡಕ್ಕಾಗಲ್ಲ. ಅದಕ್ಕೆ ನಾನು ಏನು ಮಾಡಕ್ಕಾಗಲ್ಲ.
ಅವ್ರಿಬ್ಬರ ವಿಷಯದಲ್ಲಿ ನಾವು ಇಂಟರ್ಫಿಯರ್ ಆಗಲ್ಲ. ಬಟ್ ನನಗೆ ನ್ಯೂಸೆನ್ಸ್ ಆಗ್ತಿದೆ ಸೀನಿಯರ್ ಸಿಟಿಜನ್.
ಏನ್ ಮಾಡಕ್ಕಾಗಲ್ಲ.
ಅದಕ್ಕೆ ಇಂಜೆಕ್ಷನ್ ಸೂಟ್ ಹಾಕಿ ಎಂಟ್ರಿ ಮಾಡ್ರಿದೆ. ಇನ್ ಸ್ಪೈಟ್ ಆಫ್ ದಟ್ ನನಗೆ ಪೊಸಿಷನ್, ಐ ಆಮ್ ಎಂಟೈಟಲ್ಡ್ ಪೊಸಿಷನ್ ಆಸ್ ದಿ ಓನರ್.
ಸೂಟ್ ಆಗ್ಲಿ ತೊಂದ್ರೆ.
ಅದರಿಂದ ಅಲ್ಲ,
ಫೈನಲ್ ಆರ್ಡರ್ ನ ಈಗಲೇ ಕೊಡಕ್ಕಾಗಲ್ಲ.
ಅಲ್ಲ ಇಂಜೆಕ್ಷನ್ ಸೂಟ್ ಕನ್ವರ್ಟ್ ಆಗ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಉಪಯೋಗ ಆಗಲ್ಲ.
ಉಪಯೋಗ ಆಗದೆ ಇಲ್ಲ.
ಅದರಿಂದ ನೋಟಿಸ್ ಮಾಡಿ.
ನೋ
ನೋಟಿಸ್ ಆದ್ರು.
No. Why should the wife and child now come, engage a counsel, come and yes.
Alla, series of litigation is pending between the parties.
Correct. One such.
There are litigations. They have engaged advocates, and 2-3 advocates they have engaged.
Hanganta fourth advocate.
ಆಗಲ್ಲ. ಅದರಿಂದ ದಯವಿಟ್ಟು ನೋಟಿಸ್ ಮಾಡಿ.
No. Husband.
No, but he is also not staying there.
ಮನೆ ಖಾಲಿ ಇದೆಯಾ?
ಅಲ್ಲ, ಅವನು ಬೇರೆ ಬಾಡಿಗೆ ಮನೆಯಲ್ಲಿ ಇದ್ದಾನೆ.
ಮನೆ ತುಂಬಾ ಖಾಲಿ ಇಡಬೇಡಿ, ಬೋಲ್ ಬುಲಯ್ಯ 4 ಆಗುತ್ತೆ.
ಅಲ್ಲಲ್ಲ, ಅದರಿಂದ ಗ್ರೌಂಡ್ ಫ್ಲೋರ್ ಅಲ್ಲಿ ಪೇರೆಂಟ್ಸ್ ಆರ್ ದೇ, ಫಾದರ್-ಇನ್-ಲಾ ಅಂಡ್ ಮದರ್-ಇನ್-ಲಾ. ಫಸ್ಟ್ ಫ್ಲೋರ್ ವಾಸ್ ಇನ್ ಆಕ್ಯುಪೇಷನ್ ಆಫ್ ದೇ daughter-in-law and son shifted now because of their
ಅದೆಲ್ಲ ಎವಿಡೆನ್ಸ್ ಅಲ್ಲಿ ಮಾಡಿ.
disturbance.
Nothing wrong with the order. The petitioner husband,
notice,
no sir, is before this court calling in question an order dated 16th November 2024 by which the application filed by the petitioner seeking possession of the premises in which his wife and child are residing comes to be rejected. The learned counsel for the petitioner submits that the petitioner husband is entitled for the possession of the property.
I'm sorry, my lord. They are not the facts. The first petitioner is the owner of the property.
Sorry, the first petitioner, father of the husband, father-in-law of the wife is the owner of the property, and therefore he is entitled to the possession of the property and is now suffering unbearable nuisance from the hands of the respondent wife in the squabble between the husband and the wife. Therefore files an application before the concerned court to get possession of the property. Ostensibly, the husband is shooting from the shoulder of the father-in-law, shoulder of the father to get the wife and the child out of the premises. The concerned court has, on the following reasons, rejected the application so filed. I do not find any, page 17-18, I do not find any perversity in the order for this court to interfere and allow possession of the property which would result in the wife and the child being moved out of the house. in that light, petition lacking in merit stands rejected. Yes, next.
42.
Millard, appear for the petitioner. Millard, the petitioner purchaser who was added in 2023 in Cleveland.
Petitioner is defendant number 12. What application?
Millard, application for
17.
amendment is allowed. 2005, the alienation is made. They challenge now in 2023. Millard,
1 minute, sir.
please.
The petitioner defendant number 12 is before this court calling in question an order dated 24/4/2024 by which an application filed by the plaintiff under Order 6 Rule 17 comes to be allowed. What is bought under challenge is, what is bought as an additional relief is a suit for declaration, declaring a particular document / instrument of the year 2004 to be null and void. The suit for declaration admittedly has to be preferred under within 3 years from the date of accrual of the cause of action as obtaining under Article 58 of the Limitation Act. The application is sought to achieve something that the law does not permit even for filing of an independent suit. In that light, there shall be an interim order of stay of the order impugned. It is made clear further proceedings before the concerned court are not stayed. Emergent notice to the respondents.
Much obliged.
43.
Notice.
44.
I think for the petitioner, it may kindly be called with the connected matter. Your
That's all right. Deposit Madakin rent to.
Swami, my senior would like to make submission.
Avare rent deposit madabeka.
Illa, Swami. Next week, Swami, my senior would like to make his.
I will not tag. We will dismiss the petition.
No, it may be kindly be called with the connected matter. On
What has happened in the connected matter?
Same application on 151 rent deposit application.
Yes, sir.
Swami, two separate cases, Your Honor, no separate cases.
No ground. Tag the petition along with so and so list day after tomorrow in preliminary hearing. We'll dismiss it day after tomorrow. Yes, next.
45.
Respondent. Yes, madam.
Dependents read petition Manish. And filed application under order.
For production of the original will
Manish.
Silvanta ಅವ್ರ ಹತ್ರ
Ide Manish, he is not produced before the court Manish.
Petitioner to serve on the counsel who represents the respondent in the trial proceedings and file an acknowledgement of such service.
Caveator copy.
Heard the learned counsel appearing for the petitioner, there is no representation on behalf of the caveator. The respondent is the plaintiff. Files the subject suit seeking declaration.
Suit for declaration.
Seeking declaration on the strength of a particular will. The petitioner defendant files an application seeking production of the said production of the original of the will. The concerned court rejects the application. The rejection of it is erroneous. In that light, further proceedings before the concerned court shall remain stayed. List on 17th September. Next.
46.
Exemption from limitation. Why?
ಇದರಲ್ಲಿ
ಏನು
ಕೌಂಟರ್ ಕ್ಲೈಮ್ ಕೇಳಿದ್ದಾರೆ. ಇನ್ 2 suits she is
ಕೌಂಟರ್ ಕ್ಲೈಮ್ ರಿಜೆಕ್ಟ್ ಮಾಡಿದಾರಾ?
ಅಲ್ಲ, ರಿಜೆಕ್ಟ್ ಮಾಡಿಲ್ಲ. ನಾನು ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದೆ, ರಿಜೆಕ್ಟ್ ಮಾಡಿ ಅಂತ. That application came to be dismissed. In 2 suits, same similar relief she is claiming, respondent.
ಅದರಲ್ಲೂ ಎರಡರಲ್ಲೂ ಸೇಮ್ ಕೌಂಟರ್ ಕ್ಲೈಮ್.
Same relief. That is the reason why I made application for rejection of cross objection. That application came to be rejected.
Petitioner to serve on the counsel who represents the respondent defendant in the trial proceedings. List the matter on 17th. Further proceedings before the concerned court till the next date shall remain stayed on the score that the defendant has preferred 2 counterclaims in 2 different suits.
ಅಲ್ಲಿ plaintiff ಅವರು ಇಲ್ಲಿ
the defendant has preferred a counterclaim verbatim similar to the plaint that the respondent has initiated in the light of initiate Ashtak. List on 17th.
47.
My lordship,
This
copy
court
has not served,
directed
my lordship.
the trial court to hear the issue number 4. My lord may kindly turn to page 45.
They have not
MFA
served the
ಆರ್ಡರ್
copy.
ಪೇಜ್ ಅಲ್ಲಿ ಇದೆ.
Page 45,
ಯಾವ ಪೇಜ್ ಅಲ್ಲಿ ಇದೆ?
page 45 of the paper book,
They have not served the copy.
the result,
ಕಾಪಿ ಕೊಟ್ಟಿಲ್ವಾ?
ಸರ್ವ್ ಆಗಿದೆ.
ಕೆವೇಟ್ ಇದೆಯಾ?
We are the
ಫೈಲ್ ಮಾಡಕ್
curator,
ಮೊದ್ಲೇ
man.
ಸರ್ವ್ ಮಾಡಿದ್ವಿ.
They have not
ಫೈಲ್
served
ಮಾಡಕ್
the
ಮೊದ್ಲೇ
copy.
ಸರ್ವ್ ಮಾಡಿದ್ವಿ.
ಅಕ್ನಾಲೆಜ್ಮೆಂಟ್ ಎಲ್ಲಿ? ಕೋರ್ಟ್
ಹೌದು.
ಸೈನ್ ಇದೆ. ಬೇರೆ ಏನಾದ್ರು ಹೊಸ ಸಬ್ಮಿಷನ್
No,
ಮಾಡ್ಬೇಕು.
madam.
ತುಂಬಾ ಹಳೇದಾಗೋಯ್ತು.
They want to serve one more copy, my lord speaker.
ಅದು ಕೇಳಿ. ಕೊಟ್ಟೇ ಇಲ್ಲ ಅಂದ್ರೆ ತಪ್ಪು. ಇನ್ನೊಂದು ಕಾಪಿ ಕೊಡಿ.
Page
Petitioner
45 ಮೇಲೆ.
to serve on the, serve another set of paper on the counsel for the caveator. List the matter on 17 till such time further proceedings before the concerned court shall remain state.
The other respondents has to be served. ಬೇರೆಯವರು ಇದ್ದಾರೆ.
Contesting ಯಾರು?
Contesting ಒಬ್ಬರೇ.
So and so. The contesting ಒಬ್ಬರೇ ಯಾರದು?
Respondent. The plaintiff is the first respondent, the others are also respondents who are
ಅದು
contesting.
ಪರವಾಗಿಲ್ಲ. Who are contesting?
All are contesting because of the suit, not maintainability of the suit.
So and so. Petitioner to serve on the counsel who represents the other respondents and file an acknowledgement of such service by the 28th. In the event no acknowledgement is filed, the interim order would stand automatically vacated.
48.
Petitioners, my lords.
Counsel for the respondent, my lord.
I pray for a short accommodation, my lords. Senior S.C. Giridhar is appearing before the Andhra. High
Correct.
Court.
Is this the way to file synopsis? Your synopsis stops at 2006. What? How? Just throw some paper, is it?
My lords,
The
this will
petitioner to
challenge
file a better synopsis
application,
in the
my
next
lord.
2 weeks. List the matter of 2 weeks. Next.
49.
That's a filed a writ of Mandamus, my lords, to expedite the trial before the learned trial court, my lords.
Declaration.
Declaration of the will, my lords. But what is
2020 suits, sir.
2020? Yes, my lords. But the trial in the matter is not yet commenced, my lords, even after a lapse of 5 years. In fact, my lords, the learned trial court is hearing on an application which is filed in the year 2020, IA number 11 and 12, my lords. So the plaintiff seems to be, they have filed an application, my lords, IA number 11 to file a rejoinder to my counterclaim, and also, my lords, IA number 12 to file an amended plaint. They have filed 2 IAs, my lords. IA number 11, plaintiff has filed to file a rejoinder to my counterclaim, my lords. And second, IA number 12, my lords, to file an amended plaint, my lords. Now, this was
Direct-
filed in the year 2020. And it
1
is-
year, sir.
Please, my lords.
Disposal within 1 year.
As my lords, please, my lords. Anytime, as my
The
lords.
petitioner is before this court seeking the following prayer. The suit is filed by the plaintiff. Plaintiff, huh?
Suit is filed by the plaintiff. I am the defendant. I
The
enter.
petitioner is the defendant. Suit for declaration is filed by the respondents 1 and 2, the plaintiffs 1 and 2. The allegation is that despite passage of 5 years, there is, the trial itself has not commenced before the concerned court, and the concerned court has granted adjournments repeatedly. In that light, and the suit being one of declaration, I deem it appropriate to direct the concerned court to dispose the suit with an outer limit of 1 year from the date of
I'm
receipt
so
of the copy of this order, ordered accordingly.
I'm so grateful, my lords.
Was the plaintiff, my lord, in the trial court?
Office is directed to assess penalty and duty.
My lord, office is directed to assist penalty and duty. In the course of the order, my lord, even for collateral purpose.
Petitioner to serve on the counsel who represents the respondent in the trial proceedings, 17th till such time. Next.
Please.
51.
Eight weeks, no representation.
52.
For the petitioner filing memo for withdrawal.
The, okay, agoytu, suit agoydi.
Dismiss ಆಯ್ತು ಅವ್ರು.
Learned counsel for the petitioner files a memo saying to withdraw the petition in terms of the memo.
53.
No representation, 4 weeks. Next.
54.
I represent the respondent in this matter, my lord. I have filed the NOC Occult, my lord, on behalf of respondent. I need to receive some papers. 2 days time may be granted.
2 days, please. Divergent finding. Bless the matter on 22nd.
Grateful.
55.
55 ಆಯ್ತು ಈಗ. Oh, sorry, 55.
55. Divergent findings.
ಇದು divergent.
Divergent findings, my lord. Respondent has filed a suit for permanent injunction and
Learned HCGP is directed to accept notice for the second respondent. Petitioner to serve on the counsel representing the first respondent before the concerned court. List the matter on 17th. Status quo que the property be maintained till the next date of hearing.
much obliged.
56.
Petitioner in this case, challenging the order regarding pecuniary jurisdiction, file an application to return the plaint to present the proper court, my lord. By contending that the value of the property has not been properly considered. In addition to that, 10% enhancement.
Partition suit.
Please, my lord.
Aಯ್ತು serve ಮಾಡಿ.
Please.
Petitioner to serve on the counsel who represents the respondent in the trial proceedings. 10th September. Next.
57.
The petitioner. So suit for injunction, my lord. Trial court had.
Yen
granted him-
pathway.
He is contending, my lord. Defendant is contending that there is a roadway of 15.
Petitioner to serve on the counsels representing the defendants before the concerned court. KVT ಇದೆಯಾ?
Other.
No representation on behalf of the caveator. Heard the learned counsel appearing for the petitioner. But it's concurrent.
No, divergent.
Divergent, yes. List the matter on 17th September. Status quo be maintained till the next date of hearing.
58.
Next. Four weeks, no representation.
59.
Are the same jail, not to post sorts.
My lord, I was for the defendant. My lord, the earlier suit 1999, my lord, it was allowed for partition. And after 20 years, they filed final degree proceedings.
39-192 concurrence.
My lord,
39-192.
but my lord, again, they cannot file a separate suit.
711 ಹಾಕಿ.
My lord,
711 ಹಾಕಿ.
Allah, that is true, but.
Partition ತಾನೆ.
Allah, partition is already granted. Item number 6 was not included in an earlier suit. And FDP, my lord, they do it. My lord, 2 rule 2, my lord, order 2 rule 2 will come in the way. My lord, they file another suit for partition again.
Application ಯಾವ್ದ್ರಲ್ಲಿ ಹಾಕಿದ್ರಿ ಸರ್?
My lord, in this suit only, my lord, 2021 suit. It is a simple suit for only perpetual injunction. That could not have been done, my lord. Because earlier, my lord, partition suit has been decreed and RSA is pending. FDP.
2 rule 2 ಮೇಲೆ ಬಂದಿಲ್ಲ ಸರ್ ಇಲ್ಲಿ ನೀವು.
No, I have not, my lord, 2 rule 2.
39-192 is granted.
My lord, it's very true.
Against that an appeal is filed.
Appeal is dismissed, concurrent finding. My lord, the very filing the suit or passing the order, my lord, I am challenging before the court. Not to alienate is the order passed, my lord.
Correct.
My lord, my other contentions.
No right of yours is taken away. Not to alienate ಇದೆಯಲ್ಲ.
Not to alienate is there always.
You
there.
want to alienate?
50, no, my lord. 52 TP Act is always there. That during the
lispendence knows.
Again, one more suit for that, my lord. In the FDP itself, my lord, they could have done it.
No, sir.
Then, my lord, increasing the suits, my lord, unnecessarily, that don't alienate, don't do disturb, my lord, unnecessarily, my lord, it would increase. In the FDP, what they filed, they could have filed it there only.
Sir, 2021 grant ಆಗಿರೋ 39-192 is confirmed in 24. You are now.
My lord, true. But, my lord, they could have filed it in.
Will
FDP
permit you to urge all the contentions before. The counsel for the petitioner, after arguing the matter at length, would seek leave of this court to withdraw the petition and urge all the contentions urged before this court, before the concerned court at the appropriate stage, reserving such liberty. Petition stands disposed.
60.
Lord, it is a case, my lord, where suit.
Defendants have sought restoration.
Yes.
So what? Partition plaintiff defendant is same.
ನಾವೇ ರಿಸ್ಟೋರೇಷನ್ ಕೇಳಿರೋದು.
Reject ಮಾಡಿದಾರ.
Petition reject
ಆಯ್ತು,
ಮಾಡಿದ್ದಾರೆ.
ತಪ್ಪು sir.
Defendant ಮಾತ್ರ ಮಾಡಕ್ಕಾಗಲ್ಲ, plaintiff ಮಾತ್ರ ರಿಸ್ಟೋರೇಷನ್
No, no, in a suit for partition that is illusory, plaintiff and
ಅದನ್ನೇ ನಾವು
defendant.
ಕಂಟೆನ್ಷನ್ ತಗೊಂಡಿರೋದು. MA ಕೂಡ ಅದೇ ಗ್ರೌಂಡ್ ಮೇಲೆ ರಿಜೆಕ್ಟ್ ಮಾಡಿದ್ದಾರೆ.
Already one suit, another suit.
ಅದಲ್ಲ ಬೇರೆ. Reason rendered that only plaintiff has to seek restoration, no.
Already another suit filed on partition suit.
ಇದಾದ್ಮೇಲೆ ಇದು ರಿಜೆಕ್ಟ್ ಆದ್ಮೇಲೆ
ಅಲ್ಲ ಇದೇನಾಗಿದೆ
ಮತ್ತೆ ಅದೇ
ಅಲ್ಲ ಇದೇನಾಗಿದೆ ಅಂದ್ರೆ
ಸೇಮ್ ಕಾಸ್ ಆಫ್ ಆಕ್ಷನ್
ಕೇಸ್ ಹಾಕಿದೆ ಅನ್ನೋದನ್ನ ನೋಡ್ಕೊಳ್ದೆ ಬೇರೆ ಲಾಯರ್ ಇಟ್ಕೊಂಡು ಇನ್ನೊಂದು ಕೇಸ್ ಹಾಕಿದ್ದಾರೆ. ಅದಾದ ತಕ್ಷಣನೇ ಅದ್ರಲ್ಲಿ 23 ರೂಲ್ ಆನ್ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿ ಪ್ಲೇಂಟ್ ವಿತ್ಡ್ರಾ ಮಾಡಕ್ ಇದ್ ಮಾಡಿದ್ರು. ಈ ಕೇಸ್ ರಿಸ್ಟೋರ್ ಮಾಡಿ
ವಿಡ್ರಾ ಮಾಡಿದ್ಮೇಲೆ ಇದನ್ನ ಕೊಡ್ತೀನಿ ಆರ್ಡರ್.
ಅಲ್ಲ ವಿತ್ಡ್ರಾ ಮಾಡೋ ಅಪ್ಲಿಕೇಶನ್ ರಿಜೆಕ್ಟ್ ಆಗಿದೆ.
ರಿಜೆಕ್ಟ್ ಆಯ್ತಾ?
ಅದ್ರ ಮೇಲೆ CRP ಈ ಕೋರ್ಟ್ ಮುಂದೆನೆ
ನಂಬರ್ ಕೊಡಿ.
ಕೊಡ್ತೀನಿ.
ಎರಡು ನಡ್ಸಕ್ ಆಗಲ್ಲ, ಒಂದ್ ನಡ್ಸಿ.
ನಮಗೆ ಹೊಸ ಕೇಸ್ ನ ವಾಪಸ್ ತಗೋಬೇಕು ಅಂತ ಇದೇ ಗ್ರೌಂಡ್ ಮೇಲೆ ಕೊಟ್ಟಿದ್ದು.
ಬಟ್ ಬೋತ್ ದಿ ಆರ್ಡರ್ಸ್ ಆರ್ ರಾಂಗ್. ಇನ್ನೊಂದು ಹಾಕಿರೋದ್ರಿಂದ ನಿಮ್ ಪ್ರಾಬ್ಲಮ್ ಅಷ್ಟೇ.
2 ಸೂಟ್ ಹಾಕಿದಾರೆ ಸಮ್ ಪಾರ್ಟಿಷನ್ ಸೂಟ್. ಇದಾದ್ಮೇಲೆ ಮತ್ತೆ 2 ಸೂಟ್ ಆಗಿದೆ.
ಯಾವ್ಯಾವ್ದು ಹಾಕಿದೀರಾ? ಯಾವ್ಯಾವ ಲಾಯರ್ ಹತ್ರ ಹೋಗಿ ಹಾಕಿದಾರೆ ಎಲ್ಲ ಕಲೆಕ್ಟ್ ಮಾಡ್ಕೊಂಡ್ ಬನ್ನಿ.
ಇಲ್ಲ ನಾವು ಹಾಕಿಲ್ಲ.
28 ಆಫ್
ನಾವು ಹಾಕಿಲ್ಲ. ಬೇರೆ ಫ್ಯಾಮಿಲಿ ಮೆಂಬರ್ಸ್ ನಾನ್ ವಿತ್ಡ್ರಾ ಮಾಡ್ತಾ ಇದ್ದೀನಿ ಅಂತ ತಿಳ್ಕೊಂಡು ಇನ್ನೊಂದು ಕೇಸ್ ಹಾಕಕ್ ಹೋಗಿದ್ದೆ.
ಅದಕ್ಕೆ ಅದು ಯಾವ್ಯಾವ್ದು ಇದೆ ಈ ಪಾರ್ಟಿಷನ್ ಎಲ್ಲ ತಗೊಂಡ್ಬನ್ನಿ.
ಆಯ್ತು.
ಎಸ್. 2 ವಾರ ಕೊಡ್ಲಾ?
ಇಲ್ಲ 1 ವಾರ ಸಾಕು.
ಒಂದೇ ವಾರ ಸರ್. ಎಸ್. ಲಿಸ್ಟ್ ದ ಮ್ಯಾಟರ್ ಆನ್ 29th. Yes, next.
61.
In this case, my lord, I am appearing for the petitioner. I filed the writ petition, my lord.
Request for a passover, my lord. File.
Passover illa ಇವತ್ತು passover ಕೇಳಲೇಬೇಡಿ.
Tomorrow, my lord.
Unless I want to dismiss it.
Tomorrow, my lord. File
No,
has been
tomorrow.
dismissed.
In this case, my lord, I challenged the impugned order dated 7/2/25 on IN number 11, filed under order 11 rule 14 of the CPC. Prior to that, my lord, the same this one, my lord, prior to produce the original will, it was filed, my lord, the IN number that is also produced. That annexure F, my lord, ink page number 44.
ಅವ್ರು ಇಷ್ಟೊತ್ತಿಗೆ ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕ್ಬಿಡ್ತಾ ಇದ್ರು.
Order 13 rule 14, it was dismissed their application relating to the production of the will. Then after that again they have filed the IN, my lord, relating to the section 45 of the Indian Evidence Act to produce that particular will to expert opinion. It was dismissed. Against it, they have approached this honorable court in WP number 4229/24.
ಒಂದ್ ನಿಮಿಷ.
Annexure K, my lord.
ಒಂದೇ ನಿಮಿಷ.
10 minutes, my lord.
ಪಾಸ್ಓವರ್ ಇಲ್ಲ.
ಅಲ್ಲ, file has been
10 minutes ಅಲ್ಲ 10 seconds ಪಾಸ್ಓವರ್ ಇಲ್ಲ.
Didn't be taken up at 2:30, my lord.
No sir, ಅದು indirect passover. Yes. List the matter on Wednesday. Wednesday ಎಷ್ಟು ಮೇಡಮ್? 22nd ಎಷ್ಟಿದೆ ಕೊಡಿ. ಹೇಳಿದ್ರ ಚಾಕ್ಲೇಟ್? ಮೇಡಮ್ ಚಾಕ್ಲೇಟ್ ಹೇಳಿದ್ರ? Well, take it on 28th.
Please.
Yes,
My lord,
list on 28th.
In the meanwhile, my lord, today is the matter in the trial court, interim order for stay till next date.
Today next date ಬರ್ಲಿ ಅವಾಗ ಹೇಳಿ.
ಅಲ್ಲ ಇವತ್ತಿತ್ತು.
ಇವತ್ತು ಅಡ್ಜರ್ನ್ಮೆಂಟ್ ಆಗುತ್ತೆ ಬಿಡಿ.
Yes, please.
28th.
28th, yes.
62.
The short point, my lord, Mandamus, my lord.
Compensation ತೀರ್ಮಾನ ಮಾಡಿ.
Yes, my lord.
2023 suits.
My lord, because, my lord, the lands belongs to defendants, my lord. As per the will, my lord, they obtain the revenue records. And the suit for partition, my lord, the will in year 1957, my lord.
Suit for partition will never direct.
And the lands are acquired by the KDB, my lord, now.
May be.
Therefore, my lord, any time frame may be fixed.
No, 23 suit ಗೆ partition suit.
No, my lord, suit in year 2016, my lord. The suit in year 2016, 850/2016. 8 years old suit, my lord.
ಎಲ್ಲಿದೆ?
Page number 12, my lord, annexure A.
ಆಯ್ತು, 6 months.
Yes, right.
A petitioner prayer before this court seeking the following prayer. The petitioner is the defendant. The plaintiff institutes a suit for partition. The impending urgency in the case at hand is acquisition of the land and distribution of compensation. The compensation is held up in the proceedings without it being given to anybody's benefit. In that light, 6 months.
The next matter also on the matter, same, my lord.
Same,
But in this case, my lord, the petitioner is a plaintiff, my lord, 10 years old suit, my lord, page 13, my lord, 2014 suit, my lord.
60?
2014 suit, my lord, page number 13, my lord.
Serial number ಯಾವ್ದು sir? Oh, same 63.
Next matter, my lord.
OS for possession.
Yes.
The petitioner is before this court seeking the following prayer. The petitioner is the plaintiff. The plaintiff institutes suit for possession of the, for possession, which is said to be pending since 2014. The perusal at the order sheet would indicate that the court has granted adjournments without any rhyme or reason. In that light, I deem it appropriate to infuse finality into the proceedings. The proceedings shall conclude with an outer limit of 6 months, if not earlier.
Also injunction, possession
For
injunction.
injunction. All right, yes.
63.
Right.
Madam. Sixty?
64 Lordship.
64.
Sorry, 63.
63 ಆಯ್ತಲ್ಲ ಮೇಡಮ್ 62 63 ಎರಡು ಆಯ್ತು.
My lordship, in this, even before issuance of notice to the defendant, my lord, suit is dismissed, my lord, on the ground of limitation, my lord, on the basis of the note raised by the office, my lord.
List tomorrow. We'll dispose it tomorrow.
Please.
65 and 66.
My lord, kindly have it on tomorrow.
You are the purchaser.
Yes.
A petitioner shall serve on the counsel who represents the defendants before the concerned court. The petitioner is the plaintiff who files an application under Order 1 Rule 10, seeking to implead whom? Implead the purchaser. Okay.
Kindly have to.
Implead the purchaser as a party respondent to the proceedings. In the light of the proceedings projected, the application ought to have been allowed. In that light, further proceedings before the concerned court shall remain stayed. The petitioner shall serve on the counsel who represents the respondent in the trial proceedings and file an acknowledgement of such service before the 17th September. File ilva?
ಇಲ್ಲ,
ಯಾವುದೋ ಒಂದು ಇದೆಯಲ್ಲ
ಅಲ್ಲಿ
ಬಿಡಿ.
67.
I appear for the petitioner, my lord. Petition seeking refund of court fee.
Correct.
Or withdrawal of the suit.
Who has to? Arbitration.
My lord, the issue was only our defendant number 1 had an arbitration agreement with the plaintiff. During the proceedings,
Respondent's presence is necessary?
it can be dispensed with, my lord. It's only an issue of, even in the trial court, they had said no objection to my application.
Tomorrow we'll dispose it. Yes.
Great, sir.
Let's tomorrow in preliminary.
68.
Lord, appearing for the petitioner, I'm seeking liberty to withdraw the writ petition.
Why, madam? Withdrawal.
If they're withdrawing, my lord, I can have.
Withdraw and urge all
And-
contentions before the trial court.
No, my lord, that is not possible because the position, my lord, is that the trial court has already taken a view that our petition under section 34 is in time. So that cannot be reopened again.
Cleverly drafted memo.
My lord, this is a matter where the arbitration award was passed on 7th September 2024. We have sought for erasing one portion of the
When
cost.
that erasal happen and when was the order passed? On 27/10/2024.
Please, after 30 days.
After 30 days, it is filed within 120 days.
My lords, it cannot be considered that this falls within the period under section 33, my lords.
Seriously. 2018 SCC online SC 3181. Ved Prakash.
Yes.
My lords, I may be granted
Correct.
liberty to withdraw the writ. urging
No,
contentions.
withdrawal simpliciter, no problem. No urging again, because law is goaded against you.
Can I request for a short accommodation? my lords?
No, that's not a problem. Withdrawal will not permit.
Please, any date.
Because it's completely
any date-
covered. Not only that, there are plethora of judgments later
Any date.
following Ved Prakash.
Please,
All right.
please.
You've not seen Ved Prakash Mittal? Not. Oh, yes. We'll list it 28th. List on 28th at the request of the counsel appearing for the petition. Counsel for the petitioner seeks to files a memo seeking withdrawal of the petition with liberty to urge all the contentions before the concerned court all over again. The learned senior counsel KG Raghavan objects to the memo as the court has already formed an opinion that the appeal filed under section 34 was within time and entertainable. Application within time and entertainable. As the issue in the list stands answered by the judgment of the apex court in the case of Ved Prakash Mittal 2018 SSC Online SC 3181. The learned counsel for the petitioner at this juncture seeks a week's time. List the matter on 28th in preliminary hearing. Withdrawal simpliciter, no problem. Yes.
69.
Petitioner, defendant number 7 before the trial court, my lord. I am the purchaser. I have purchased the property in the year 2005, my lord. See, the plaintiffs have filed a suit for partition in respect of the property of their maternal grandfather, saying that
suit yavag hakid.
2017, Swami. I have purchased in 2005, 2017.
Order 1 rule 10 reject ಆಗಿದೆಯಾ?
ಅಲ್ಲ ಸ್ವಾಮಿ, ಆರ್ಡರ್ 1 ರೂಲ್ ಅಲ್ಲ ಸ್ವಾಮಿ. ಇದರಲ್ಲಿ ಏನಾಗುತ್ತಂದ್ರೆ, see, I have produced the certified copy of the will on my behalf because the defendant number 1 to
1978.
ಹೌದು ಸ್ವಾಮಿ, ಯಾಕಂದ್ರೆ ನಾನು ಐ ಆಮ್ ದ ಪರ್ಚೇಸರ್. ಅವ್ರು ಏನಾಗುತ್ತಂದ್ರೆ defendant number 1 is the brother of the plaintiff ಸ್ವಾಮಿ. ಅವರು colluded ಆಗಿ
serve on the petitioner to serve on the counsel who represents the respondent in the trial proceedings. List the matter on 3rd September.
Interim order, please.
Yes.
70.
This case appear for the petitioner, my lord.
That's it.
This case appear for the petitioner, my lord. 2 weeks time may be granted, my lord.
Why, sir? 70?
70, my lord. Serial number, my lord. There is a settlement is going on. That's why.
Settlement going on?
Yes.
The learned counsel for the petitioner submits talks of settlement between the parties are afoot AFOT. In that light, list after 2 weeks.
71.
Petitioner is the defendant in the suit filed by the respondent number 1, 2, 3 for the relief of declaration, position and injunction.
617 allow ಆಗಿದೆಯಾ?
ಯಾವುದು ಸರ್?
ಅಲ್ಲ ಯಾವುದು serial number?
IA number 20.
71. What is under challenge?
So IA number 1, IA number 20 is filed by the petition, the respondents before this honorable court. They sought for the order 6 by filing an order 6 rule
17, sir. The petitioner is the defendant. Calls in question allowing of an application filed under order 6 rule 17 filed by the plaintiff seeking amendment of the plaint. The suit is instituted in the year 2015. The amendment application is filed in the year 2024, which comes to be allowed, which prima facie changes the nature of this suit. In that light, further proceedings, the order impugned shall remain stayed. It is made clear further proceedings before the concerned court are not stayed.
Yes, sir.
72.
Defendant petition, my lords, challenging the order passed in the application 39 to 1 and 2, my lords. There is a concurrent finding, my lords. Understand, my lords, one point is that there is no prima facie material to show that they have been using that land for very long time. That is one.
Still evidence.
Yes, I understand, my lords.
ಏನದು memo for withdrawal?
No.
ಮತ್ತೆ?
My notes.
Notes?
But second thing, that they have an alternative route. They have suppressed that fact and they have come up with the suit.
Both the courts have not believed.
I understand, my lords, and one more condition that I am the courts have held that the ownership of the ownership is in my favor, my lords. There's a RTC extract to show that I am the owner, my lords, and even they do not dispute it. They have not produced any prima facie material, my lords. I have been using in the land.
You urge all the contentions there.
May seek short accommodation, my lords. I'll take instruction.
All right. Next week, 29th, at the request. Next.
73.
Petitioner to serve on the counsel who represents the respondents. Drag the petition along with so and so till such list on 17 till such time.
There's already an interim order in the connected.
ಈಗಲೂ ಕೊಟ್ಟನಲ್ಲ ಸರ್ ಅದರಲ್ಲ.
74.
ಜಯ till such time ಗೊತ್ತಲ್ಲ.
Production application filed by partly allowed.
No, correct. Specific performance.
A specific performance suit, because I have allegation against the one ST Lingaraju with the plaintiff.
Who is Lingaraju?
ST Lingaraju is the counsel on behalf of the plaintiff in different cases. In respect of the other property concern, colluding with the plaintiff and ST Lingaraju, they have created on GPA and agreement.
What document you want to produce?
Wakalat of the plaintiff and ST Lingaraju.
ಒಂದೇ ಅಂತ ತೋರ್ಸಕ್ಕೆ.
ಇಬ್ರು ಕೊಲ್ಯೂಸಿವ್ ಆಗಿದ್ದಾರೆ ತೋರ್ಸೋದಕ್ಕೆ. ದಟ್ಸ್ ಬಿಕಾಸ್ ದೇರ್ ಇಸ್ ಎ ಐ ಹ್ಯಾವ್ ಆಲ್ರೆಡಿ ಸ್ಪೆಸಿಫಿಕಲಿ ಸ್ಟೇಟೆಡ್ ಇಟ್ಸ್ ಲೋನ್ ಟ್ರಾನ್ಸಾಕ್ಷನ್.
You serve on Lingaraju.
Yes, sir.
The petitioner to serve on the counsel who represents the respondent or the respondents before the concerned court. List on 70 till such time further proceedings shall remain stayed. Yes.
75.
Petitioner to serve on the counsel who represents the respondent in the trial proceedings. 17th till such time there shall be an interim order of stay of further proceedings. Next.
76.
Order 18 rule 17.
Order 18, 17 and 151, two applications are there. Notwithstanding the PWN has already been cross-examined, nevertheless a false affidavit is filed for recalling, because to avoid the certain to application that has been filed. Application was filed in 2011, Milord. That is certain to application. So far it has not been decided and
What's
they
the
are
next
not allowed to decide it.
What is the next date?
Today it is, now this one is, the corresponding suits are for today. And this is for 22nd or something, I'm not ready for.
This yavat.
Next day to, ಒಂದು ಯಾವುದೋ ಇದೆ ಅದರಲ್ಲಿ.
3rd September ಹಾಕ್ತೀನಿ. You serve on the respondents.
But if PW1 is not cross-examined on that day, it will be closed and then.
ಅದಕ್ಕೆ which day? What is the next date?
That is. I am not able to give the next date.
ಅದಕ್ಕೆ list on 29th. Petitioner to serve on the counsel who represents the respondent in the trial proceedings. ಅವತ್ ಮುಗಿಸ್ಬಿಡೋಣ.
In the meanwhile, if it comes in this.
Move ಮಾಡಿ.
I am not aware of the date.
No, you get to know the date and tell me. If the date is before 29th, I'll grant interim order.
In the afternoon, Mila.
Afternoon. ಇಲ್ಲ ಕೋರ್ಟ್ ಆಫೀಸರ್ ಹೇಳಿದ್ರೆ ಆಯ್ತು ಡೇಟ್.
There's
77.
ಪೊಲೀಸ್ ಪ್ರೊಟೆಕ್ಷನ್.
ಅವ್ರು ಕೇಳಿದ್ದಾರೆ, ಕೊಟ್ಟಿದ್ದಾರೆ ಅದನ್ನು ನಂತರ.
ಇಂಜಂಕ್ಷನ್ ಯಾರ ಫೇವರ್ ಇದೆ?
ಅವ್ರ ಫೇವರ್.
ಮತ್ತೆ ಸೋ ವಾಟ್?
ಬಟ್ ಪೊಲೀಸ್ ಪ್ರೊಟೆಕ್ಷನ್ ನೆಸಿಟಿ ಹ್ಯಾಸ್ ನಾಟ್ ಅರೈಸ್.
ಅಕಾರ್ಡಿಂಗ್ ಟು ಯು ನೆಸಿಟಿ ಇರೋದೇ ಇಲ್ಲ, ಅವ್ರಿಗೆ ಇರುತ್ತೆ ಬಿಡಿ. ಇಂಜಂಕ್ಷನ್ ಇದ್ರೆ ಫೇವರ್.
ಅದು ಇಂಜಂಕ್ಷನ್
ಅಲ್ಲ, ಇಂಜಂಕ್ಷನ್ ಅವ್ರ ಪರವಾಗಿದೆಯಾ?
ಇದೆ. ಡಿಕ್ಲರೇಷನ್ ಇಂಜಂಕ್ಷನ್ ಸೂಟ್ ಡಿಗ್ರಿ ಆಗಿದೆ.
ಡಿಗ್ರಿ ಆಗೋಗಿದೆ.
It has attained finality in Supreme Court also.
No grounds. Dismissed.
78.
For the petitioners, Malaj. Malaj, I'm the decree holder before the trial court, Malaj. An award was passed in the year 2000.
Memo of calculation is rejected.
Please, Malaj.
Why?
I undertake to enter appearance on behalf of the respondent. They've been directed to file a fresh memo of calculation. The difference is.
Malaj, the issue is the memo was rejected because every payment that was made was first adjusted towards interest and then the principal amount, Malaj. The court felt that that is wrong and has asked both of us to file fresh memo for calculation.
Why are you here?
Malaj, the issue is there are 3 components to the award. They have subsequently denied the 3rd component, Malaj. There is principal amount,
when
interest.
Fresh memo comes, fresh arguments ಮಾಡಿ.
Illa, Malaj, the issue is they have denied the payment. There's 3 components, Malaj. The 3rd component is the final invoice.
How do you know what fresh calculation will come?
Illa, the amount will be the same. It will just the interest portion will increase for the last few months, Malaj.
Whatever, file a fresh memo of calculation. Submit all that you want to submit.
My lords, the issue is we filed a judgment before the trial court to say that any and all payments first have to be adjusted towards the interest and then the
In
principal
accordance
amount,
with
my lords.
law, the court will decide on your submissions.
My
That's
lords, we're
all.
challenging that merely on those
Now,
grounds, my lords, because
only-
interest has to be first.
Now, what the order is, only fresh memo is directed to be filed.
Please, my lords.
I will not enter. Anything else?
No.
The petitioner is before this court, calling in question an order dated so and so. The order only directs the parties to file a fresh memo of calculation after rejecting the memo of calculation that is presented. The counsel for the petitioner submits that is aggrieved by the said order. The order does not prejudice anybody. What is directed is filing of fresh memo of calculation. In the event fresh memo of calculation is filed, the petitioner would be at liberty to urge all the contentions that are now sought to be urged before this court. Reserving such liberty, petition stands disposed.
Please, much.
Separate order sheet, learned counsel, what's your name?
Nitya.
So and so undertakes to enter appearance for the respondent, registry to print the name of so and so. Madbut Madi.
Defendant's petition, defendant's petition, in suit for injunction, my lord, my application to file written statement is rejected, my lord.
The petitioner shall serve on the counsel who represents the respondent in the trial proceedings 17th September till such time further proceedings shall remain stayed. Next.
80.
I am for the petitioner, my lord. Lord, here, the government of Karnataka granted 23 acres of land to the petitioner for establishing medical college. Thereafter,
the petitioner heard the learned counsel P. Sitaram Rao appearing for the petitioner. Petitioner is the defendant number 5. The plaintiff in a suit instituted in the year 2009 files an application seeking amendment under Order 6 Rule 17, which comes to be allowed in the year 2024 in the light of the law with regard to the proviso to Rule 17. The amendment application ought not to have been considered favorably. In that light, the order dated so and so shall remain stayed. It is made clear further proceedings are not stayed.
Lord, further proceedings under evidence post ಆಗ್ಬಿಟ್ಟಿದೆ.
ಆಗ್ಲಿ ಬಿಡಿ.
ಅಲ್ಲ, on the basis of the amended pleadings, they are coming
ಅಷ್ಟೇ ಮಾಡದ್ನಲ್ಲ ಈಗ ಅದನ್ನ.
Lord, serial number 331 is also same.
ಆಯ್ತು 331. Execution petition dismissed.
Not dismissed. It was disposed of. My lord, the order is at page, starts from page 60, where executing court had directed to attach the properties.
Parvailla.
My lords, the guidance value is
Chief
very less,
Officer. Sir, petitioner to serve on the counsel represents the respondents in the trial proceedings 10th September. Dispose ಆಗೋಗಿದೆಯಲ್ಲ ಮತ್ತೆ ಅದರಲ್ಲಿ ಏನು ಸ್ಟೇ?
It is not disposed, my lords.
ಮತ್ತೆ
Dispose ಆಗಿಲ್ಲ.
ಇನ್ನೇನಾಗಿದೆ?
My lord, just to attach the properties, the order has been made to attach the properties.
Nim properties, town municipal council properties.
It was acquired, my lords. Guidance value was 11,000, but the amount granted was 14,000 before the LAC court. That has been challenged in writ petition, my lords. That is still pending, lords. But the executing
Further proceedings before the executing court shall remain stayed. Next.
Great.
17th September.
Hearing for petitioner in this case, kindly a week's time may be granted. Regular counsel is not in station.
Suit barred by res judicata. Why?
Yes, my lords. I'm proxy counsel. Regular counsel not.
How do you know res judicata suit barred anta? Proxy counsel ಹೇಳಿ ಕಳಿಸಿದ್ರ ಈ ತರ ಹೇಳಿ ಅಂತ. ಹಂಗಾರೆ agreement ಮಾಡಿ.
The file is not with me. That's why.
At the request of the counsel appearing for the petitioner.
A date may be fixed.
List after 2 weeks. Date is today. If you don't do it, no date. Registry is directed. Next. 80?
83, Lordship. 83.
Challenging the order dated 15th March 2025.
Will direct parties not to alienate the property.
Much.
ಇನ್ನು ಆರ್ಡರ್ ಮಾಡಿಲ್ಲ ಇರಿ.
Sorry.
The petitioner is before this court Petitioner shall serve on the counsel representing the respondents before the concerned court. List the matter on 17 parties not to alienate the property till the next date.
84.
The petitioner is before this court seeking the following prayer. Heard sounds. The petitioner, the plaintiff, institutes a suit for specific performance. Plaintiff 1 and 2. The said suit is languishing before the concerned court since 2022. A perusal at the order sheet would indicate plethora of adjournments granted by the concerned court. In the light of the suit for specific performance and the mandate of the statute that it should be disposed within 1 year of its filing after the amendment in the year 2018, I deem it appropriate to direct the concerned court to dispose the said suit with an outer limit of 6 months from the date of receipt of the copy of the suit. Order record. Next.
85.
For petitioner in this matter,
Sir, file 482. NI Act dala ಇಲ್ಲಿ ಯಾಕೆ?
ಅಲ್ಲ ಏನೋ ಆಯ್ತಲ್ಲ OS ಅದು.
ಇನ್ನೇನು? Section 37 ಏನು ಹೇಳಿದ್ರೆ? Procedure.
Impugned order dated 4/4/2025 melody.
Correct.
Annexure A.
Yes.
So without seeking the leave to defend, respondent had filed the written statement.
In what proceeding?
Application.
In what proceeding?
It is the suit is filed under order 37 melody.
Recovery of money. Yeah.
Recovery of money. There is a written contract between the plaintiff and the defendant as well, melody.
Petitioner to serve on the counsel who represents the respondent. Respondent defendant before the concerned court, 17th September.
86.
Permanent injunction suit, my lord. Defendant writ petition. The ground for rejection of the court commissioner application is that, my lord.
Petitioner to serve on the counsel who represents the respondent in the trial proceedings. Application ಹಾಕಿದ್ದು ಯಾರು?
Defendant, my lord.
ನೀವೇ. The petitioner files an application under Order 26 Rule 9 of the CPC seeking appointment of the court commissioner owing to the disputed questions of fact with regard to the proper identification of regard to the boundaries of the property. The concerned court has rejected it on the score that it is only to fetch evidence while it is not it is not prima facie. In that light, owing to the law laid down by the coordinate bench of this court in 2023 ILR Karnataka, page 53, there shall be an interim order of stay of further proceedings before the concerned court. Next.
87.
Petitioners, my lord. Petitioners, my lord. Petitioner.
80.
My lord.
Executing court has closed.
Memo of calculation, my lord, is as per the decree, my lord. It was not considered by the executing court, my lord. The joint memo, my lord, joint memo filed by both the parties in OS, my lord. As per the terms, they have to file before pay the amount. They have not paid that amount.
ಆಯ್ತು ಯಾರು represent serve ಮಾಡಿದ್ರೆ? Petitioner to serve on the counsels representing the respondents before the executing court. List the matter on 10th September.
88 appearing for petitioner, my lord. At 6 for weeks time, my lord, in this matter.
Why dispose ಮಾಡಿದಾರಾ IA?
ಇಲ್ಲ ಸ್ವಾಮಿ, ಪೆಂಡಿಂಗ್ ಇದೆ IA ಇನ್ನು.
Will direct disposal within 4 weeks.
ಒಬ್ಳೆ.
The petitioner is before this court seeking the following prayer. The petitioners are defendants. The plaintiff institutes a suit in OS 453 of 2024. What is the suit for?
Suit for partition, my lord.
Partition. Anyways, suit for partition. In the said suit, the defendants file application seeking rejection of the Plaintiff Order 7 Rule 11D, A and D. The defendants are before this court on the score that the application is pending since 1 year and no order is passed. In the light of the pendency of the application so filed under Order 7 Rule 11D, for a period of 1 year, I deem it appropriate to direct the concerned court to pass orders on the application IA3 within an outer limit of 8 weeks from the date of receipt of the copy of this order, ordered according.
89.
Obliged.
Petitioner will this is a plaintiff's petition, suit for declaration and possession. Amendment was made in view of the eastern boundary of the scheduled property. Though the father had purchased way back in 87, they were not aware about the wrong.
Serial number 90?
89.
89.
So amendment application was rejected by the court.
Suit for?
Suit for declaration and possession.
Petitioner to serve on the counsel who represents the defendants before the concerned court and file an acknowledgement by the 28th list on 17th. Further proceedings shall remain stayed.
90.
Placed.
The appellant, my lords. No, this is the petitioner's appeal.
Concurrent.
My lords, the partition deed was executed in the year 2003.
39 1 and 2 concurrents.
My lords, 22 years they did nothing, my lords. I'm only seeking a status quo order which can be provided, my lords. Status quo order insofar as the nature of property, my lords. 22 years they haven't done anything, my lord. Now suddenly they're saying gully, the gully to the property, they're saying we are obstructing their access. 22 years we haven't done anything, my lord. How it was, the tanti hakiradella angetu, my lords, for 22 years.
Tanti gully enidella?
My lords, there was a road going to the property.
Tanti ಆಗ್ತಾ ಇದ್ದಾರಾ?
The road, my lords, they are claiming we are putting up a barricade to the road. But for 22 years there was no obstruction to the property, my lords. So I'm only seeking status quo insofar as the nature of property is concerned. Status quo, temporary injunction may not be granted. Status quo at least be granted.
No, sir. You are the plaintiff.
Plaintiff.
So for this story, both the courts have not believed. Gully Tanti, nobody believed.
My lord, it's just the road which is going into their property, my lord. We are not obstructing any road, my lords. That is all their contention.
Urge all the contentions there.
My lord, status quo may be granted, my lord. They are interfering with our possession, my lord. That is the only
file application.
Status quo, notice go and come, my lord. Status quo may be granted until then, my lords. My lord, they are interfering with the possession of my
file applications there, sir.
My lord, that is been rejected, my lord. That is why we are before this honorable court.
Both courts have not considered your submission at all.
But for 22 years they haven't interfered.
No, sir. Same submission you have made there also. 2003 in the ಏನು ಮಾಡಿಲ್ಲ ಇವಾಗ ಬರ್ತಾ ಇದ್ದಾರೆ ಅಂತ.
ಹೌದು my lord. 2003 the same road, same tanti ಇದೆ, same barricade ಇದೆ my lord. 2003 ಇಂದ 22 years they haven't done anything. Now suddenly they are interfering with my possession, my lord.
No, sir.
That is the only reason why we have appeared, my lord.
Even the appellate court has passed a reasoned order. No warrant of interference.
My lord, that notice go and come, my lord. That is all I seek, my lord. Notice be issued, my lords.
Notice to the respondents. Pendency of this petition will not come in the way of any further proceedings before the court.
Great, my lord.
Yes, next.
91.
This case I am for the petitioner, my lord.
IA6.
IA6 on
disposal.
2022 in the pending is.
The petitioner is. What is IA6 for?
7 Rule 11 rejection of the client during the pendency of the suit.
7 Rule 11 ಹೇಳಿದ್ನಲ್ಲ ಈಗ ಒಂದು. Serial number.
My person one
Serial number
Supreme Court judgment in respect of very same parties during the pendency of the suit, the respondent herein has filed challenging the land acquisition of the before this honorable court has been dismissed. Against that they have prepared a writ appeal.
711 ತಾನೆ.
ಹೌದು ಸರ್. ಅದೇ ಗ್ರೌಂಡ್ ಮೇಲೆ ನಾವು ಹಾಕಿದ್ದೇವೆ.
Yes, 8 weeks. ಅದು ಕೊಡಿ, ಆರ್ಡರ್ ಕೊಡಿ.
Lordship me. ಒಂದೇ ಒಂದು ಪೇಜ್. ಅದರಲ್ಲಿ last the lordship also disposed by observing the above judgment, the reported judgment ತಗೊಂಡು ಮಾಡಿದಿರ ಸರ್.
ಕೊಡಿ ಯಾವುದು ಕೊಡಿ.
Judgmental Sankara para 9 some, page 7 ಅಲ್ಲಿ. Supreme Court. ಅದ್ರ ಮೇಲೆ
ಇದು ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ತಗೊಂಡೋಗಿದ್ರ?
ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ತಗೊಂಡೋಗಿ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಅಲ್ಲಿ ವಿತ್ಡ್ರಾ ಮಾಡ್ಕೊಟ್ರು ಲಾಸ್ಟ್ ಎರಡೇ ಲೈನ್ ಆಫ್ಟರ್ ಅಡ್ರೆಸಿಂಗ್ ದಿ ಆರ್ಗ್ಯುಮೆಂಟ್ಸ್
ಫಾರ್ ರಿಲೀಸ್ ಆಫ್ ದಿ ಅಕ್ವೈರ್ಡ್ ಲ್ಯಾಂಡ್.
ಹೌದು
ಅದು ಆಗೋಯ್ತು, ಫೇಟ್ ಎಲ್ಲ ಸೀಲ್ ಆಗೋಗಿದೆ.
ಅದೇ ಸ್ವಾಮಿ, ಅದ್ರ ಮೇಲೆ ಒಂದು ಇದ್ರ ಮೇಲೆ CRP ಒಂದಿತ್ತು ಸ್ವಾಮಿ, ಇನ್ ರೆಸ್ಪೆಕ್ಟ್ ಆಫ್ ವೆರಿ ಸೇಮ್ ಪಾರ್ಟೀಸ್.
ನಂಬರ್ ಕೊಡಿ.
CRP ನಂಬರ್ 581 of 2020
ಪೆಂಡಿಂಗ್ ಇದೆಯಾ?
ಪೆಂಡಿಂಗ್ ಇದೆ ಸ್ವಾಮಿ.
ಕೊಡಿ. Tag this petition along with so and so, list them both on 22nd.
ಆಯ್ತು,
ಎರಡು ಮುಗಿಸ್ಬಿಡೋಣ ನಾವು.
ಆಯ್ತು.
92,
ಅದ್ರಲ್ಲಿ ನೋಟಿಸ್ ಆಗಿದೆಯಾ?
ನೋಟಿಸ್ ಆಗಿ ಸರ್ವ್ ಆಗಿದೆ ಸ್ವಾಮಿ.
For the petitioner. Amendment application.
617 partition.
Partition.
So what?
It was purchased by the petitioner. The petitioner in the year 2011, and it is a self-acquired property. Earlier,
Self-acquired property is a matter of evidence.
the reason assigned by the trial court is that there is nothing is mentioned in the sale deed as to how he has.
That's a matter of evidence.
It was purchased.
Partition ನಲ್ಲಿ ಕಷ್ಟ.
Junior member of the family has purchased the property in the year 2011. The father
No,
was
sir.
alive. Father was alive. And now what they will do is, after this application is allowed, they will make one more application seeking direction to the tenants to pay the rents. It was his property.
Nothing. The petitioner is before this court seeking the following prayer. The petitioner is the defendant. Calls in question an order dated 2/5/2025 by which the application filed by the plaintiff in under Order 6 Rule 17 comes to be allowed. The suit is for partition. The order of the concerned court, the reasons rendered by the concerned court for allowing the application is as follows. In a suit for partition, it is necessary that all the joint family properties are put as suit scheduled property, so that the suits are not instituted, so that it would not give rise to fragmented institution of suits. In the light of the reasons so rendered by the concerned court, there is no warrant for this court to interfere, as the order does not suffer from any perversity or error apparent. In that light, petition stands disposed.
93,
Petitioner. It is a concurrent order, my lord. The first appellate court, my lord, categorically finds that, my lord.
Order
both the
26 Rule 9.
Lord, no, my lord. This is 39(1) and 2. Lord, the lower appellate court categorically finds that, my lord, the properties belonging to the plaintiff and the defendant number 1 are different properties, distinct properties. Lord, kindly turn to page 68, my lord. The observation is it appears that these properties are distinct properties. Despite that, my lord, no documents are considered.
Page
68, my lord. 67 bottom last line. At this juncture, looking into the documents placed on record, it appears that these properties are distinct properties. Lord, I am the allottee of a
Where am I?
ink page 67.
67.
Last line, my lord.
At this juncture.
At this juncture, looking into the documents placed on record, it appears that these properties are distinct properties. The suit properties belonging to the plaintiff is not disputed with the defendants.
They heard the learned counsel appearing for the petitioner. The petitioner is before this court challenging concurrent findings with regard concurrent findings allowing application under Order 39 Rule 1 and 2. The learned counsel for the petitioner takes this court through the order of the first appellate court. The order reads as the relevant portion reads as follows. In the light of the aforesaid observation by the first appellate court, parties to maintain status quo till the next date of hearing.
24,
2017 suit. Early disposal.
Suit for
Suit for possession, eviction and possession.
the petitioner is before this court seeking the following prayer. The petitioner is the plaintiff, institutes a suit for eviction,
Possession and eviction.
suit for delivery of vacant possession against the respondent. The concerned court has not commenced or concluded the trial despite the fact that a suit for possession is filed and pending 8 years ago. In the light of the prayer being innocuous only to dispose the suit within a time frame and the suit being one of possession, I deem it appropriate to direct the concerned court to dispose the petition with an outer limit of 6 months from the date of receipt of the copy of the order, if not earlier.
Next matter is similar matter, similar
25.
directions.
ಅದು ಯಾವುದು?
Similar directions, my lord. but
ಅದು
it is-
ಸೂಟ್ ಫಾರ್ ಡ್ಯಾಮೇಜಸ್ ಇಯರ್ 2019 ಅಂತ ಮಾಡಿ ಸಾಕಷ್ಟೇ. ಅದು 6 months.
Great,
ಸೇಮ್ ಆರ್ಡರ್ ಜೈ, ಬರೀ 2 ಮಾತ್ರ ಚೇಂಜ್.
great, oblige.
96,
I appear for the petitioner.
ಏನ್ ದೇ ಆರ್ ನಾಟ್ ಇಂಟ್ರೆಸ್ಟೆಡ್ ಇನ್ ದಿ ಸೂಟ್?
They are not interested. I filed an application, but it is rejected. The evidence is recorded that I have reported the death of a defendant number 17, that who died on 3/1/2025. It is reported in 22/1/25, but the court held that the suit is abated against defendant number 17. Against that only I prefer this.
ಟ್ರಾನ್ಸ್ಪೋಸ್ ಹಂಗ್ ಡೈರೆಕ್ಟ್ ಆಗಿ ಆಗಲ್ಲ.
Transpose, I am not challenging the transpose.
Then what are you
That I am challenging only the order passed on 22/1/2025. That is, I reported the death of defendant number 17, who died on 3/1/2025. Till there was a time when I made.
Contesting ಯಾರು?
The contesting, we are the contesting, and the plaintiff, we are the defendant contesting.
Plaintiff serve ಮಾಡಿ will dispose.
Please.
Petitioner to serve on the counsel for the plaintiff before the concerned court. List the matter on 3rd September. We'll
Obliged.
dispose it on that.
Okay.
87,
Appear for the petitioner, my lord. Amendment application file 6/17, my lord, partly allowed. Partition suit, my lord, and implead the item number 35 to 40, my lord. That application is rejected.
That is rejected.
Rejected, man, partly allowed.
Contesting ಯಾರು?
My defendant, respondent 1 to 5, my lord, only family members.
Petitioner to serve the counsel representing defendants 1 to 5 whom the learned counsel for the petitioner submits are the contesting respondents. The petitioner is before this court calling in question a partial allowing of an application filed under Order 6 Rule 17, which in the considered view of the court, albeit prima facie, ought to have merited complete consideration. In that light, further proceedings before the concerned court shall remain stayed 17th September.
98,
Petitioner, let's suit for partition. No, suit for partition.
98.
98. Petitioner.
First, appeal dismissed.
Appeal is dismissed on the premise, my lords, the respondent files a memo. My lords, may kindly peruse ink page number 53.
ಈಗ ಎಂಟ್ರಿ ಮಾಡಲ್ ರೆಸ್ಟೋರ್ ಮಾಡಕ್ಕಾಗತ್ತಾ?
Restore alla.
ಮತ್ತೆ
What happens is that he concedes, saying that I won't put up any construction. After conceding, my lords, the first appellate court, my lords, dismisses the appeal. Despite there being.
ಆಯ್ತು, ಎಂಟ್ರಿ ಮಾಡ್ರೆ ಸಿಕ್ತಲ್ಲ ಇನ್ನೇನು?
No, there is no interim order.
ಅಲ್ಲ,
My
will not put up ಅಂತ ಅಂಡರ್ಟೇಕಿಂಗ್ ಕೊಟ್ಟಿದ್ದಾರೆ.
There is an undertaking, but there is no order to that effect. The appeal is dismissed.
You serve on him, we will pass that order.
Indeed, my lords. Date may be fixed.
Petitioner to serve on the counsel representing the respondent. List on 29th. We will pass that order and dispose it.
Grateful.
Yes.
99,
My lord, I appear for the petitioner, my lord. Petitioner is the plaintiff before the trial court.
38-5.
Please, my lord. Lord, the trial court only on the ground, my lord, that this property does not belong to defendant alone.
No, serve on this.
Please.
Petitioner to serve on the respondent defendant. Counsel for the respondent defendant. List on 3rd September.
I'm requesting for an interim order.
Yeah,
Let the
avvattu
property not be alienated, my lord. There's an agreement to sell already executed by defendant number
List
1.
on 24th September. A respondent shall not alienate the property till the next date. Yes, next.
Great.
100.
My lord, for the petitioner,
The petitioner is before this court calling in question an order dated 25th March 2025 allowing an application under Order 6 Rule 17. The law as obtaining under Article 59 bars the relief that is granted by the concerned court. In that light, further proceedings shall remain stayed.
101.
125 CRPCA,
my lord,
482. What is called in question is a proceeding instituted by the respondent wife under section 125 of the CRPC.
interim application.
Interim order. Yes, sir. CRP, the petitioner is registered to appropriately list the matter before the bench having roster. Alked. 2 courts away.
102.
Lord, appeal for the petitioner, my lord. Petitioner are challenging the INR number 11 dismissed by the trial court, my lord.
Petitioner to serve on the council representing the contesting defendants,
Yes, plaintiff, my lord.
contesting respondents before the concerned court, 17th till such time. Next.
103.
Question is whether the seat court has jurisdiction to entertain.
Covered by my order, sir. Kode.
I'm filing memo to dispense notice to respondent. Notice was never issued to respondent.
A petitioner is before this court seeking the following prayer. Since the proceedings are closed before the concerned court without issuing notice, notice in the subject petition need not be issued. The issue in the list stands completely answered by the judgment rendered by this court in 2025 SCC Online, Karnataka 147142. This court, on considering the identical circumstance, has held as follows. Para 8 till the end.
Please.
The concerned court has grossly erred in law in passing the impugned order, holding that the petitioner does not, the concerned court has no jurisdiction as the respondent does not reside in the said jurisdiction, notwithstanding the fact that the arbitral award was passed in the jurisdiction of the concerned court. In the light of the issue standing answered, petition deserves to succeed. Allowed, quashed the proceedings in AC 114 Ada
Commercial execution 689 of 2024.
22 stands restored on the file of the concerned court. The concerned court is at liberty to regulate its procedure thereafter.
Date for appearance may be fixed because it is a disposed matter. Tomorrow also.
The petitioner shall appear before the concerned court on the 28th, Hakla?
Please.
On the 28th of August.
One other request, my lord, in light of Periamal 6 months direction to dispose of the execution. Very well. Great.
104.
Dismiss ಆಗಿರೋ suit restore ಆದ್ಮೇಲೆ
Okay.
ಬೇಕಿದೆ. Yes.
The petition, my lord, is the respondent number 1 in the execution, my lord. The CMC Sagar, my lord. Lands were acquired for the benefit of the municipality for a drinking water project. Lord, in the execution, my lord,
What application, what you wanted to produce?
Lord, I sought to produce the documents, my lord, kindly.
The audit 12 rule 8 application, what did you want to produce?
Lord, I sought to produce, my lord, the documents relating to the acquisition, documents relating to the award, documents relating to, Lord, all the documents, my lord, pertaining to, Lord, the page. Application, my lord, is at annexure H, my lord.
Next date, you know.
Next date, my lord,
But you are the judgment at all.
please, my lord, Lord, my
What's the next,
intention,
what's
my
the
lord,
next date?
my specific contention. my lord,
Next date.
Lord, it was there day before yesterday, my lord. I don't know, my lord, the next date of hearing.
List petitioner to serve on the council representing the decree holders before the concerned court. List on 10th. Next.
105.
My lord, I appear for the petitioner plaintiff.
Order on rule 10.
Please, my lord. My lord, is already a party in the suit.
Then why again?
My lord, I file a memo, my lord, to delete him, my lord, because there was a chance of settlement with the defendant number 1 and 2.
ಈಗಲೂ chance of settlement ಇದೆಯಾ?
No, my lord, there's no chance of settlement. My lord,
No
is
chance.
continuously alienating the property. My lord, he's a proper party, my lord, to the suit for specific performance because the property is already alienated to defendant number 3. So, my lord, I'm requesting for stay of further proceedings.
Seriously. Petitioner to serve on the council representing the respondents in the trial proceedings, including the proposed defendant number 4. A perusal at the application would clearly indicate that the third respondent was a necessary party to the proceedings had he has purchased the property from the hands of
Defendant number 1 and 2.
defendant number 1 and 2, specific performance of which is claimed by the present petitioner, the plaintiff. In that light, further proceedings before the concerned court shall remain stayed till the next date of hearing, 17th.
Please read.
106.
No representation, 4 weeks, not the list. Next.
107.
The petitioner is before the court calling in question an order dated 3/6/2025 of an application filed in the year 2012.
My lords, I pray 2 days time in this matter.
No problem.
Kindly.
Learned counsel for the petition respondent seeks two weeks.
No, Lordship, there is some inconvenience today, Lordship, kindly.
Allah, take 2
Thus
weeks
may have
time.
it tomorrow at least, Lordship, please.
List the matter on 10th September. Objections, if any, by the
Caveator.
by the caveator respondent by then till such time the order dated so and so shall remain stayed. Please.
108.
Plaintiff's writ petition, my lords. Pleading
When did you
application.
purchase?
My lords.
Allah, yaar, pleading applicants yaar.
Pleading applicants 8 to 11, my lords. They purchased in the year 2022, my lords.
After the
August
suit.
22.
After the suit.
Before the suit, my lords. I filed
Suit for?
Suit for partition, my lords.
Before the suit.
Please, my lords. On 4/8/2022 is the sale deed, my lords. Suit was filed on 17/10/22. After 2 months, suit has been filed. I was not knowing about the transaction, my lords. As on that. After 2 months, my lords, I have filed this.
Let's see. Serve Madi.
Please. Respondent 8 to 11 of the contesting.
Petitioner to serve on the counsel representing respondents.
8 to 11, my lords.
8 to 11, who the learned counsel for the petitioner submits, are the contesting respondents. List the matter on next date.
Date.
But they list the matter on 10 September.
Please.
109.
Suit for declaration and mandatory injunction, my lord. And I have suit for declaration and mandatory injunction. I have been implicated in the proceedings, in the suit
That's
as defendant number
rejected.
4. My property is site number 46, my lord. And the
ನಿಮಗೂ
suit
ಅದಕ್ಕೂ
pro-
ಸಂಬಂಧ ಇಲ್ವಾ?
ಸಂಬಂಧ ಇಲ್ಲ, madam. And the adjoining property owner, Kallama, who is owner of site number 50 and 51, she has not been implicated.
Petitioner emergent notice to the respondent.
Kindly stay may be granted.
1
my
minute.
lord.
Emergent notice to the respondent. In the meantime, the order dated 14/10/2024, which impletes the present petitioner, shall remain stayed.
110.
Commercial suit, Lord.
Speedy disposal.
There is a reason, 2019, 50.
Aito, will grant it for the asking. 2019 in the commercial suit pending, that's
40 applications are filed. 30 applications still pending, my lord.
an apology on the statute. Yes. Heard petitioner is before this court seeking the following prayer. Heard the learned senior counsel Dhyan Chinnappa appearing for the petitioner. The learned senior counsel, the petitioner is the plaintiff, institutes a commercial suit in commercial OS.
13.
Commercial
13 of
OS?
19. Commercial OS 13 of 2019.
13 of 2019. The said suit is still pending, notwithstanding the mandate of the statute for disposal within 1 year. Within 1 year from the institution of this suit. The learned senior counsel impresses upon the court, taking this court through the documents appended to the petition, to demonstrate that about 40 applications are filed time and again, and the court has granted adjournment, time and again. In that light, I deem it appropriate to infuse finality into the proceedings, with the direction to the concerned court to dispose the commercial 6 months. An outer limit of 6 months. If not agreed. All contentions remain open.
111.
This is identical to 104.
Same,
my lord. Same order.
same order. ಯಾವ್ದು
104, my lord.
104 JY. Yes.
112.
Regarding court fee, please, my lord.
Correct.
In a partition suit, I filed the counter relief, please, my lord, the honorable trial court has held that the court fee is to be paid and the consideration shown in the sale deeds.
The order dated, order in 6/9/24.
Please, I also filed the review.
Review rejected, yes.
Review rejected, please.
The order dated 24/4/2025 and 6/9/2024 passed by the concerned court shall remain state till the appearance of the respondents. Petitioner to serve on the counsel representing the respondents in the trial proceedings.
113.
Suit for partition.
Want to implead whom, sir, in partition?
I'm the son of defendant number 5, my lord. The respondent number 3 hearing. And the absolute owner of the scheduled property A and B. As per the gift deed dated 23/2 executed by my mother, my lord.
Gift deed yavathinda?
23/2/2024. Filed the application in June 2024, my lord.
Gift after the suit?
No, the suit is still pending, my lord.
After the institution of the suit?
Right now I may be implemented. I will
No. Gift deed ಯಾವಾಗ execute ಆಗಿರೋದು?
23/2/2024.
Suit institute ಮಾಡಿದ್ದು ಯಾವಾಗ?
21, my lord.
To get over the property gift deed,
No.
ಇನ್ನೇನ್ ಮಾಡಿ?
There are 3 scheduled properties.
Anyway, you have to be inside to fight. Serve on the respondents.
Interim order may be granted.
The petitioner to serve on the counsel who represents the respondents in the trial proceedings 17th in preliminary hearing till such time. Next.
Then 14.
No representation.
115.
Lord, in this matter, I put petitioner.
Partition.
Partition.
617.
Lord, these
Allowed.
issues are framed. Thereafter, I filed an application for amendment. At that stage, my lord, what is this, my lord? Deleted the entire issues and reframed. I'm not let the issues already framed be in the on record. But those
Partition suit al nadiyutte.
Those issues are deleted completely, my lord, and now the posted for when the matter posted for cross-examination of PW1, and now it is posted. It is kept in abeyance, posted for the evidence of the
Heard the learned counsel so and so appearing for the petitioner. The petitioner is before this court calling in question an order dated 1/3/2025 by which an application filed by the plaintiff under Order 6 Rule 17.
My
application filed by the petitioner under Order 6 Rule 17
without hearing me, the
comes to be rejected.
that is allowed, my lord.
ನಿಮ್ಮ application ಅಂತ ಇದೀರಾ ಮತ್ತೆ?
My application for amendment was failed, and the matter posted for to hear on IA number 9. The court has heard the matter on the side of
ನಿಮ್ಮ application ಏನು ಸರ್?
for amendment.
ನಿಮ್ದು 617.
617.
ಅವ್ರದ್ದು ರೆಸ್ಪಾಂಡೆಂಟ್ಸ್
ಅವ್ರದ್ದು ಇಲ್ಲ, ಅಪ್ಲಿಕೇಶನ್ ಇಲ್ಲ.
ಮತ್ತೆ ಏನ್ ಮಾಡುದು? ಏನಕ್ಕೆ ಬಂದಿರ?
ಏನಾಯ್ತು, when the matter posted for the argument, the learned judge has heard the matter on the side of the plaintiff and deleted the issues already framed.
So moto.
That is the reason, my lord. ನಮ್ಮ issues ಇರ್ಲಿ, ಅವ್ರ issues ಇರ್ಲಿ, ನಮ್ ಡಿಲೀಟ್ ಅವರು ಸಬ್ಸಿಕ್ವೆಂಟ್ ಫ್ರೇಮ್ಡ್ ಇಶ್ಯೂಸ್ ಮಾಡಿಬಿಟ್ಟು ಅರ್ಲಿಯರ್ ಇಶ್ಯೂಸ್ ಡಿಲೀಟ್ ಮಾಡಿಬಿಟ್ಟು
ಅಲ್ಲಿ ಬಿಡಿ, ಕಾಂಪ್ಲೆಕ್ಸ್ ಇಶ್ಯೂ
ಹಂಗಾಗೋಗಿದೆ ಅದು.
Petitioner to serve on the counsel represents the respondents in the trial proceedings and file an acknowledgement of such service. Learned counsel for the petitioner submits that the concerned court so moto, without there being any application, has deleted all the issues already framed and evidence let in and has recast the issues. The counsel submits that the additional issues now framed can also be retained along with the earlier issues since evidence was already let in. In the light of the said submission, further proceedings before the concerned court shall remain stayed.
116.
In connected matter, my lords have already granted stay.
Tag this petition along with sounds. Next.
Interim order, kindly.
Same order.
117.
For the respondents 1 and 2. The petition becomes
DNA
test. Petition becomes
wait sir. ಅವ್ರು ಇನ್ನು ಹೇಳೋದೇ ಇಲ್ಲ ಯಾಕೆ?
The suit for partition.
Correct.
Lord, plaintiffs claim to be the children of first wife. First defendant is the father. Second defendant, not third defendant, claims to be the first wife. They allege that she is not.
How many wives?
Two.
Eradella.
And I am born to the second defendant, born to the third defendant. Not the allegation.
Second defendant or third defendant?
Third defendant.
No, I am born to the second defendant. I am born to the.
I am the
third
second defendant, born to the third defendant.
Oh.
So there is already a matrimonial proceeding between first and third defendant. And maintenance has been ordered. There is a series of proceedings amongst them. And now the partition suit is filed by the children of another wife. Who is first, who is second is yet to be decided.
Who is first, who is second?
Our first one. Now the first one. Already it's a matter of court record. Now the application is filed for DNA test of the second defendant. That has been allowed. But my contention is there is already sufficient documentary evidence on record. And unless there is a plea raised regarding non-access between the first and the third defendant, the judgment of the Honorable Supreme Court, but that could not have been allowed.
Ashok Kumar.
Idu Aparna Ajinkya, Florida, 2024, 7.
Blood
SCC.
samples, blood samples already collected, sent to them at the laboratory, run by order. Let the order, as per the order of the trial court, the already collected blood samples, they already sent to them the forensic lab. Now the by report 21/8 there is a matter kept with trial court.
Yavattu?
21/8 ಗಿದೆ.
21/8 ಗಿದೆ.
ಹೌದು. This is the order, trial court order.
Heard the learned counsel appearing for the petitioner.
Before that,
and the respondent. ಹೇಳಿ sir, ಏನು ಹೇಳ್ಬೇಕು?
Annexure C, written statement filed by the D2 and 3, page number 25. Annexure C. That written statement filed by the defense 2 and 3. Defendant 2, the claiming to be the wife, second wife of the defendant number 1. Defendant number 3 is the born to the second defendant. That is their claim. That para number 16 at page number 30. There, their contention is that the third defendant was born on fourth line. In the third defendant born on 19/3/1987. It is the contention of the defendants here, out of the wedlock between the first defendant, second defendant, third defendant born 87. Now, the last way kindly the annexure C, objections filed to the my IA at annexure F at page number 42, para number 9.
Yes.
To overcome my contention in the application, that in the year 1979 there was vasectomy operation to the defendant number 1. There is no chances of not born of the children. That in the para number 9, the defendant number 2 has contended that he born on 10/5/1976. Contrary to the earlier written statement and the objections filed to the my application, annexure F is the.
ಅದಕ್ಕೆ DNA test.
Sorry?
ಅದಕ್ಕೆ DNA test. ಏನು ಆಶ್ಚರ್ಯವಾಗಿ ನೋಡ್ತಾ ಇದ್ದೀರಾ?
ಅಲ್ಲ, ಅವರು 79 ಅಲ್ಲಿ ಆಪರೇಷನ್ ಆಗಿದೆ D1 ಗೆ.
ಏನು ಆಪರೇಷನ್?
Vasectomy operation. There was 3-time test was conducted. 1917 operation was
ಯಾರು who confirmed that vasectomy had happened on 3/10/1976?
1979 was the operation, not 3/7/1979.
It is not admitted, or that whether it is actually done or whether it is successful, we do not know. But in the matrimonial proceedings, all these contentions were raised.
Certificates, the last week of earlier orders also it's there in the
ನೀವು ಯಾರಿಗೆ ಅಪಿಯರ್ ಆಗ್ತಿದ್ದೀರಾ ಮುರಳಿ ಬಾಬು?
ನಾನು the plaintiffs in this suit, the first wife sons,
first wife children,
first wife children. Now second wife ಅವ್ರಿಗೆ ಮದುವೆನೂ ಆಗಿಲ್ಲ, ಮಕ್ಕಳು ಅವರು ಥರ್ಡ್ ಡಿಫೆಂಡೆಂಟ್ ಈಸ್ ನಾಟ್ ದಿ ಸನ್ ಆಫ್ ದಿ ಫಸ್ಟ್ ಸೆಕೆಂಡ್ ಡಿಫೆಂಡೆಂಟ್ ಬಾರ್ನ್ ಟು ದಿ ಫಸ್ಟ್ ಡಿಫೆಂಡೆಂಟ್ ಅಂತ ನಮ್ ಕಂಟೆನ್ಷನ್. ಅವರು ಸ್ಕೂಲ್ ಸರ್ಟಿಫಿಕೇಟ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡ್ತಾರೆ ಇದು ಅರ್ಲಿಯರ್ ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಅಲ್ಲಿ. ಕ್ಯಾರೆಕ್ಟರ್ ಸರ್ಟಿಫಿಕೇಟ್ ಅದರಲ್ಲಿ
ಕ್ಯಾರೆಕ್ಟರ್ ಸರ್ಟಿಫಿಕೇಟ್
ಹೌದು ಹರೀಶ್ ಕುಮಾರ್ ಥರ್ಡ್ ಡಿಫೆಂಡೆಂಟ್ ಸರ್ಟಿಫಿಕೇಟ್ ಕಾಪೀಸ್ ಎಕ್ಸಿಬಿಟ್ ಅರ್ಲಿಯರ್ ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಅಲ್ಲಿ ಪ್ರೊಡ್ಯೂಸ್ 87 ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡ್ತಾರೆ. ಅದರಲ್ಲಿ 25/6/1986 ಡೇಟ್ ಆಫ್ ಬರ್ತ್ ಅವ್ರದ್ದು ಯಾರ್ದು ಥರ್ಡ್ ಡಿಫೆಂಡೆಂಟ್ ಈಗ ಪಿಟಿಷನರ್ ತಮ್ಮ ಮುಂದೆ ಇದಲ್ಲ. ಆಮೇಲೆ ಸ್ಕೂಲ್ ಸರ್ಟಿಫಿಕೇಟ್ ಅಲ್ಲಿ ಹಂಗೆ ಹೇಳ್ತಾರೆ ಮೆಡಿಕಲ್ ಹಾಸ್ಪಿಟಲ್ ರೆಕಾರ್ಡ್ಸ್ ಪ್ರಕಾರ ಹಾಸ್ಪಿಟಲ್ ಅಲ್ಲಿ
ಹಾಸ್ಪಿಟಲ್ ಏನಾಯ್ತು
ಹಾಸ್ಪಿಟಲ್ ರೆಕಾರ್ಡ್ಸ್ ಪ್ರಕಾರ 87 ಅಂತ ಹೇಳ್ತಾರೆ ಅವರು ಹುಟ್ಟಿದೀವಿ ಅಂತ ಹೇಳ್ತಾರೆ 1987. The first medical test, Laship in the year 2024 also, there was a medical test conducted to the first defendant in Kim's Hospital, Research, Bangalore. The medical, in the medical report, it is clear that patient has come for semen analysis on 8/2/2024. Thursday at 12 p.m. in surgery outpatient department. Patient says that he has undergone vasectomy in 1979.
Patient says that.
Patient andre Sannegaudru. First defendant.
Sannegaudru yaru?
Haudu.
Who is Sannegowda here?
Sannegowda is not the under whom they are claiming that the father anta helbitu Sannegaudru father anta avaru claim madudu. First petitioner claim madudu. ಆಮೇಲೆ and now is requesting for semen analysis. ಇದರಲ್ಲಿ
ಏನ್ ಅನಾಲಿಸಿಸ್ ಮಾಡಿದ್ರ ಅದರಲ್ಲಿ
ವೆಸೆಕ್ಟಮಿ ಇದರಲ್ಲಿ
ಏನ್ ಅನಾಲಿಸಿಸ್ ಹೋಗಿದ್ದಲ್ಲಿ
ಆಮೇಲೆ ಇದರಲ್ಲಿ ಸೆಮೆನ್ ಆಮೇಲೆ ಅನಾಲಿಸಿಸ್
ಸೆಮೆನ್ ಅನಾಲಿಸಿಸ್ ಅದಕ್ಕೂ ವೆಸೆಕ್ಟಮಿಗೂ ಏನ್ ಸಂಬಂಧ
ಅಲ್ಲ ಅವರು ಕ್ಲೇಮ್ ಮಾಡಿದ್ರಲ್ಲ 87
ಅವರು ಕೇಳಿದ ಡಾಕ್ಟರ್ ಕೇಳಿದಾರೆ ಏನೇನಾಗಿದೆ ನಿಮ್ಗೆ ಅಂತ ಎಲ್ಲ ಹೇಳ್ಕೊಂಡು ಹೋಗಿದ್ದಾರೆ ಅಷ್ಟೇ. ಹೌದು ಎವಿಡೆನ್ಸ್
ಹೌದು.
ಆಮೇಲೆ
ಅಲ್ಲ ಇದರಲ್ಲಿ ಮತ್ತೆ 1986 ಅಲ್ಲೂ ನಾವು ಟೆಸ್ಟ್ ಮಾಡ್ಕೊಳ್ತೀವಿ. ಟೆಸ್ಟ್ ಇದರಲ್ಲಿ ಡಾಕ್ಟರ್ ಸರ್ಟಿಫಿಕೇಟ್ ಪೋಸ್ಟ್ ಪರ್ಚಮ್
ಈಗ ಮದುವೆನೇ ಆಗಿಲ್ಲ ಇವ್ರಿಗೆ
ಇಲ್ಲ ಅವರು ಸೆಕೆಂಡ್ ವೈಫ್
ಸಣ್ಣಗೌಡ್ರಿಗೆ ಮದುವೆನೇ ಆಗ್ಲಿಲ್ವಾ
ಫಸ್ಟ್ ವೈಫ್ ಅದೇ ಫಸ್ಟ್ ವೈಫ್ ಚಿಲ್ಡ್ರನ್ನೇ ನಾವು
Sannegowda is first husband.
ಅಲ್ಲ husband
only husband.
Only husband.
Only husband.
There are the two wives claiming our second wife son ಅಂತ ಹೇಳ್ಕೊಂಡು ಅವರು ಬರೋದು ಇದಕ್ಕೆ.
ಬರ್ಲಿ ಬಿಡಿ.
ಇಲ್ಲ 86 ಅಲ್ಲಿ 13/11/86 ಸರ್ಟಿಫಿಕೇಟ್ ಮೆಡಿಕಲ್ ಸರ್ಟಿಫಿಕೇಟ್ ಪ್ರಕಾರ that this is to certify that Sri A.C. Sannegowda son of Sri Chikkalingeಗೌಡ ಆದಿಹಳ್ಳಿ ನಗರ
ಅವ್ರ ಅಡ್ರೆಸ್ ಯಾಕೆ ಓದ್ತಾ ಇದ್ರಿ ಯಾರು ಕೇಳಿದವ್ರಿಗೆ ಅವ್ರು ಸೀಮೆನ್ ಅನಾಲಿಸಿಸ್ ಹೋಗಿ ಏನೋ ಹೇಳ್ಕೊಂಡಿದ್ದಾರೆ ನೀವು ಅದನ್ನೇ ಇಟ್ಕೊಂಡು DNA ಟೆಸ್ಟ್ ಮಾಡಿಸ್ಬಿಟ್ಟಿದ್ದೀರಾ.
Sperm count was taken on 3/11/86 and on the basis thereof it is certified that semen analysis ಇಲ್ಲ ಅಂತ ಹೇಳಿ ಬರ್ತದೆ ಇದರಲ್ಲಿ 86 ಅಲ್ಲಿ. ಅದಕ್ಕೆ ಈಗ blood samples already collected. That in view of the by virtue of the order, not the possible trial court. Not the order in the order, it clear trial court order, it clearly says that the D1 and 3 are present. Chandrayapatna medical officer with the lab technicians were present. Blood has been drawn from D1 and D3 from DNA for DNA test. Lokesh PC 749. Shravanabelagala police station is deputed to take the blood sample to the forensic lab. Bangalore and plaintiff side counsel is directed to bear the expense of 3,000 expense PC Shravanabelagala police.
ಆಯ್ತಾಯ್ತು ನೀವು ಬಿಟ್ರೆ ಬರೀ ಅಡ್ರೆಸ್ ಅವ್ರು ಇರೋದು ಎಲ್ಲ ಓದ್ತಾ ಇದ್ದೀರಾ. Yes, heard reserved. In the light of the judgment being reserved after hearing the parties further proceedings before the concerned court shall remain straight till the pronouncement of the judgment. Next.
May I pass on this judgment?
ಇಟ್ಕೊಳ್ಳಿ.
118.
Don't worry.
Aparna,
you can take my judgments. Number
118.
For petitioner, my lords. This is a suit for partition, my lords. We have
appoint receiver to collect rent. Respondent, serve ಮಾಡಿ.
Emergency
Petitioner to serve,
notice.
interim order, I won't grant that. The petitioner to serve on the counsel representing the respondents before the concerned court. List on 10th September. Next.
119.
For the petitioners, my lords.
LACL ಯಾರನ್ನ ಇಂಪ್ಲೀಟ್ ಮಾಡ್ಬೇಕು ಅಂತಿದ್ದೀರಿ?
No, we are not seeking for implement. We are the decree holders.
Hmm.
In that petition, my lord, the respondent number 2 to 10, my lords, they have filed an application seeking to implement as they are also the co-owners of the property. My lords, in the original proceedings, they were not.
Co-owners ಇದ್ರೆ ಮಾಡ್ಲಿ ಬಿಡಿ.
Allah, our contention is they are not belong to our family. So if they have got any right, my
neighbor.
lords, Allah, if they have got any right, my lords, they should have get the decree amended, my lords. The execution is only to execute the decree.
Let us see. ಯಾಕೆ ಅಲ್ಲಿ ಬರಕ್ಕಾಗಲ್ವಾ?
No.
Okay?
No.
Yes.
My lords, that the judgment of the appeals court in 1996, my lords.
ಅಯ್ಯೋ ತುಂಬಾ ಹಳೇದಾಯ್ತು. Yes.
Allah, the position has not been changed.
I know.
Because
2197.
Allah, that is with respect to the
2197.
objection, my lords. Here it
ಇದು
is
one
not a
rule
case
10,
of one rule 10.
ಎಲ್ಲ ಒಂದೇ. The other form ಅಷ್ಟೇ.
Because, no,
Yes.
because, my lords, the honorable appeals court has held that in the
ಆಯ್ತು ಅದನ್ನೇನು ಓದ್ಬೇಡಿ ಪರವಾಗಿಲ್ಲ.
Allah,
ಸರ್ವ್
the
ಮಾಡಿ.
executing court, please,
Petitioner to serve on the counsels representing the
R1 is
respondent.
statement.
2 to 10.
Please.
1 AGA. 10th.
My lords, on 30th, the matter has been posted.
29th. Yes. Sir, ಇವಾಗ್ಲೇ ಮಾಡಿ. Next.
120.
The petitioner is before this court seeking the following prayer. The petitioner is the petitioners are the plaintiffs. Institute a suit in OS 254 of 2010 for declaration and possession. The suit is still pending for the last 15 years. A perusal at the order sheet would indicate plethora of adjournments granted by the concerned court and not taking the proceedings to its logical conclusion. In that light, I deem it appropriate to infuse finality into the proceedings as it is already 15 years old. 6 months. Dispose the matter in 6 months. Next.
121.
Suit for permanent injunction below.
Concurrent.
Permanent.
Concurrent.
Concurrent finding is that, my lord, our contention is that the property itself is not available.
ಅದರಲ್ಲಿ ಡಿಫಿಕಲ್ಟ್. ಅದು 3 ವರ್ಷ ಆಗಿದೆ. All contentions you urge before the concerned court. The petitioner is before this court seeking quashment of an order passed on 19/6/2025, which affirms the order passed by the concerned court allowing application under Order 39, Rule 1 and 2. The petitioner is the unsuccessful defendant before the first appellate court. The reasons rendered by the first appellate court to reject the appeal and confirm the order is as follows. Para 3 in the page 38. I do not find any warrant to interfere with the order passed by the first appellate court affirming the order passed by the concerned court under Order 39, Rule 1 and 2 of the CPC. The petitioner is at liberty to urge all the contentions before the concerned court at the appropriate time. Finding no merit, the petition stands rejected.
122.
The LB matter, post the matter before the bench having roster at the LB as the proceedings as it is not GMCPC but a local board LB matter. But please post before the bench having roster. Next.
123.
I am for the petitioner counsel. Divergent finding, Order 39.
There is no representation on behalf of the respondent, the caveator. We list the matter on 17th. Status quo where the property be maintained till the next date of hearing.
Possession, my lord, I am with the possession.
Status quo. Yes.
24.
Appear for petitioner.
Stage of cross-examination,
cross-examination, and it was not allowed.
but rejected, allowed.
ಇಲ್ಲ ರಿಜೆಕ್ಟ್ ಆಗಿದೆ. So,
Reject ಆಗಿದೆ ಮತ್ತೆ.
This was remand, it's a remand matter, my lord.
From where? First appellate
Lower
court.
appellate, yes, first appellate court, only to appoint a court commissioner. Court commissioner.
Petitioner to serve on the counsel representing the respondent defendant before the concerned court. List on 10th September. Till such time further proceedings shall remain still. Next.
25.
But concurrent.
Lord, application, Lord, seek injunction not to alienate. There is already one alienation, my Lord. Now, there is a possibility of second alienation. The application is rejected. We filed a miscellaneous appeal. Not
Appeal is
considered-
also rejected.
ಇಲ್ಲ, reject ಮಾಡಿಲ್ಲ.
ಮತ್ತೆ ಏನ್ ಮಾಡಿದ್ದಾರೆ?
Emergent notice ಅಂತ ಮಾಡಿದ್ದಾರೆ.
ಅಷ್ಟೇನಾ? Will direct the appellate court to consider it.
ಅಲ್ಲ sir, ಅಷ್ಟು
Within
ಮಾಡ್ಬಿಡ್ತಾರೆ sir.
within 2 weeks.
No, in this case particularly, because it's already alienated and we filed application to implead the purchaser. Now, there is a possibility of second alienation, my lord. There is a genuine threat, my lord.
The petitioner is before this court. Petitioner is the defendant. Challenges an order passed under.
Plaintiff.
Petitioner is the plaintiff. Challenges an order of rejection of application under Order 39 Rule 1 and 2 before the first appellate court. The first appellate court issues notice and does not grant an order of temporary injunction as sought for. The learned counsel for the petitioner submits that where the respondent defendants would alienate the property as they have already alienated once, and the purchaser was impleaded as a party respondent in appeal
In the OS.
in the original suit. In the original suit, and would apprehend second alienation. Therefore, the concerned court ought to have protected the petitioner. The petitioner shall serve on the counsel representing the respondent defendants. The defendant shall not alienate the property till the next date of hearing.
Defendant number 1 only.
Defendant number 1, not alienate the property till the next date. List on 10th September. We'll dispose it and send it back. Please.
126.
My lord, 126 appear for petitioner, my lord. My lord, similar matter is posted for on 28th of this month, my lord.
PK Gajra.
Yes, my lord. Yes, my lord. There are other 18 matters, my lord. Kindly collect
18
all.
matters.
There is
Ah,
so
Swami.
many alienations made and transfer of my property to by the developer.
That is, I'll serve on copy on them, my lord. Kindly have all this thing on 28th, my lord. Similar.
Let them serve copies on us.
I'll serve.
Numbers kodi.
My lord. Copy. Today itself, I'll serve the copy, my lord.
Serve ಮಾಡಿ.
Please.
We'll take it on 22nd.
My lord, 20th, already a matter has been posted. Similar matter.
I'll tag the petition along with so and so. List on 20th.
Please, my lord. Oblige me.
Heard so and so ಅಂತ ಮಾಡಿ ಆಮೇಲೆ ಮಾಡಿ.
127.
Petitioner in this case.
1817 allowed.
No, rejected by.
Correct ಆಗಿದೆ.
Recall and reopen the suit for injunction.
Correct. ಎಷ್ಟು ವರ್ಷದ್ದು? 2020.
But
ಎಷ್ಟನೇ ಸರ್ತಿ ಕೇಳಿದ್ರಿ ಇದು?
third time.
ಥರ್ಡ್ ಟೈಮ್. ಅಯ್ಯೋ. ಫಸ್ಟ್ ಟೈಮ್ಗೆ ಕೊಡಲ್ಲ ನಾವು. ಥರ್ಡ್ ಟೈಮ್ ಗೆಲ್ಲಿಂದ ಬರುತ್ತೆ.
No, my lordship. On the first time only the matter is reached on 5:30. The court has adjourned. The second time also is same time reached. And third time on 38/2024.
Anyway, serve ಮಾಡಿ. Let the respondent concede, we'll see. Petitioner to serve on the counsel for the respondent. List the matter on 3rd
Matter is
September.
posted for argument, sure.
So what? List on 3rd September. Next.
128.
For petitioner, sir. 1 week time, sir. Senior complaint.
List after 4 weeks at the request of the counsel appearing for the petition. Registry is directed not to. Next.
29.
129 appear for the petitioner, my lord. In this petitioner, in this case, my lord, the petition before the district court under section 73, 74, 75 of the.
Sir. Petitioner to serve on the counsel who represents the respondent in the, before the concerned court. List on 10th.
Milord, ಅದು interim
No,
order
sir.
ಬೇಕು.
I have not seen you in the court only. You're always in the office.
ಅಲ್ಲ 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 sorry. ಅದು interim
Work
order
from
ಸ್ವಾಮಿ.
home ಗೊತ್ತಿದ್ದು, work from office ಗೊತ್ತಿಲ್ಲ.
ಅಲ್ಲ ಅಲ್ಲ ಮೊನ್ನೆ ಬಂದಿದ್ದೇನೆ ಸ್ವಾಮಿ, ಮೊನ್ನೆ ಇದ್ದೆ ನಾನು.
Oh, last year ಬಂದಿದ್ರಾ?
ಅಲ್ಲ ಲಾಸ್ಟ್ ವೀಕ್ ಅಲ್ಲಿ ಇದ್ದೆ. ಅಲ್ಲ ಒಂದು interim order.
No, sir, not an interim. Next.
I'm for the petitioner, my lord.
130.
Specific performance.
When did you purchase property?
Registered agreement ಆಗಿರೋದು 23/5/2000.
Suit ಮುಂಚೆನಾ?
ಸೂಟ್ ಮುಂಚೆ ಅಲ್ಲ, ಸೂಟ್ ಆದ್ಮೇಲೆ ಸ್ವಾಮಿ. ಯಾಕಂದ್ರೆ ಅವರು ಡ್ಯೂ ಡೆಲಿಜೆನ್ಸ್ ಮಾಡಿದಾಗ ಅನ್ರಿಜಿಸ್ಟರ್ಡ್ ಅಗ್ರಿಮೆಂಟ್ ಆಗಿದ್ರಿಂದ ನಮ್ಗೆ ಗೊತ್ತಾಗಿಲ್ಲ ಸ್ವಾಮಿ. ಯಾವ್ದು ಇದು ಎಂಟ್ರೀಸ್ ಯಾವ್ದು.
The petitioner to serve on the counsel who represents the respondent, plaintiff, before the concerned court and file an acknowledgement of such service by the 28th. List the matter on 17th September. Further proceedings before the concerned court shall remain stayed till the next date.
131.
131 and 135 same.
Yes, ma'am. Suit for recovery of my, I'm only asking for refund of the court fee, ma'am. The court directs me to approach the arbitrator.
Correct, I know it is to be refunded. Respondent ಬೇಕಾಗಿಲ್ವಾ ಅದಕ್ಕೆ?
ಬೇಕಾಗಿಲ್ಲ.
ನಾಳೆ ಹಾಕ್ತೀನಿ, ನಾಳೆ ಡಿಸ್ಪೋಸ್ ಮಾಡ್ತೀನಿ.
ಇನ್ನೂ 2 matter ಇದೆ ಸ್ವಾಮಿ.
ಕೊಟ್ಬಿಡಿ ಅಲ್ಲ. Tag this petition along with so and so list tomorrow in preliminary hearing.
132.
My lord, but the petitioner, the other 2 matters connected, my lord. 22/428/25,
Number
23/001/25. Kindly order.
ಅದ್ರಲ್ಲಿ ಸ್ಟೇ ಇದೆಯಾ?
ಇಲ್ಲ ಡಿಸ್ಪೋಸ್ ಆಫ್ my lord. Mandate.
ಡಿಸ್ಪೋಸ್ ಆಗಿದೆಯಾ ಅದು?
ಅಲ್ಲ ಆಗ್ಬೇಕು, ಇದನ್ನು ಅದ್ರ ಜೊತೆ.
ಆಯ್ತು, ಲಿಸ್ಟ್ ಏನ್ ಕೇಳಿರೋದೇನಿಲ್ಲಿ?
Mandamus.
Threat of Mandamus.
The AS pending before the Honorable Principal District Session Judge Ramnagar.
2019 ಇಂದ?
ಹೌದು sir.
List tomorrow along with so and so.
Please.
Next, yes.
133.
Petitioner defendants. ಎಲ್ಲ ಒಂದೇ ಕನ್ಕರೆಂಟ್ ಇದೆ ಸ್ವಾಮಿ. ಆದ್ರೆ
ಫಸ್ಟ್ ಅಪೆಲೇಟ್ ಕೋರ್ಟ್ ಸೇಮ್ ಏನೇನು ಮಾಡಿಲ್ವಾ?
ಏನು ಮಾಡಿಲ್ಲ.
ಸೇಮ್ ಆರ್ಡರ್ ತಗೊಳ್ಳಿ. ಬಟ್ರೆ ನಿಮ್ದು ಯಾವ್ದು? ಇನ್ನೊಂದು
133
ಅಲ್ಲ ಮುಂಚೆ ಕೊಟ್ಟಿದ್ದ ಆರ್ಡರ್ ಯಾವ್ದು? ಈಗ ಒಂದು ಕೊಟ್ಟಲ್ಲ ಫಸ್ಟ್ ಅಪೆಲೇಟ್ ಕೋರ್ಟ್ ಎಲ್ಲ. ಸೀರಿಯಲ್ ನಂಬರ್ 125 ಸೇಮ್ ಆರ್ಡರ್. ನೆಕ್ಸ್ಟ್. ಜೋಬಿಂದ ಚೀಟಿ ತೆಗಿತಾ ಇದೀರಾ?
ಸೀರಿಯಲ್ ಇದು that is not to alienate, my lord.
Correct, sir. ಇದು ಏನು?
ಇದು I am challenging the grant of injunction. I have sought for stay of the
status quo be maintained till the next date of hearing. Next. V.V. Shivakumar. No representation. 2 weeks. Next.
135 and 136.
Petitioner to serve on the counsel who represents the ಇಲ್ಲ ಇದ್ದೀರಾ?
R1 to R4.
Learned counsel so and so undertakes to enter appearance for respondent 1 to 4. We'll take it on Monday. Don't alienate the property till then.
Please.
List the matter on 29th. The respondent shall not alienate the property till the next date of hearing.
Please.
Next.
Notice may be issued, my lord, to respond number 5 to 7.
Petitioner to serve on the counsel who represents the remaining respondents before the concerned court.
Please.
137.
I appeal for petitioners, my lords. Seek for a short adjournment, my lords.
V.V. Shivakumar. 137, madam.
Yes, ma'am.
Short adjournment. Why?
The senior is held up in other court.
You have not seen the file? Where is the file?
File is with the senior.
ಯಾವ್ದಾರ ಒಂದು ಫೈಲ್ ತಗೊಂಡಾರ ನಿಂತ್ಕೋಬೇಕಲ್ಲ. It's a case for stay.
Yes, my lords.
Yes, sir.
It's not for stay, my lords. Miscellaneous first appeal.
At the request of the counsel appearing for the petitioner, list the matter on 1st September.
Yes.
But get the read and come henceforth. Yes.
138.
Petitioner is
ಇದು ಅಷ್ಟೇ
39
same.
rule 1 and 2, my lord. 39 rule 1 and 2, my lord.
Correct.
Please.
ವಾಪಸ್ ಹೋಗಿ ಅಲ್ಲೇ.
That is.
Defendants are represented now?
No more representation. Only in IA 1 of 22 is suit summons issued the trial court, my lord. And this is page number
Petitioner to
36.
serve the respondents by way of hand summons and file an acknowledgement of such service. List the matter on 3rd September. This defendant shall not alienate the property till the next date of hearing. Next.
139.
Petition dismissing IA for appointment of commission.
Correct ಆಗಿ.
ಇಲ್ಲ,
Suit
correct
for.
ಇಲ್ಲ. Suit for declaration and possession.
10 ವರ್ಷ ಆದ್ಮೇಲೆ. At what stage did you file? 26/9 through 2014?
Yes.
Application 24.
Yes, because
Yes, sir.
there was no representation in the trial court judges, my lord, and.
Trial court judges ah?
Some of the, sometimes this court was vacant, that's why it was taken.
Sometimes
over.
this court was vacant.
Yes, this particular trial court.
Or trial court.
Yes, not this court, my lord. He has admitted in the cross examination that he has enclosed the property, my lord. He has admitted in the cross examination, but he said he enclosed on the roadside, 11/5, same common.
Roadside ಮಾಡಿದ್ರೆ ನಿಮಗೇನ್
No,
ಸಂಬಂಧ?
he has demolished the common wall and enclosed the entire my property, my 11/5.
Fair property.
Entire property which
Serve
is.
ಮಾಡಿ ನೋಡೋಣ. Petitioner to
Sir,
serve.
The advocate who represents the trial court, my lord. Please.
Petitioner to serve on the counsel who represents the respondent in the trial proceedings. List on 3rd September.
Please.
140.
My lord, issue has been.
Preliminary
taken.
issue.
Yes, my lord. Only court fee, my lord. Though full bench judgment of this court was.
Petitioner to serve on the counsel who represents the respondent before the concerned court. List the matter on 17th. Further proceedings before the concerned court shall remain stayed till the next date.
141.
Delivery warrant. ಇನ್ನೇನ್ ಮಾಡ್ಬೇಕು execution ಅಲ್ಲಿ ಅದೇ ತಾನೆ?
Twice the matter was remanded, my lords. Adverse possession, point of adverse possession has not been considered by both the courts, my lords.
No, sir.
The matter is pending before this honorable court, my lord, on the civil appellate side, my lords. Therefore, my lords, the executing court, my lords, should have deferred the matter. Otherwise.
I will also defer the matter. List after 2 weeks. Petitioner to serve on the counsel who represents the respondent in the execution proceedings.
Till
List
then.
on 3rd, no sir.
Till then, no.
No.
Otherwise, if I am disposed of 3.5 acres of land, my lords.
List on 3rd, yes. Next.
142.
The petitioner is before this court seeking the following prayer. The learned counsel, the petitioner is the defendant. The suit in OS 343 of 2019 is set to be heard and reserved on 14/10/2024 and the judgment is yet to be pronounced. In that light, the concerned court shall dispose this suit by pronouncement of judgment within an outer limit of 4 weeks from the date of receipt of the copy of this order, if not earlier. Ordered accordingly. Next.
143.
Petitioner to serve on the counsel who represents the respondent in the trial proceedings. The trial proceedings file an acknowledgement of such service. List the matter on 17th till such time further proceedings before the concerned court shall remain stayed.
144.
ಹೇಳಕ್ಕೆ ಬಿಡಲ್ವಲ್ಲ. ಕೊಡಲ್ಲ ಅಂದ್ರೆ ನಾನು ಡಿಟೆಕ್ಷನ್ ಶುರು ಮಾಡೋದೇ ಇಲ್ಲ, ಡೋಂಟ್ ವರಿ. ಎಸ್ ಸರ್.
44 I am applicable.
Compromise decree.
Compromise
Oh,
decree.
sir.
In that, I am entitled for 34 guntas. They allotted me only 13 guntas. In that effect, the filed for cancellation of compromise petition in the trial court. Now.
Compromise ಆಗಿದ್ದು ಯಾವಾಗ ಸರ್?
Compromise ಆಗಿದ್ದು 23 ಇದ್ರಲ್ಲಿ.
2019. You are the judgment debtors.
Yes. No, see, in the compromise petition, kindly see the page number.
Emergent notice to the respondent, returnable by
There is
the
appointment
17th.
of commissioner
No,
to execute
let
the share deed, my lord. Kindly.
Nothing. Yes,
till-
yes. No,
till the
sir.
Service of notice.
Servant come. List on 10th. Yes.
145.
Two days time.
2 days time.
Senior is Shabarimala.
Traveling. Sorry. List after 2 weeks, since
weeks,
the
2 days.
arguing counsel is said to be traveling for the next 2 weeks.
2 weeks, my lord. 2 days.
2 weeks. Yes, next.
2 days next commercial court ಅಲ್ಲಿ
ಡೇಟ್ ಇದ್ರೆ ಇವತ್ತು, ಇಲ್ಲ ಅಂದ್ರೆ ಇಲ್ಲ. ಎಸ್, ನೆಕ್ಸ್ಟ್.
46.
In this case and the next case,
If you have to go.
we want to file a counter, your lordship may get this 1 week's time.
ನೆಕ್ಸ್ಟ್ ಡೇಟ್
Next date is
ಅಕ್ಟೋಬರ್
6/9.
6/9.
6/9.
ವಿಲ್ ಫಿಕ್ಸ್ ಇಟ್ ಆನ್
I'm
3.
not asking for stay of the proceedings.
ದೆನ್ ಅವ್ರ ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕ್ಲಿ ಬಿಡಿ.
It's an amendment application. In a application seeking to set aside a compromise petition, grounds are taken. Now you're taking grounds that the original proceeding itself was not maintained. That's the amendment.
ಆಯ್ತು, ಲೆಟ್ ಹಿಮ್ ಫೈಲ್ ವಾಟ್ ಎವರ್. Heard the learned senior counsel Dhyan Chinnappa appearing for the petitioner and H.S. Dwarkanath for the respondent. The learned counsel seeks 10 days time
10 days time.
to file statement of objections. List the matter on 10th September. Agboda? Adyavatu ಅಲ್ಲಿ?
Before that date, if it.
3rd September. Objections, if any, by then. In the event no objections are filed, this court would be constrained to grant stay of further proceedings before the concerned court.
148.
They may want that.
Oh, but
That is exactly what
not
they-
necessary. Yes, yes.
Illa, we are also eager to get the case. If you are not pressing that, we will get answer.
147 same, huh?
146.
147 same.
148.
If the petitioner, my lords,
For a QA
written
response.
statement. Lords,
Award
calculation,
Rajeshwar.
lords, 120 days have not happened. I filed it on 120th day, my lords.
No.
Court has taken a wrong calculation, my lords.
No,
Kindly
no,
come to
sir.
page 27, my lords.
Date.
20
Dates ಹೇಳಿ.
Lords, suit summons was served by RPAD on 1/5/2024 and 2/5/24, my lords.
On 1/5 and 2/5.
There are three defendants.
ಆಯ್ತು, ಸರಿ.
Please, my lords. Then, my lords, on 23
WS filed on.
plus WS filed on 20th September 2024, my lords. 20th September.
4 ತಿಂಗಳಾಯ್ತು.
The suit summons through court was served on 23/5/2024.
What is 1/5 and 2/5?
It came by RPAD, my lords. Only the suit summons was there, my lords. Plaint was not accompanied, my lords. Then, my lords, on 3/9/2024, my lords, I requested the Honorable Trial Court to grant me time. The Honorable Trial Court granted time to file the written statement. This 3/9/2024 was the date when 120 days had already expired. If my lords were to take the 1st September, 1st February, 1st May or 2nd May as the time.
Difficult, sir.
Plus, if suit summons served through court, I mean, with plaint copy, my lords, then, my lords, I'm within time. Plus, when the plaint is served, my lords, not served, my lords, it's difficult.
Let's see, ಯಾವುದು you're on the periphery. We'll see.
Therefore, my lords, unless the suit summons accompanies the
We'll
plaint,
see.
order 5 requires the plaint to accompany the suit summons, my lords.
ನೋಡ್.
My lords, there is no such contention in the application or while the.
ಅದು ಇಲ್ಲಿ
requesting, my
ಹೇಳಿದ್ದಾರೆ
lords.
ಬಿಡಿ. We'll answer it. We will not stay for the proceedings. I'll take it on 22nd.
Please.
You look into the judgment and come.
No, 120 days, no court has any power to grant time. There's no, the question is reckoning.
2025 SCC online Karnataka 1213.
I'm not on that aspect. I'm saying my written statement is within 120 days and interpretation to be placed on order 5.
We'll see. List on 22nd.
Plus, is the sole respondent.
ಬೇರೆ ಯಾರಿಲ್ವಲ್ಲ?
ಬೇರೆ ಯಾರಿಲ್ಲ.
Registry to print the name of, ಇದರಲ್ಲ, this is already on KBA.
Please.
22nd.
49.
1817. No, sir. How many times?
Lord, partition suit. She executes a release deed in our favor. In spite of that, she files a suit for partition in the year 2013. I produce additional documents. At least for that sake, my lord, the court could have given me permission.
With exemplary costs will permit. But serve and get.
Please.
Petitioner to serve on the counsel representing the respondent. List on 28th.
Matter is on 20th for final argument.
Sir, parval. List on 22nd ಮಾಡಿ. Yes.
Stay till then.
No, sir. You seek adjournment there.
Please.
150.
Lords, 150, I appear for the petitioner, my lords.
Petition to serve on the counsel who represents the respondent in the trial proceedings. Status quo quo, the property be maintained till the next date of hearing. What's the matter on 17th September? Next.
151.
For petitioner in this case, blood.
ಏನ್ ಮಿಸ್ಟೇಕ್ ಆಗ್ಬಿಟ್ಟಿತ್ತು?
ಅಲ್ಲ, ಅದರಲ್ಲಿ ಒರಿಜಿನಲ್ ಪಾರ್ಟಿಷನ್ ಡೀಡ್ ಅಲ್ಲಿ ಸರ್ವೆ ನಂಬರು ಮತ್ತೆ ಎಕ್ಸ್ಟೆಂಟ್ ತಪ್ಪಿದೆ. ಒರಿಜಿನಲ್ ಪಾರ್ಟಿಷನ್ ಡೀಡ್ ಅನ್ರಿಜಿಸ್ಟರ್ಡ್ ಪಾರ್ಟಿಷನ್ ಡೀಡ್ ಏನಿತ್ತು ಅದು. ಬಟ್ ಪ್ಲೈಂಟ್ ದ ರೆಸ್ಪಾಂಡೆಂಟ್
ಅದನ್ನ ನೋಡಕ್ 13 ವರ್ಷ ಯಾಕೆ ತಗೊಂಡ್ರಿ?
ಆಕ್ಚುಲಿ ಪ್ಲೈಂಟ್ ಅಲ್ಲೂ ಹೇಳಿದ್ದಾರೆ ಆಕ್ಚುಲಿ ಕರೆಕ್ಟ್ ಮೆಷರ್ಮೆಂಟ್ ಏನಿದೆ
13 ವರ್ಷ ಯಾಕೆ ತಗೊಂಡ್ರಿ ಅದನ್ನ ರಿಯಲೈಸ್ ಮಾಡ್ಕೊಳಕ್ಕೆ?
ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ರೆವಿನ್ಯೂ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ನೋಡಿದಾಗ ಅವ್ರು ಕರೆಕ್ಷನ್ ಕೊಟ್ಟಾಗ he recognized that one. But in fact, the court have identified that this is a mistake.
Get the contesting respondent.
Yes, ma'am.
Petitioner to serve on the contesting respondent by way of hand one day respondent.
One day respondent.
By way of hand summons list on 10th September. ಅವ್ರು ಒಪ್ಪಿದ್ರೆ ಕ್ಲೋಸ್ ಮಾಡು.
ಅವ್ರ ಅಬ್ಜೆಕ್ಷನ್ ಮಾಡೇ ಮಾಡ್ತಾರೆ.
ಅದು ಏನ್ ಮಾಡಕ್ಕ? 13 ವರ್ಷ ಆದ್ಮೇಲೆ ನೀವು ಎದ್ರೆ?
In fact, the plaint
ಈಗ ಅಡ್ಜರ್ನ್ಮೆಂಟ್ ಆದ್ಮೇಲೆ ಆರ್ಗ್ಯುಮೆಂಟ್ ಆಮೇಲೆ
152.
Application and order 6/17 lots.
ರಿಜೆಕ್ಟೆಡ್.
Rejected.
ಕರೆಕ್ಟ್. 2007 suit ಅಲ್ಲಿ 2024 ಹಾಕಿದ್ರೆ ಇದೇ ಆಗದು.
Lots, my only belief is lots. But the judge sale deed executed by lots, the lots co-shaver lots is not binding on me lots. Before the lots partition, the sale deed was executed. Before the partition, sale deed was executed.
All the more reason that 617 should be rejected. Anything else, sir? Urge all this before the concerned court.
Lots, there is no prior lots to that effect lots. I'm seeking lots amendment.
Anything else?
So the only thing is lots.
Anything ಅಂದ್ರೆ only thing ಹೋಯ್ತು ಈಗ. ನವೀನ್ ಇದ್ದರ ನಾನೇ ಕೊಡ್ತೇನೆ. 7 suit ಅಲ್ಲಿ 24 ಅಮೆಂಡ್ಮೆಂಟ್ ಹಾಕಿ ಅದು ರಿಜೆಕ್ಟ್ ಕರೆಕ್ಟ್ ಆಗಿ ಮಾಡಿ. ಜಮೀಲ್ ಅಲ್ಲ? ಅವ್ರೇನು ಹೇಳಿದ್ರಲ್ಲ, ಏನ್ ವಿಡ್ರಾ ಮಾಡ್ತೀರಾ? ಇಲ್ಲ.
To the extent not the prior, not that is not binding. The sale deed is not binding on.
It is an argument you can advance. Anything else? Dismissed.
Dismiss as withdrawn lots. I will withdraw lots.
Counsel for the petitioner seeks leave of this court to withdraw the petition and urge all the contentions advanced in the subject petition before the concerned court. Reserving such liberty, the petition stands disposed as withdrawn. Yes, sir.
153.
ಇನ್ನು ತೀರ್ಮಾನ ಆಗಿಲ್ವಾ ಸೂಟು?
ಇಲ್ಲ ಮೈ ಲಾರ್ಡ್ಸ್, ಇನ್ನ ಆಗಿಲ್ಲ.
1998 ಸೂಟ್.
ಕರೆಕ್ಟ್ ಮೈ ಲಾರ್ಡ್ಸ್.
ವೈ ಇದು ಅದಕ್ಕೆ ಸಂಬಂಧಪಟ್ಟಿದ್ದೇನಾ?
ಇಲ್ಲ ಮೈ ಲಾರ್ಡ್ಸ್, ದಿಸ್ ಇಸ್ ಡಿಫರೆಂಟ್.
ಸಂಬಂಧ ಅದೇನು ಹೇಳಿದ್ರಲ್ಲ ಯಾರು? ಜೈರಾಜ್. ಅದಕ್ಕೆ ಇದಕ್ಕೆ
ಇಲ್ಲ ಮೈ ಲಾರ್ಡ್ಸ್.
The petitioner is before this court seeking the following prayer, heard so and so. The petitioner is the first defendant before the concerned court in a suit instituted for declaration. The suit is instituted in the year 1998 and is said to be languishing before the concerned court even today, despite passage of 27 years.
Yes, madam.
The pendency of this suit in OS 8201 of 1998 before the concerned court for 27 years is appalling. The learned counsel for the petitioner takes this court through the documents appended to the petition to demonstrate that adjournments are granted without any rhyme or reason for the last 20 years. In that light, the concerned court shall endeavor to conclude the proceedings in OS 8201 of 1998 within 2 months from the date of receipt of the copy of this order, if not earlier. ನೀವು ಕೇಳಿದ್ಕಿಂತ ಒಂದು ಜಾಸ್ತಿ ಅಷ್ಟೇ.
Yes.
154.
154, my lords, appear for the petitioner. I filed an application for revocation.
Petitioner to serve on the counsel who represents the respondent in the trial proceedings. There shall be an interim order of stay of further proceedings in P&SC.
Not.
ಯಾವ್ದ್ರಲ್ಲಿ ಬೇಕು?
No, I'm not asking for further proceedings, my lords. I'm asking for the further order passed by.
There shall be an stay of the impugned order so and so till the next date of hearing.
What has happened, I'll just explain in a minute, my lords. They have issued a probate certificate has been issued. I filed for an application for revocation of the probate certificate. In the meanwhile, my lords, the revenue entries have been changed. The application, Dasildar has kept the date for 28th of this month. Now, my lords, by taking advantage of the certificate, my lords, I have sought for a stay of the order of the issuance of probate certificate.
ಅದು impugned ಅಲ್ವಾ?
No, that is not impugned.
What have you impugned?
No, I have challenged for the notice for IA which I have filed. Notice has been issued. That is impugned before your lordships.
Whatever is impugned will grant stay. There shall be interim order of stay of the order impugned. You should know what to impugn
My lords, that,
and all further proceedings taken thereto. Yes. ನೀವು ತಹಶೀಲ್ದಾರ್ ಕೊಟ್ಟರೆ ಸ್ಟೇ ಕೇಳಿದ್ದೀರಾ ಇಲ್ಲ ತಾನೆ?
yeah, Tahsildar, I asked for,
ಅದನ್ನೇ ಕೊಟ್ಟಿದ್ದು ಮತ್ತೆ. Yes, next.
I've asked for not direct the respondent, the revenue authorities not to effect change in the name of the.
As spread for ಮಾಡಿಬೇಡ. Yes, next.
Please.
155.
Duty penalty ಬೇಕೇ ಬೇಕು ಸೇಲ್ ಡೀಡಿಗೆ.
When the document has been produced before subregistry only, it arises. Already registered agreement and GP has been registered before.
Not yet produced.
ಇಲ್ಲ ರಿಜಿಸ್ಟ್ರಿಗೆ suit pending ಇದೆ performance. When the suit is decreed, then only it arises.
The petitioner shall serve on the counsel who represents the respondent.
Just expert before trial court.
ಯಾರು ಇಲ್ವಾ ಹಾಗಾದ್ರೆ?
ಯಾರು ಇಲ್ಲ.
ಯಾರು ಇಲ್ವಾ?
Defendants expert plus expert. ನೋಟ್ ಮಾಡಿದೆ ಅದರಲ್ಲಿ ಕಾಸ್ಟ್ ರೇಟ್.
Where is the order? Expert ಅಂತಿರೋದು ಎಲ್ಲಿದೆ? ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಆರ್ಡರ್ ಇದೆಯಾ?
8/12/20. Page number 17.
Page number
17.
Not represented at all.
D1 D4 refused to receive the summons.
The
Service of
order
summons.
dated, order impugned shall remain state till the next date. Further proceeding, it's made clear, further proceedings before the concerned court is not stayed. Yes.
Then we are not claiming any relief against respondents.
ಮತ್ತೆ ಅವರು ಎಕ್ಸ್ಪರ್ಟ್ ನಾ ಏನ್ ಮಾಡ್ಲಿ? ಹ್ಯಾಂಡ್ ಸಮನ್ಸ್ ಅಲ್ಲಿ ಸರ್ವ್ ಮಾಡ್ತೀರಾ? Petitioner to serve by way of respondents by way of hand summons. Next.
156.
For the petitioner, my lords, I'm
Yes.
seeking a mandamus. My
Correct,
lord.
madam. Petitioner to serve on
For 4 and 5 KIDB, my lords.
4 and 5. Name.
Charan Sabrad, my lords.
1, 2, 3 AGA. List on 9th September. Next.
157.
For the petitioners.
You are in possession.
I am in possession. I am running a poultry and animal sheep yard. And
1 AGA. Nice.
Nice. KIDB.
Oh,
KIDB.
Dildar.
Yes, ma'am.
Yes. The council so and so accepts notice for the second respondent board. List the matter on 16th September. The petitioner, if in possession as on today, such possession shall not be disturbed till the next date. Next.
158.
For the petitioner, my lord.
Approval of award.
Lapse of acquisitions.
1 ನಿಮಿಷ sir. The learned council, learned HCGP accepts notice for respondents 1 to 4.
1 to 3, my lord. 4 learned and Nagaya may be directed to accept.
Okay? Regional commissioner. ಅವರೇ sir.
Sorry, my lord.
5th respondent Nagaya.
Please.
Council Nagaya so and so accepts notice for the 5th respondent. Petitioner to serve set of papers upon the aforesaid council. List the matter on 16th September.
159.
Learned counsel PV Chandrasekhar accepts notice.
Appeared and it's covered, my lords.
Kodi.
Already it is- They received the compensation.
Against them,
They received the compensation.
covered against them or what?
No, in respect to identical matters, similar to the matters.
Same counsel for the petitioner respondent in unison would submit so and so. Disposed. Next.
160.
You are in possession.
Yes, I'm in possession of the property.
Same. Learned counsel BB Patil is directed to accept notice for the board. HCGP for respondents.
2 and 3 KDP.
2 and 3 board, 1 HCGP if in possession shall not be disturbed 16th. Next.
161.
NHI compensation.
Please.
My lords, I appear for respondent numbers 2 and 3 in this matter. I pray for some time to file my objections.
I sought for a mandamus to consider my representation.
List the matter on 9th September.
Could it be on 10th, 9th?
10th, 9th or 16th?
16th, 9th.
16th, yes.
Grateful, my lords.
Next.
162,
My lord, I appear for the petitioner.
NHAI.
NHAI, while paying the compensation, they have deducted the GST
We'll
amount.
see.
GST.
Learned counsel, the Sudarshan, madam?
R1.
Yeah, 160?
262.
Yaru vakala takilla.
Union of India. Union.
Yaru? Learned counsel Timmanna Bhatt.
R1.
Learned counsel Timmanna Bhatt submits that is entered appearance for
R1 lodge.
R1. Registry to print the name of so and so. Less the matter on 16th.
163,
You're in possession.
Yes, I'm in possession. I produced the photographs. Annex D.
Photograph possession agala document idya.
I'm in possession. I'm in possession.
Yeah, KDB na.
Ella, National
Highway.
Authorities. Highway number 169.
1-2. Shobh, 1-2 Sudarshan Suresh accepts notice. 3-4 AGA. The petitioner, if in possession as on today, the possession shall not be disturbed till the next date of hearing, 9th September. Petitioner to serve set of papers upon the aforesaid counsel.
164,
My lord, my property has been acquired by the
Compensation.
compensation.
Learned HCGP accepts notice for respondents 1-3. Learned counsel Srimati HR Renuka is directed to accept notice for the 4th respondent. List the matter on 9th.
165,
Learned counsel PV Chandrasekhar covered. PV Chandrasekhar accepts notice for the respondent
2 and 3.
2 and 3. 1 HCGP. 1 HCGP. 16th
Please.
compensation.
Compensation, my lord.
16th.
It is covered because according to them, it is Karab land. Even then, my lord, dishonorable.
Ye kharab ha?
Please, and the RTC, my lord, it shows only 28 kuntas is Karab.
Right. Sorry. Next.
166,
Covered Nishant.
Please, my lords, annexure F, page 53. Preliminary notification, my lords, is 3/4/2006.
ಏನು ಮಾಡಿಲ್ವಾ
They have
ಆಮೇಲೆ?
not done anything. Endorsement, my lords, is at annexure E, page 52.
Heard the learned counsel Nishant AV appearing for the petitioner. Learned counsel for the petitioner submits that the issue in the list stands completely covered by what is rendered by the coordinate bench in terms of page so and so. We'll stay it now. Amala, we'll close it next time.
Please.
The learned counsel.
I'm not short
Muda.
for Muda, my lords. I'm not short for any
ಏನಿಲ್ವಾ
interim.
ಅಂದ್ರೆ ಸರ್ವ್ ಮಾಡ್ಬಿಡಿ ವಿಲ್ ಕ್ಲೋಸ್ ಇಟ್
Please.
ನೆಕ್ಸ್ಟ್ ಟೈಮ್. ಲಿಸ್ಟ್ ದ ಮ್ಯಾಟರ್ ಆನ್ 2nd September. 1 AGA 2 and 3 TP ಇನ್ನೊಬ್ಬರು ಇದ್ದಾರೆ. TP Vivekanand. Yes. Petitioner to serve set of papers upon the aforesaid counsel. Next week we'll close. Next. Yes. Allotment.
Mandamus, my lord, in spite of the order passed by this honorable court to consider my representation, see, they have colluded with the brokers and they have alienated all my properties.
ಆಡಪ್ರಭು ಕೆಂಪೇಗೌಡ ತಾನೆ ಒಂದ್ ನಿಮಿಷ ತಾಳಿ. You what so many respondents are there?
So, ಏನಕ್ಕಂದ್ರೆ see my property which are reserved for my.
ಆಯ್ತು ಈಗ ಫಸ್ಟ್ ಸರ್ವ್ ಮಾಡಿ ಬೇರೆಯವ್ರು ನೋಡೋಣ. 1 to 5 learned AGA ನಾ HCGP ನಾ? ಅದ್ ನೀವು ಅದು ಗೊತ್ತು, ನೀವು ಯಾರು ಡಿಸ್ಟ್ರಿಬ್ಯೂಟ್ ಮಾಡ್ಕೊಂಡಿದ್ದೀರಾ? Learned AGA accepts notice for respondents 1 to 5. List on 9th September.
168,
Nice matter.
Nice matter covered by discussion.
Learned counsel Ravindra V. Reddy accepts notice for the respondents 1, first respondent. Board ge.
Vasant is, they served the copy to Vasant.
Vasant.
It's been served, my lord.
Counsel Vasant accepts notice for respondents 2 and 3. Nitin Prasad for the 4th respondent. Covered. Yes, Devadas or order.
Yours, my lord.
Page 64.
64, my lord.
List on 2nd. Close it on that. Next.
169,
Not to allot.
My lords, the reason is this, my lords. I am the owner of the property. I have not received the compensation. 24 sites, my lords, I am entitled for.
You know, as compensation.
As 24, 30, 40 sites I am entitled for.
ಯಾವ ಲೇಔಟ್ ಇದು?
This is Nadaprabhu Kempegowda layout.
In terms of the division bench judgment.
There is a circular, my lords, which is issued by BDA at Annexure K, page 146.
The learned counsel Ajay Kumar M is directed to accept notice for respondent BDA. ಇನ್ಯಾರಿದ್ದಾರೆ ನಿಶಾಂತ್?
That's
BDA ಅಷ್ಟೇನಾ?
BDA, my lords.
BDA for all the respondents, petitioner to serve set of papers upon the aforesaid counsel. Status quo, the allotment be maintained till the next date of hearing.
Please.
Status quo ಸಾಕಾ?
With respect to the sites, my lords, which are.
Entry ಮಾಡ್ರಿ ಏನ್ ಕೇಳಿದ್ದೀರಾ?
Please, my lords.
The respondent BDA shall not precipitate the
Site numbers.
sites mentioned in the prayer till the next date of hearing.
Please.
List on 9th September. ಇವತ್ತೇ ಸರ್ವ್ ಮಾಡಿ. Yes. ಸಿದ್ದರಾಮಯ್ಯ ಅಪೀಲ್ ಫೈಲ್ ಮಾಡ್ಬೋದಲ್ವಾ?
ಮಾಡಬಹುದು, but only technical error, my lord, multiplier 2 needs to be applied. For enhancement of compensation, but determination of enhancement of compensation appeal ಹಾಕ್ಬೇಕು. It's only a technical error, my lord, for the very same survey number, 2 multiplier is applied. And
Government is the answer.
Government.
3 and 4.
3 and 4 answer in this.
Learned AGA
Connected case.
is directed to accept notice for the respondents.
3 and 4.
3 and 4. ಶುಕ್ರವಾರ ಡಿಸ್ಪೋಸ್ ಮಾಡ್ಬೋದಾ?
ಮಾಡಬಹುದು. 2 is national highway.
2 ಯಾರು? Sudarshan Suresh is directed to accept notice for the second respondent petitioner to serve set of papers upon the aforesaid counsel. Then we'll take it on 29th.
Connected cases, my lord.
ಕೊಡಿ.
363.
Copy serve ಮಾಡಿ. List tag the petition along with so and so list on 29th.
363 also.
363.
ಇದ್ರದೆ.
ಆಯ್ತು ನೋಡೋಣ. Yes.
All are connected, my lord.
ಅದ್ ಬಂದಾಗ ಹೇಳಿ. Next.
171.
Yeah, for the.
You are in possession, Rajesh?
Yes, ma'am. Only in June 2025, they issue a notice to me, my lord.
ಆಯ್ತು ಒಂದು ನಿಮಿಷ.
Okay, IDB.
ಅದು ಯಾರು?
HL Pradeep Kumar. HL Pradeep.
Counsel HL Pradeep Kumar accepts notice for respondent 2, 3, 4. AGA 1. The petitioner, if in possession as on today, such possession shall not be disturbed till the next date of hearing. List on 16th September. Objections, if any, by then.
172.
Appeal dismissed for non.
Pre-deposit 7.5%.
Please, my lords, I have made deposit even otherwise.
100 back, my lords.
Now that they have paid the pre-deposit. Even otherwise, it's covered under Chinmaya Seva Trust, my lords.
Correct. Eಲ್ಲಿ ಇದೆ ಕೊಡಿ.
26 years.
Page. Where is the file?
File is here.
Yes.
File is here. I'll supply.
Chinmaya Seva Trust number ಇದೆಯಲ್ಲ ಕೊಡಿ.
1154 of 23.
Same. The learned counsel for the petitioner submits the issue in the list and is answered by 1115 of 2023 disposed.
4, my lords. 1154 of 23.
2023. Same order. ಯಾವುದು ಇನ್ನೊಂದ್ರಲ್ಲಿ ಇದೆ covered by Chinmaya ಅಂತ ಇನ್ನೊಂದಿದೆ. Anyway, yes. Input tax credit.
My lords, this is
I appear for respondent, my lord.
107 order, my lords. No tribunals there, my lords. I'll deposit
10%.
Please, my lords, I'll do that. My bank account is frozen, my lords. They may be directed to deep.
Yes, Jyoti madam.
Yes, my lord.
Bank account frozen. 10% deposit.
Yes, my lord. Maybe
there will be an interim order subject to 10% deposit.
Of the tax amount, my lords. Of the tax amount.
Of the tax amount, of course.
Obliged.
Yes. ಅದು ಸೇಮ್ ಆರ್ಡರ್ಸ್ ಮಾಡಿದೀವಲ್ಲ.
174.
ನೋಟಿಸ್.
Seeking only for.
ಏನೋ ಟೈಮ್ ಕೇಳಿದ್ರಲ್ಲ ಬೆಳಗ್ಗೆ. ಟೈಮ್ ಕೇಳ್ಬಿಟ್ಟು ಇವಾಗ ರೆಡಿ ಆಗ್ಬಿಟ್ಟಿದ್ದೀರಾ?
Installment ಮಾತ್ರ.
I'll take notice,
Two
my lord.
vehicles tax demand is there.
Learned HCGP accepts notice for the respondent. List on 20.
Next month first week.
ಅಯ್ಯೋ ನೀವು ಡಿಸೈಡ್ ಮಾಡಬೇಡಿ. ವೇಟ್ ಡೇಟ್ ನೋಡ್ತಾ ಇದ್ದೀನಿ. 11th September.
Please.
175.
Ozone. Annamalai. You have come out of the VC.
Yes, my lord.
Page number.
Page number, my lord, 179, my lord.
Same order.
Same order, my lord.
179.
Earlier year, my lord. 179.
Same 179 ಏನ್ ಆರ್ಡರ್ ಇದೆ ಅದು? Next. Entry ಮಾಡ್ರೆ ತಾನೇ ಅದು?
Yes, my lord.
Yes, next.
For R3, I take notice.
ಶಿವಯೋಗಿ ಸ್ವಾಮಿ ಸರ್, ಮೊನ್ನೆ ಡಿಸ್ಪೋಸ್ ಮಾಡಿದ್ವಲ್ಲ?
They sought to recover the ITC, my lord. On the ground, my lord, I have purchased the goods from the seller, my lord.
ಆಯ್ತು. Land Counsel M. Dilip accepts notice for respondents.
Manoj, in 175 for R3, Manoj.
175 ದಿಲೀಪ್ ಸಾರಿ ಅದು ಏನಾಗಿದೆ ಅದು 176
That's 176.
176 ಜ್ಯೋತಿ ಮೇಡಮ್
I will take notice, my lord.
Leonard HCGP why all
My
of you
lord,
are on VC
tribunal not yet formed, my lord, in this case also.
10%
Yes, my lord.
10% ಆರ್ಡರ್ ಬೇಡವಾ
I already paid 10% before the appellate.
10% ನಾನು ಎಲ್ಲದರಲ್ಲೂ ಅದೇ ಎಂಟ್ರಿ ಮಾಡ್ರೆ ಕೊಡ್ತಾ ಇರೋದು
ಅಲ್ಲ appellate authority ಕಟ್ಟಿದ್ದೀನಿ ಸ್ವಾಮಿ ಆಗಲೇ.
ಅಲ್ಲಿ
ಅಲ್ಲ
stay ಬೇಡ
extra before this honorable court.
ಇಲ್ಲಿಗೆ ಎಕ್ಸ್ಟ್ರಾ ಬೇಕಲ್ಲ 10% ಸೇಮ್ ಮಾಡಿ 10% ಆರ್ಡರ್ ನೆಕ್ಸ್ಟ್
177.
ಇಂಟರ್ಮೀಡಿಯರಿ ಸರ್ವಿಸ್ ಎಲ್ಲಿದೆ
That's covered by, in my own
Covered.
case, my own case, there's an order of this honorable court. Granting stay, page 185. In an earlier writ petition, similar matters covered by different orders.
1 minute
185.
ಯಾವುದು ಜೀವನ್ ನೀವಿದ್ದೀರಾ
Mr. Jeevan.
Learned Counsel Jeevan Neralge accepts notice for the respondent. Central tax.
Yes.
So and so registered to print the name of so and so. Which page?
185 minutes. Final order is there. Number of final orders are there.
Final order enter ಮಾಡ್ರಾ?
This is an interim order in my own case for an earlier period.
Your own case.
There are final orders of this honorable court. 5-6 orders.
Yes. The Learned Counsel appearing for the petitioner submits that prior to disposal of the case at page 185, there was an interim order operating in the favor of the petitioner. In that light, there shall be an interim order as was granted at the time of admission of the aforesaid case till the next date of hearing. List the matter on 11th September.
178.
Single
Same,
single
10%.
notice has been issued.
Same.
Covered by decision of this honorable.
ಕುಡಿ ಜೀವನ್ ನೀವಿದ್ದೀರಾ
ಪೆಂಡಿಂಗ್ ಇದೆ ಸ್ವಾಮಿ.
ಯಾವುದು
ಕನ್ಸಾಲಿಡೇಟೆಡ್ ಶೋ ಕಾಸ್ ನೋಟಿಸ್.
ಅಯ್ಯೋ ಅದು ಪರವಾಗಿಲ್ಲ ಬಿಡಿ ಎಲ್ಲ ಡಿಸ್ಪೋಸ್ ಮಾಡ್ತಾನೆ ಇದೀವಿ.
Covered by decision.
Petitioner is before this court seeking the following prayer. The Learned Counsel appearing for the petitioner submits the issue in the list stands covered by the judgment rendered by the coordinate bench, which is not disputed by the Learned Counsel appearing for the revenue, but would submit that the matter is pending before the division bench. There is no stay granted by the division bench of the order quoted. So the order in writ petition so and so. The coordinate bench has held as follows. In the light of the issue being identical and no stay in the division bench, the interim order, so the petition deserves to succeed on the same lines. Hello. Next.
179.
Annamale. Same page.
Here the petitioner challenged the jurisdiction of the DCGA to issue notice. My lord, similar issues are pending before the
ಅದನ್ನೇ ಕೇಳಿದ್ದು ಪೇಜ್.
Yes, my lord. 516 to 517, my lord.
516 3 volumes ಇದೆ ಇದರಲ್ಲಿ ಕರೆಕ್ಟ್. Page 516 same order. Akash to take notice. Full name in Akash?
My lord, for Union of India, Madan P. Shetty.
Akash P. Shetty. Learner AG na HGP na? Oh, Akash P. Shetty is directed to accept notice. Sorry. Yes, next. 180. Covered,
Appearing for the petitioners, my lord. Lord, on 10/10/2024, the goods were detained at 7:30. The e-way bill was generated on 10:30.
1:30.
My lord, I will
We'll
take.
continue to 2:30.
My lords, may I make a submission?
My lords, in the previous matter, sir.
My lord, law and order
If
issues
you
involved.
law and
One
order,
matter for- Yes, my lord.
ಏನ್ law and order sir?
My lords.
GM police ಹಾಕಿ sir.
ಇಲ್ಲ GM police ಅಲ್ಲ. Your lordship. IA has been rejected before the trial.
ಅದಕ್ಕೆ law and order ಯಾಕಾಗುತ್ತೆ sir?
Your lordship, religious construction is being carried out in an apartment premises. Lordship,
Tomorrow.
Great.
I am hungry.
ಮೇಡಮ್ ಅವರೇ 155 ಅಲ್ಲಿ
ಮೇಡಮ್ ಲಂಚ್ ಆದ್ಮೇಲೆ ಎಷ್ಟು ತಗೊಂಡ್ರೆ
ಡೇಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ ನೋಡಿ.
33 ಬರ್ತಾ ಇಲ್ವಾ ಆಮೇಲೆ ನೋಡ್ಬಿಡಿ. ಅದು ಮಧ್ಯದಲ್ಲಿ 2 ಆಯ್ತಲ್ಲ ಅಲ್ಲ ಅದೇ ಆರ್ಡರ್ಸ್ ಅಲ್ಲಿ ಮತ್ತೆ ಹೌದು 31 ಇಲ್ಲ 32 33 ಕರೆಕ್ಟ್ ಆಗಿ ಅನ್ಸುತ್ತೆ ನೋಡ್ ಹೇಳ 15 19 20 23 24 29 30 36 41 49 52 59 62 63 77 84 88 78 84 88 92 94 95 103 110 120 121 142 152 153 159 172 178 ಆಮೇಲೆ 253 265 ಪಾಸ್ವರ್ಡ್ ಯಾವ್ದಿಲ್ಲ ತಾನೆ
Yes, sir. Serial number? Withdraw ಮಾಡ್ತೀರಾ? Yes, sir.
Able to file fresh and also we kindly make an order written up board now.
GMCPC na?
Yes.
In term memo ಹೇಳಿದ್ದೀರಾ ಅದು? In terms of the memo.
Lordship kindly. A fresh matter will not, the school premises are being carried out and my lord, now on the strength of the cancellation of the CSI.
ನಾಳೆನೆ.
So great. BDA matter.
FR number?
ಇಲ್ಲ ನಂಬರ್ ಆಗಿದೆ.
WP.
BDA. So grateful.
Announcement ಆಗಿದೆ. ಮುಗಿಬೇಕಲ್ಲ. ಮುಗ್ದಿದೆಯಲ್ಲ ಎಷ್ಟು? ಅಲ್ಲ ಒಂದು ನಿಮಿಷ ಮೇಡಮ್.
My lords, with your permission, may I mention serial number 5 in list number 2? Your lordships had heard this matter and reserved it for orders on Thursday.
Which one? One moment, sir. One moment. List number 2.
Serial number 5, your lordship.
Madam, list
On
2.
Thursday, your lordships might recollect the learned ASG
One moment. Just give me one moment. GMRES. I had not reserved it.
My lords, this is that matter where a compounding notice was issued 12 years later, and there was
No. I had not reserved it. I posted it for dictating orders. If it's possible to dictate, I'll dictate today.
Oblige.
That was never shown as reserved. Yes.
Oblige.
Yes. Pronouncement.
List number 3, pronouncement of order.
We'll just read the summary of findings. The POCSO Act, being a progressive enactment, is intended to safeguard the sanctity of childhood. It is rooted in general neutrality, with its beneficent object being the protection of all children, irrespective of sex. The Act is thus gender neutral. Sections 3 and 5, which form the foundation of the offences under Section 4 and 6 of the Act, delineate various forms of assault. Although certain provisions may employ gendered pronouns, the preamble and the purpose of the Act render such usage inclusive. Therefore, it is inclusive of both male and female. The ingredients of Section 4 of the Act dealing with penetrative sexual assault are equally applicable to both men and women. The language of the provision clearly indicates inclusivity. The ingredients of the offences, the ones punishable under Section 4 and 6 of the Act, are clearly met in the case at hand, albeit prima facie. Delay in registration of the crime in the case at hand cannot become a reason for quashment of the proceedings owing to the alleged offence and the age of the victim. The submissions of psychological impossibility and absence of potency testing fall flat in the light of modern jurisprudence noted herein above. The submission that psychological trauma cannot result in so and so would tumble down in the light of several studies that psychological trauma does not always prelude physiological or biological reactions, especially ones in coercion and fear. The submission that in so and so the woman is only a passive participant and the man is an active participant, it is noted, only to be emphatically rejected, as the thought itself is archaic. The jurisprudence of present times embraces livid realities of victims and does not allow stereotypes to cloud legal scrutiny. Therefore, none of the submissions made by the learned senior counsel merit any acceptance, wherefore finding no merit in the petition stands rejected. It is made clear that the observations made in the course of the order are only for the purpose of consideration of the case of the petitioner under 482 of the CRPC and does not bind or influence the proceedings pending before the petitioner, pending against the petitioner before the concerned court. It will be uploaded now in half an hour.
Grateful.
List 1 continued. 180.
Yes, sir.
On importation, the customs duty was paid, not the IGST was also paid. On 10/10, the goods were being transported from the customs station in Bangalore to the premises of the importer. But on the goods, the verification happened on the way at 6:30 a.m., stating that the document had been produced by the driver. Driver produces the invoice.
287.
Driver produces the bill of entry.
Will issue notice.
I'll take notice.
The learned HCGP accepts notice for the all respondents. All respondents, accepts notice for both the respondents.
Both.
List the matter on 11th September. That day, we'll see. Yes.
Bank guarantee has been issued in this case, and also surety is also been.
Bank guarantee and surety is already there. The learned counsel for the petitioner submits bank guarantee and surety, both of which are placed before the concerned authority. In the light of the said statement, further proceedings shall remain stayed.
181.
Covered.
Orders are produced at pages 250.
Heard the learned senior counsel Vikram Hooligold appearing for the petitioner. Yaar idu respondent? Jeevan. Neralgi sir. Learned counsel Jeevan Neralgi accepts notice for respondent's petitioner to serve set of papers upon the aforesaid counsel registry to print the name of Jeevan Neralgi as appearing for the respondent. We'll close it on the next date. List on 4th September. Intermodal Becca. In the light of the issue standing covered by plethora of judgments rendered by the coordinate benches of this court as well as the apex court and coordinate benches of this court, there shall be an interim order of stay of further proceedings. Yes, next.
182.
Apex court ilva? I the coordinate benches of this court.
First and second respondent, your lordships. My name is not shown.
Why 180?
I have filed my appearance, but the name is not shown, your lordships.
Income tax matter.
Iವ್ರು ಯಾರು? Who is the counsel representative? Your counsel.
I am the counsel for respondent 1 and 2.
Respondent to one. Counsel so and so undertakes to enter appearance for response. Sarojini Mutana, madam.
Yes, your lordships.
Yes, yes. So and so accepts notice for respondents 1 and 2. Arvind Chavan for
3 to 5.
4 and
3 to 5.
3 to 5. Registry to print the name of so and so. List the matter on 4th. 4th or 11th?
11th.
11th. We'll close it on that day.
Please.
183.
ಈಗ ಒಂದು ಕೊಟ್ನಲ್ಲ ಯಾವ್ದದು? ಸೇಮ್ ಆರ್ಡರ್. ಜೀವನ್ ನೆರಳಿಗೆ ಆಕ್ಸೆಪ್ಟ್ಸ್ ನೋಟಿಸ್ ಸೀರಿಯಲ್ ನಂಬರ್ 177 ಏನು ಆರ್ಡರ್ ಮಾಡಿದ್ದೀನಿ ಅದು. ಎಸ್. ನೆಕ್ಸ್ಟ್
184.
184. Faceless.
Issue is there, but first principle, second paragraph. I am entitled to spend up to 27% on PF. That comes to 2 crore 90 lakhs. I have spent 1.7 crores. They still say that
Learned Counsel M. Tirmalesh accepts notice for respondent registry to print the name of so and so. He lists the matter on 11th September. For the Learned Counsel appearing for the petitioner submits that what triggered the proceedings against the petitioner is usage of provident fund amount. According to the Learned Counsel, 2 crores is a maximum limit that can be spent, and the petitioner has spent only 1.7 crores. Therefore, the respondents did not have jurisdiction even to initiate proceedings against the petitioner. Apart from the Learned Counsel would submit that these submissions are inter-alia. In that light, there shall be an interim order of stay of further proceedings. Further proceedings -A in terms of annexure A, A1, A2 till the next date of hearing, 11th September.
185.
Lordship, appearing for the petitioner, 185, 186, 188 and 192 go together.
All same. Yes.
Yes, Lordship. There is some development. We've challenged the notice. Meanwhile, they've passed an order dropping the proceedings, Lordship, in all these.
Very good developments. Yes.
Yes, Lordship.
The petitioner is before this court seeking the following prayer. The Learned Counsel appearing for the petitioner in all these cases submits that submits that the revenue has dropped the proceedings against the petitioner. In the light of the said dropping of the proceedings, these petitions are rendered infructuous. They are to be disposed as having become infructuous, reserving liberty to the petitioner to knock at the doors of the appropriate fora in the event of need in future. With the aforesaid observations, the petition stands disposed. Same order. Yes, next.
187.
My lord, I am appearing for the petitioner online. My friends are in court. My lord, here, my lord, this is a petition filed by, my lord, somebody who's called Federation of State Medical Boards in USA. My lord, these are petitions which deal with a particular provision, my lord, where similar petitions are pending. At least 3 of them are pending and interim orders have been granted by your lordship. My lord, I'm just passing that on.
Numbers.
Yes, the writ petition number, the first one is 27091 of 2024.
Citations as well.
Sorry. Learned Counsel, the Learned Senior Counsel?
Yes.
Learned Senior Counsel appearing for the petitioner so and so. The Learned Senior Counsel would submit that identical issues are raised in several petitions and interim orders are granted on the score that on the ground that the proceedings instituted are beyond limitation and in violation of principles of natural justice. 74 proceedings.
Also, my lord, without jurisdiction, because, my lord, we are outside India and they don't.
And also the fact that and also the fact of lack of jurisdiction.
Yes, my lord.
In the light of the said circumstance, Jeevan sir, Niva.
DGGI is there, my lord. I take notice.
Learned Counsel Jeevan Neralgi is directed to accept notice for
1 and 3.
1 and 3.
1, 3, 4.
134, registry to print the name of so and so, Union of India. The Shanti Bhushan is directed to accept notice for respondent Union of India. Registry to print the name of so and so is appearing for Union of India. In the light of the interim order subsisting in companion petitions, there shall be an interim order of stay as is obtaining in those petitions till the next date of hearing. Now, numbers yavudu idera? Yavudu? Page? First page?
Yes, my lord. First page onwards, my lord, there are 3 petitions we put on.
All right. Yes, madam. Idರಲ್ಲಿ ಫಸ್ಟ್ ಪೇಜ್ ಇಂದ ಒಂದು 3-4 ಇದೆ ಟ್ಯಾಗ್ ಮಾಡಿ ಸೇಮ್ ಆರ್ಡರ್ ಮಾಡಿ. Yes, next.
Obliged.
Yes.
Deeply
Next.
obliged.
189.
Based on consolidated total world by substance in annexes E to G.
181 ಅಲ್ಲಿ ಏನು ಆರ್ಡರ್ ಕೊಟ್ಟೆ ಅದು ಪೇಜಸ್ annexures and there shall be an interim order of stay for the proceedings pursuant to annexures E to G. Learned Counsel Jeevan Neralgi is directed to accept notice for the respondent same order. Yes, next. Registry to print the name of. Yes, next.
190.
Appeal rejected due to delay.
This is regarding the Chinmaya Seva Trust.
Page, the petitioner is before this court seeking the following prayer. Heard so and so. The learned counsel appearing for the petitioner submits that the issue in the list stands covered by the judgment rendered by the coordinate bench, page 108. In the case of so and so, the coordinate bench is held as follows. Madam, page 158 in the end orgu hakbidi, order end orgu, so and so. The learned counsel appearing for the respondent would not dispute the position that the present petition is identical to the one that is decided by the coordinate bench. In that light, the petition deserves to succeed on the same lines with the same relief that is granted therein. Adu quote marbidi matte operative portion same order. Yes. Yes.
191.
I appear for the petition condemnation of delay.
Yes.
Your Lordship,
Rejected.
YV Raviraj and Dilip will take notice, my lord.
Learned counsel YV Raviraj and Dilip.
Dilip, my lord.
Ibru.
Ibru, is it because senior and junior both are.
Learned counsel YV Raviraj is directed to accept notice for the respondent. List on 11th. Petition copy serve ಮಾಡಿ ಅವ್ರಿಗೆ.
193.
Next to same appeal delay.
I'm appearing for petitioner, my lords. It's delay, my lords, in filing
Delay,
appeal under
yes.
section.
Learned income tax.
I will take.
Commercial. Commercial.
Yes, my lord. They approached first appellate authority.
Oh, correct. Learned HCGP is directed to accept notice for the respondents 11th September.
Yes. My lords, sought for interim stay, my lords.
Interim
in
stay.
identical matters are allowed, my lords, because 41 lakh is the demand and it's only a penalty portion, my lords. The tax liability was discharged even at the time of original order.
But 11th bed agadre. We'll list it on 4th September. Yes, list on 4th September. Avat koduva.
Grateful, my lords.
194.
Your Lordship, I will take notice for the respondents, my lord.
Oh, 192 ಆಯ್ತಲ್ಲ. 193 ಏನಾಯ್ತು ಇದು ಆಗಿದ್ದು ಅದೇನಾ ಈಗ? ಏನ್ ಫೇಸ್ಲೆಸ್?
I will take notice, my lord, for respondents.
Learned counsel EI Sanmati accepts notice for the respondent registry to print the name of so and so is appearing for the petitioner. 148 proceeding covered kude. Learned counsel for the petitioner submits that the issue in the list stands answered. Interim order. Issue in the list. Madam. The learned counsel for the petitioner submits that in identical cases coordinate benches have granted an interim order of stay which reads as follows. Quote that order. In the light of the order passed by the coordinate bench, the petitioner is entitled to the same relief that is granted therein. There shall be an interim order as prayed for. As prayed for.
Please.
Yes. Next.
195.
Which interim order? Which interim order? Earlier.
C, my lord. Annexure B, my lord.
Page.
Showcase matter at page number 43, my lord.
ಯಾವ್ದೋ orders on interim prayer. Same order.
No, my lord. This was that matter pertaining to that Arakanat, my lord.
Oh, Arakanat.
Sovereignty release.
Yes, sir.
Our name was not showing on this
Oh,
matter.
yes. What's your name, sir?
Unni Krishna name, sir.
Notice order madilva. The
Unni Krishna name.
Learned Counsel M. Munni Krishnan is directed to accept notice for the respondent. Registry to print the name of Unni Krishnan is appearing for the respondent. This is a perishable commodity. List tomorrow and preliminary hearing. Get Unni Krishnan. Ella Areka netta. Kodi ella Areka onde kade hakbidi. Yes. List tomorrow. Tomorrow is madam. Tomorrow antane. Hmm? 20th. 20th will take together.
196.
Chinmaya Seva.
I take notice.
Covered. Learned Counsel Jeevan Neralgi accepts notice for the respondent. Registry to print the name of so and so. Petitioner is before this court seeking the following prayer. The Learned Counsel appearing for the petitioner submits that the issue in the list stands covered on all its force FOURS to the judgment rendered by the coordinate bench in the case of Avagle held madam. Illa ide, illu ide. Page 1. Annexure C, C1, Allah, C1. 47. Oh,
Page 47.
reported, all right. The so and so judgment reported in 2024-25 Syntax 382, wherein the coordinate bench has held as follows. Para 3 in the page 47 to 51, 48 to 51. The Learned Counsel Jeevan Neralgi would not dispute the position of law as is laid down by the coordinate bench. In that light, the petition deserves to succeed with the same relief and reason, relief so granted by the coordinate bench supra. As order copy paste, madam. Order portion no copy paste. Yes. Yes. Next.
197.
My lord, in this case, my lord, this honorable court doesn't have a jurisdiction, my lord.
This court doesn't have jurisdiction.
Yes, my lord.
Ayyo,
We
yake
have
madam?
just issued a notice, bogus ITC. Instead of approaching, filing a reply, they directly approach this honorable.
Yake without jurisdiction na?
Page 28, it's an order of disallowing ITC.
It's a bogus ITC, my lord.
Bogus ITC?
Yes, my lord.
When a disallowing of such sort is being made, it is a judgment of this honorable court. at
Page 30 onwards.
That they should give me a notice, which they have not given.
We have
Pass this
issued
order.
the notice, my lord. If at all they want, again, let them directed us to, we'll give one more
This
opportunity.
order should go.
We'll allow hearing.
Allowed.
No, my lord, hearing.
Coordinate bench. Blocking of input tax credit.
My lord, that is what opportunity, my lord.
So
Hearing.
that is what opportunity. The K9 judgment, madam.
No, we will provide, my lord. We have issued the notice.
If you provide, how can this sustain? There is order passed already. Is it not covered by page 30? Nodilva papers. Kotilva? Bharat. Same allu ashte. Liberty is reserved in favor. Proceed against the petition in accordance with law in terms of K9. That's all. That is the order.
May be remanded back and petitioner, the respondent may be given liberty to.
Concern to unblock the credit ledger and enable to petitioner to file returns forthwith. Liberty is reserved. Same thing. Same order. Petitioner is before this court seeking the following prayer. The Learned Counsel for the petitioner places reliance upon the judgment rendered by the coordinate bench in page 30, wherein the coordinate bench has held as follows. Para 5 to end. The Learned Counsel for the petitioner, counsel for the respondent would not dispute the position of law as is laid down by the coordinate bench, but would only submit that they would liberty be reserved to them to initiate fresh proceedings. This is exactly what the coordinate bench is also reserved. In that light, the petition deserves to succeed. Same order, operative portion. Yes.
200, serial number 200 also same.
200 also same. Yes. 201. Order beyond 198. 79 GST.
One jurisdictional issue here involved in others. Now, there is section 65 provides for audit. My account is subjected to audit. Now, the audit
Tribunal is not functioning. Ada idu.
But even otherwise, there is jurisdictional issue. Now, because there is a similar matter.
Kodi.
Only issue is this, whether the audit officer should forward it to another officer before 773 proceedings or do it himself. The risk of doing it himself, there's already a predetermined mind. Next page. The order dated 24th February.
Yes, Jyoti madam.
I've come after order.
Learned HCGP is directed. Writ appeal is pending.
No, issue is pending before the
issue is pending.
Yes,
We will answer the issue, no problem. Yes. The heard the learned senior counsel Vikram Hooligold appearing for the petitioner. The learned senior counsel would submit that in identical matters, the coordinate bench has granted an interim order which read interim order in writ petition so and so. The interim order so granted reads as follows. In that light, the learned HCGP accepts notice for the respondent. There shall be an interim order as is granted by the coordinate bench in the case at hand as well.
That order, the petitioner approached this honorable court at show cause notice. Now,
Till order agidiyalla.
And our bank account is processed.
Allah, in that light, in the light of the interim order subsisting in the companion petition, though the said petition was calling in question only a show cause notice and the order being passed in the case at hand, but the order is passed in the case at hand, nonetheless, the grounds urged in the petition are identical to what is urged in the subject petition. Therefore, there shall be an interim order as prayed for in the subject petition. Yes, next.
199 same.
Huh?
99 same.
Same 199 same. Same. Yes.
201.
Who appears? Commercial tax.
Yes, ma'am.
1 and 2 where government alva. 1 and 2 HCGP. 3, 4, 5 GSTR. Given Learned Counsel. Arvind. Learned Counsel Arvind Chavan is directed to accept notice for the respondents 2, 3, 3, 4 and 5. Registered to print the name of so and so. Order beyond 36/2024.
It's covered by the Honorable Court, Madras
Yes.
High Court judgment, my lord.
Correct. That
Because
is
they are disputing court alali matra serve agide, otherwise they are not served.
even this court page 71. Covered by 71 also. That follows Madras High Court. Yen maad entry madkodna dispose maad.
Allah
Next week maad. List the
List
the matter on 4th. There shall be an interim order as spread for till the next date of hearing. Yes.
202.
This matter, right?
Finance Act.
Chinmaya Seva Trust.
Chinmaya, same. Page. Chinmaya ellide page. Interim order I will dispose it. Innೊಂದು Chinmaya ಯಾವ್ದೋ ಮಾಡಿದ್ವಲ್ಲ madam.
Page 74.
ಅಲ್ಲ ಇನ್ನೊಂದು ಮ್ಯಾಟರ್ ಯಾವ್ದೋ ಮಾಡಿದ್ವಿ. that is page 196. 196 ಅಲ್ಲಿ ಏನ್ ಮಾಡಿದೀನಿ ಅದೇನೆ ಸೇಮ್. ಅದು ಬಂದ
Admission. 203.
Earlier proceedings that the very same plaintiffs filed this suit.
Petitioner to serve on the counsel who represents the respondent in the trial proceedings and file an acknowledgement of such service. List the matter on 12th September. There shall be an interim order of stay of further proceedings before the concerned court. Next.
204.
Lord, appear for the petitioner. Lord, the
Suit is for what?
Lord, suit is for claiming partition and setting aside sale deed.
There are no 711, sir.
Lord, my humble submission also this property, she herself has sold it in 2011.
No problem.
Lord, kindly bear with me, Lord.
711 in partition, no.
Lord, on the ground, Lord, she has sold the property herself. She admits in the plaint. There is no property available in the family for them to effect partition, Lord. And Article 15, it is directly hit. She admits selling the property.
No problem, sir.
Her father sold in 91. She challenges that sale deed as null and void, which she had no right. Lord, that's a matter which requires to be considered by your lordships, Lord. The Hibbins case has been also
notice to the respondents.
I shall take. Please.
No date.
205.
Not at all.
Another CRP, this is a revision fiction by the respondent, defendant number 3 and 12. Defendant number 23 filed a CRP.
Kodi, tag this petition along with so and so CRP, list them both on 12th September. No, sir. ಇರ್ಲಿ ಬಿಡಿ ಅದ್ರಲ್ಲಿ ಇದೆಯಲ್ಲ ಇನ್ನೊಂದು ಡಿಫೆಂಡೆಂಟ್ ಆಗಿ ನಿಮಗೆ ಹಾಕ್ಬೇಕು.
206.
Suit for what? The petitioner shall serve on the counsel who represents the respondent in the trial proceedings list on 12 till such time further proceedings before the concerned court shall remain stayed. What dispensation? Counsel for the petitioner file synopsis. In disposal, entry madugo synopsis beka. The counsel for the petitioner files a memo seeking dispensation of issuance of notice to respondents 4 to 7 at the risk of the petitioner. In terms of the memo, issuance of notice stands dispensed with. Petitioner shall serve on the counsel who represents defendants 1 to 3 before the concerned court and file an acknowledgement of such service list on 12 till such time further proceedings shall remain stayed. Next.
207.
Suit for injunction. Why 711? Serve on so and so list on 4th September. The 5th Raja madam. Yes, next.
208.
Suit for partition. Petition of the purchaser.
ಅಲ್ಲ ಪಕ್ಕ ಅಕ್ಕಪಕ್ಕ ಯಾರಿಲ್ವಲ್ಲ ಇವರೇನಾ?
ಇಲ್ಲ ಇದು ಫ್ರೆಶ್ ಮ್ಯಾಟರ್.
ನಿಮ್ಮ ಅಡ್ವೊಕೇಟ್ ರೆಕಾರ್ಡ್ ಯಾರು? ಇದ್ದಾರೆ. ಅವ್ರ ರೆಸ್ಪಾಂಡೆಂಟ್ ತರ ಈ ಕಡೆ ನಿಂತ್ಕೊಂಡ್ರೆ ಆಮೇಲೆ ಕಷ್ಟ.
Suit for partition, my lord.
No 711.
No, the sale, my lord, my father bought it in 1991. Then, my lord, in my family, my lord, partition happened in 2001. My lord, the suit is filed in 2024. Lord, there was an earlier, Lord, registered partition. In the plaint, my lord, also they, Lord, admit that there was a Lord, registered partition in my family. And my lord, all this has happened before the amendment. Now, my lord, the daughter in 2024 for the first time, my lord, comes up, my lord, with this suit saying that this sale deed is not binding of 1991 is not binding on me.
Let us see. Yes. No stay. In fact, no entertainment only.
Because it is prior to amendment.
Partition, no. Yes. Anyway, heard the learned senior counsel Sri Ranga appearing for the petitioner. Emergent notice to the respondent. Next.
209.
Please, for the petition, the matter.
The petitioner shall serve on the counsel who represents the respondent in the trial proceedings and file an acknowledgement of such service, there shall be an interim order of stay of further proceedings before the concerned court. On the score that the plaintiff raises a challenge to acquisition of the year 1974, a case before the civil court which apparently does not, apparently suffers from want of jurisdiction. Yes, next.
210.
Petition title dispute.
The petitioner is before this court calling in question an order of the concerned court which rejects an application filed under Order 7, Rule 11 of the CPC. The present case is a classic illustration of a very clever drafting, as the law that does not permit a relief is sought to be granted, is sought to be taken at the hands of the concerned court. After 24 years of a particular instrument in OS 3206 of 2024, there shall be an interim order of stay of further proceedings before the concerned court till the next date.
Council notice.
Petitioner to serve on the counsel who represents the respondent in the trial proceedings. Next.
211.
With the respondent number 1, my lord. I filed my caveat.
Partition.
Please, my lord.
It's a partition, but let's kindly see the order 23 rule 3, my lords, because they are challenging earlier partition. There was a partition and it is compromised. That degree has challenged before the trial court.
This issue stands
any number
covered.
of preliminary decrees, any number of final decrees
For
in
a
a
moment, kindly
partition.
see 23 rule 3, my lords.
Or else,
My lord, this issue stands covered by a coordinate bench of this court. It is clearly told it is a representative suit. The
23
two
rule
conditions under Order 23 Rule 3B have not been complied. Leave of the court togondilla, notice issue madilla. So it becomes null and void, the earlier compromised decree.
yes, sir.
That's in the suit. They
No,
are challenging
sir.
the compromise decree.
It's covered by a reportable
You,
judgment.
ಆಯ್ತು madam, wait, ತಾಳಿ.
Verify and once.
What verify? Verify ಮಾಡ್ಕೊಂಡು ಬರ್ಬೇಕು courtಗೆ.
Cited before the trial court also,
Kindly
my
have it
lord.
on
In
tomorrow,
fact, it's
madam.
covered by a divisional
Kindly have it on tomorrow.
judgment
because
of
we
this
have
court.
ಆಯ್ತು, list on Thursday.
Please,
Yes.
ಕೊಡಿ.
As a last chance.
Please.
Yeah, dismiss.
ಇಲ್ಲ, ನೋಡ್ತೀನಿ.
711 ಬರಲ್ಲ.
ಇಲ್ಲ, in the
Covered by a
partition
divisional
ಅಯ್ಯೋ
bench.
ಮೇಡಮ್ ಆಯ್ತು. Yes.
ಡಿಗ್ರಿ ಚಾಲೆಂಜ್ ಮಾಡ್ತಿದ್ದಾರೆ. ಇನ್ನೊಂದ್ಸಲ ಇದು degree
ಆಯ್ತು,
ಇನ್ನೊಂದ್ challenge
711
ಮಾಡ್ತೀವಿ.
ಬರಲ್ಲ ಸರ್.
ಒಂದ್ಸಲ ನೋಡ್ಬಿಟ್ಟು.
ಇನ್ನೊಂದ್ 2 ಸರಿ ಹೇಳಕ್ ಹೇಳ ಅವ್ರಿಗೆ ಬೇಡ ತಾನೆ. ಸರಿ ಆಯ್ತು. Yes.
Please, ma'am. 212.
Petitioner, money recovery suit, 2013 check payment is sought to be recovered in 2023. 7 Rule 11 application is filed on limitation, my lords. There is no allegation of even one date of acknowledgement. The only next date which is pleaded is in notice.
That is your defense.
My lords,
711 no defense, only plaint government.
my lords, Article 20, check payment 3 years from the date of check.
This is a clearly mixed question.
My lords, it is admitted in the plaint. There is no other date pleaded at all.
NI Act proceedings ಏನಾಯ್ತು?
NI Act proceedings ಏನು ಮಾಡಿಲ್ಲ. ಅಲ್ಲ, check is issued in my favor. It is sought to be recovered now. No subsequent date is pleaded except the legal notice in 2022. They claim that there is acknowledgement, but no date is pleaded.
Notice. Yes.
213.
Appearing for the petitioner request for a time, my lords. I'm so sorry.
Request for time. Why, sir?
Sorry, my senior is.
The petitioner, what's your name?
My name is Dhruva. I'm appearing for Unikrishna name.
ನೋಡಿಲ್ವಾ ಫೈಲ್?
It's not there.
ಯಾರ್ದು?
Unikrishna name.
ಫೈಲ್ ಇಲ್ವಾ ಅಲ್ಲಿ?
ಇಲ್ಲ, ಇಲ್ಲ, my lords. It's
ಬೇರೆ ಯಾವ್ದು ಫೈಲ್ ತಗೊಂಡ್ಬಂದಿರಾ?
not like that, my lords.
Heard the learned, you're his colleague, right? Heard the learned counsel so and so appearing for the petitioner. The petitioner is before this court calling in question rejection of an application filed under Order 7 Rule 11D of the A and D of the CPC. The reason for rejection is as follows. Page 18 al quote madidine, the mark madidine quote madi. If this were to be the reason quoted by the concerned court, the plaint ought to have been rejected, but the application is rejected. In that light, further proceedings before the concerned court shall remain stayed. Emergent notice to the respondent.
214.
Petitioner Miller. The application filed by 7 Rule 11 is rejected. Compromise decree was father of the petitioner was a party. Though it was more than 17 years, my lord, the suit is filed in 2011. not maintainable. Section 8 also hit, my lord, father succession by way of intestate succession. The pleadings are very clearly indicates, my lord.
Yes.
Suit is there. The earlier, my lord, is,
Karmadi.
yes.
Counsel for the petitioner to serve on the counsel for the plaintiff. List on 12th September.
Further proceedings, my lord, trial court evidence is going on.
ದಿಕ್ಕೇ ಕೊಡಲ್ಲ. ಎವಿಡೆನ್ಸ್ ಆಗೋವರೆಗೂ ಇಟ್ಕೊಂಡು 711 ಇಲ್ಲಿಂದ. Yes,
ಇಲ್ಲ,
next.
is now started, my lord.
Yes, next.
Order 12 Rule 6 application.
The petitioner, they heard the learned counsel H.S. Dwarkanath appearing for the petitioner. The petitioner is before this court calling in question the proceedings, rejection of an application under Order 7 Rule 11.
Order 12 Rule 6.
Order 12 Rule 6. Partial decree.
Huh?
Why Order 12 Rule 6?
The reason is they admit that there is no registered document in their favor. How can a declaration be granted? The court says, no, they are pleading adverse position. Adverse position never be pleaded.
The petitioner is before this court calling in question an order dated 25/5/2025 rejecting an application filed by the petitioner under Order 12 Rule 6 of the CPC seeking judgment on admitted facts. The learned counsel for the petitioner submits that in the suit for declaration, it is admitted that they have no document to seek declaration thereof. In that light, the suit ought to have been decreed on the said allowing the application. The learned counsel allowing the application. In that light, further proceedings before the concerned court. 711 ಅಂತಿದೆ ಇಲ್ಲಿ.
Rules, Order 12 Rule 6.
Sir, come to page 13.
ಅದೇನೋ ತಪ್ಪು ಬರ್ದಿದ್ದಾರೆ.
ತಪ್ಪ ಏನ್ ತಪ್ಪು? 711 ಅಂತಿದೆ ಇಲ್ಲಿ.
Application Annexure F, your lordship may kindly come to page 65.
IA 6 Order 12 Rule 6. IA 4 711.
ನಾವು Order 12 Rule 6 ಮೇಲೆ ಚಾಲೆಂಜ್ ಮಾಡ್ತಾ ಇದ್ದೀವಿ. We are challenging.
IA defendant number, you are plaintiff.
I am the plaintiff.
Defendant 711 ಹಾಕಿದ್ದಾರೆ.
ಅದು ರಿಜೆಕ್ಟ್ ಆಗಿದೆ.
ಅದು ಗೊಂಡೆ ಇಲ್ವಾ ನೀವು?
ನೋಡಿಲ್ಲ. ನನ್ನ ಕೇಸಿಗೆ ಮಾತ್ರ ರೆಡಿ ಆಗ್ಬೇಕು.
ಅಷ್ಟು ಇಷ್ಟರಲ್ಲೂ ನೀವು ನಿಮ್ ಕೇಸ್ ಮಾತ್ರ ನೋಡ್ಕೊಂಡ್ರೆ ಹಿಂಗೆ. We'll say serve on them. Petitioner to serve on the counsel represents the respondent. 711 rejection is wrong. Yes. Counsel for the petitioner to serve on the counsel representing the respondents. List on 4th.
216.
Yes. Partition.
Declaration and injunction is also there.
Partition alva.
Partition.
Yes, madam.
Notice may be.
Notice, yes. Pendency of this petition will not come in the way of further proceedings before the concerned court. Next.
217.
Suit for declaration and injunction.
The petitioner is before this court calling in question a rejection of an application under Order 7 Rule 11 dated 2nd April 2025. The suit is instituted by the respondent plaintiff seeking declaration and injunction. The cause of action, even according to the plaint, is stops at 2015. The suit is instituted in the year 2020. Article 58 will be a clear bar. In that light, there shall be an interim order of stay of further proceedings before the concerned court till the next date of hearing. Yes, next.
218.
Partitions. Notice. Dismiss ಮಾಡಲಾ?
Dismiss ಬೇಡ.
ಏನು ಬರಲ್ಲ ಅದು. The petitioner is before this court calling in question an order dated 17th March 2025 rejecting an application filed by the petitioner under Order 7 Rule 11D of the CPC. Heard so and so. The suit is the one instituted seeking partition and separate possession. In the suit for partition, it is settled principle of law that there cannot be an application under Order 7 Rule 11D unless exceptional circumstances exist seeking rejection of the plaint. The issue in the list stands answered by the judgment rendered by the apex court in so and so. In that light, finding no error apparent or perversity in the order order so and so, the petition stands rejected.
219.
Same order, partition.
Partition. I'm the purchaser. 1985 sale.
ಯಾವಾಗ ಸೇಲ್ 85
85.
ಆಯ್ತು, ನಿಮ್ ರೈಟ್ಸ್ ಪ್ರೊಟೆಕ್ಟ್ ಮಾಡ್ಕೊಳ್ಳಿ. ಹಂಗಂದ್ರೆ ಪಾರ್ಟಿಷನ್ ಆಗ್ಬಾರ್ದು ಅಂತ ಹೇಳಕ್ ನೀವೇ.
Partition ಅಂತ. Prior to amendment all the sale.
You protect your rights by filing appropriate, not 711. Same order.
There were direction to trial court dispose of it.
ಯಾವ ವರ್ಷದ ಸೂಟ್?
2023. Senior citizen, 84 years. Petition is 84 years.
ಪರ್ಚೇಸರ್ ತಾನೆ, ಆರಾಮಾಗಿರಿ, ತೊಂದರೆ ಇಲ್ಲ. ಎಸ್, ನೋ ಸೇಮ್, ಅದು in light of judgment of the apex court, so on, same order. Next.
84 years ಆಗಿರೋದು.
ಪರ್ಚೇಸರ್ 84 ಆದ್ರೆ ಏನಂದ್ರೆ ನಿಮ್ಗೇನ್ ತೊಂದರೆ? ಪೊಸಿಷನ್ ತೊಂದರೆ ಮಾಡಿದಾರ ಈಗ?
Possession ಗೆ ಏನು ತೊಂದರೆ?
ಮತ್ತೆ ಆರಾಮಾಗಿರಿ. ಡಿಸ್ಮಿಸ್ಡ್ ಮೇಡಮ್. ಸೇಮ್ ಯಾವ್ದೋ ಒಂದು ಮಾಡಿದ್ನಲ್ಲ ಮೇಡಮ್ ಈಗ, ಪಾರ್ಟಿಷನ್ ಯಾವ್ದು, ಸೇಮ್ ಆರ್ಡರ್ ಮಾಡಿ.
Suit for declaration.
220.
For respondent number 1 to 6.
Suit for declaration.
Mixed question.
And
Limitation.
that is order I file IA under order 23(3)A. As per the Triloknath case, the suit itself is not maintainable.
Why? ಲೋಕ ಅದಾಲತ್ ಆಗಿದ್ದ?
ಇಲ್ಲ.
ಕಾಂಪ್ರಮೈಸ್ ಎಲ್ಲ ಆಗಿದ್ದು?
Court.
ಮತ್ತೆ? Yes.
I am not a party to the proceedings.
As per
Only on that ground, independent suit is maintainable.
Another suit was, they withdrawn the another suit. Same, on the basis of the same order, they have filed two suits. One in another suit they had withdrawn and filed the application.
This
I have not withdrawn. Earlier in the year 2006, my lord, he filed the suit for partition that was dismissed after full-fledged trial. Thereafter, during the year 2014, my lord, within a span of 6 days, they themselves, only one branch of the defendants filed the suit and got the decree.
Aden bad.
Now the stage is further cross-examination of PW1.
711. The petitioner is before this court seeking the following prayer. The learned counsel for the respondent submits that the application under Order 7 Rule 11 is filed before the concerned court at the stage of cross-examination after having filed the written statement and stood by the written statement. Therefore, the application under Order 7 Rule 11, though it is worded that it can be filed at any point in time, any stage of the proceedings would not mean that it should be entertained when evidence is completely over and when the evidence is on and when the matter is at the stage of cross-examination. In the light of so and so, the concerned court, owing to the proceedings, has rejected the application, the rejection of which does not warrant any interference in the light of the law as laid down by the apex court, which unequivocally indicates that when the matter is at the stage of evidence, an application or Order 7 Rule 11 of the CPC should not be entertained. In the light of the said, in that light, no, the petition would not warrant any interference. Petition stands disposed. Next. The impugned order would not warrant any interference. Petition stands disposed. Next.
221.
For petitioner, my lord. My lord's honorable trial court has rejected the IA filed by the petitioner, my lord, sought for the rejection of the plaint, my lords, as it doesn't contain any cause of actions.
Why, sir? Suit for partition.
It's a repartition, my lord. Suit has acted in 1975. My lord.
Though it is partition, it is clever drafting. 1975 partition ಏನಾಗಿದೆ? Same property?
Yeah, my lord. Equally has shares, my lord.
We'll see you, sir. Petitioner to serve on the council.
They are in a position and enjoyment, my lord.
Who represents the respondent in the trial proceedings. List on 4th is.
My lord, stay, my lord.
Avath. Yes.
222.
Suit for partition. My lord, in the plaint, my lord, at para 5, my lord, there is a specific, my lord, admission on the part of
serve on the
plaintiff.
respondents. List on 4th.
Please.
223.
It is suit for partition and it was dismissed for default and we have filed the miscellaneous. For
Dismissed for
restoration.
default.
It is suit for partition, main suit.
Ah,
And dismissed for default and we have filed the miscellaneous for restoration of the suit.
notice ಆಗಕ್ ಮುಂಚೆನೆ ಆಯ್ತಾ?
ಅಲ್ಲ ಸ್ವಾಮಿ, ಇಲ್ಲ ನೋಟಿಸ್ ಇಂಪ್ಲೀಡಿಂಗ್ ಅಪ್ಲಿಕೆಂಟ್ಸ್
ಅಂದ್ರೆ ಸರ್ವ್ ಮಾಡಿ petitioner to serve on the counsel.
Respondents are expert in the miscellaneous petition.
ಯಾರ್ಗಾರು ಮಾಡ್ಬೇಕಲ್ಲ miscellaneous petition ಒರಿಜಿನಲ್ ಸೂಟ್ ಅಲ್ಲಿ
Original suit ಅಲ್ಲಿ
petitioner to serve on any of the counsel representing the respondents in the original suit.
date may be.
Yes, list on 12th September.
My lord, one more submission. In this list, serial number 239 and 250, my senior is not in station.
ಈಗಲೇ urgent advance wait.
224.
Pay for the petition in this matter, my lord. Lordship may kindly come to page 31, my lord.
Suit for?
Suit for bare injunction, my lord. Para 7, my lord, he admits. The lordship may kindly come to page 31, my lord. 5 lines from the top.
Heard the learned counsel appearing for the petition. Emergent notice to the respondent. Petitioner is at liberty to serve on the counsel who represents the respondent in the trial proceedings. List the matter on 12th. Further proceedings before the concerned court shall remain stayed till the next date.
Great to oblige.
Next.
225.
Partition.
For partition, but by a non-sharer, person who is not entitled to a share in the property.
Why?
And on the basis of the plaint, the property belonged to grandmother as per the plaint and plaint documents, admittedly by plaint and plaint documents, even with the pleadings of the plaint. And it should have been by a suit for declaration, quote in the form of a party.
See, serve on the respondents.
Right.
Petitioner to serve on the counsel representing the respondent. Which respondent?
So it's all the respondents.
The respondents put up immediately after service of notice.
May kind.
Pendency of this petition will not come in the way of further proceedings before the concerned
Wait,
court.
so only for issues.
26.
ರಮೇಶ್ ಚಂದ್ರ ಯಾರು? ಅವೇ ಕರಿಬೇಕು ನಿಮ್ಮ ಹೆಸರು.
ಇಲ್ಲ 26 ಅಂತ ಹೇಳ್ತಾ ಇದ್ದೆ.
The petitioner is before this court calling in question rejection of an application filed under Order 7 Rule 11 A and D of the CPC. The suit is filed for declaration. The suit seeks to call in question an instrument beyond the period of 3 years, which is hit by Article 58 of the Limitation Act. The application therefore ought to have been answered in favor of the petitioner. It has now been rejected. In that light, further proceedings before the concerned court shall remain stayed. Next.
227.
Partition.
My lords, the identical situation is mine. Clever drafting, they don't question the sale deeds. Sale deeds of 2000.
Clever drafting partition barala.
My lords, I have two. It's covered by 2 judgments of this honorable court. My lords, I'll just pass on.
Clever judgments kodi.
My lords, I said clever drafting. My lords, please. My lords, may just take the first judgment at page 51 at page 97. My lords.
ಆಯ್ತು ಸರ್ವ್ ಮಾಡಿ.
My lords, may I just request for it?
ಯಾವ next date? Next date.
Next date is on 21st of
September.
August, 21st of August.
That's too early. I think she's not correct.
No, my lords, 21st of August. My lords.
List the matter on, we'll see it. List the
September,
matter.
I'll take one date, I'll leave one short date.
That's good. List the matter on 4th September.
Sorry?
4th September.
Lords, permission to serve the counsel on.
Petitioner shall serve on the counsel who represents the respondent in the trial proceedings. Yes, next.
228.
Suit for bearing.
Tenant.
No, my lords.
228. Sorry, sir. Yes. Bare injunction.
Bare injunction. my lords.
ಏನು?
The title is in dispute, my lords.
ಅದಕ್ಕೆ 711 ಎಲ್ಲಿಂದ ಬರುತ್ತೆ?
My lords,
711 ಇದು. ಹೌದು.
please, my lords, it's a suit for bare injunction. In paragraph 15 of my lords, the impugned order, the court, my lords.
Impugned order come to the plaint, sir.
My lords, please.
Bare injunction ಗೆ limitation ಇಲ್ಲ ಅಲ್ಲಿ.
My lords, not
When
limitation,
possession is disturbed.
On the cause of action, my lords.
What cause of action?
My lords, my claim is that, my lords, so the suit, the property, my lords, of the plaintiff comes down to her in a partition deed, my lords. In the partition deed, my lords, they say that the total amount.
All disputed questions of facts.
My lords, but they claim 40 square feet of my property, my lords. The title is in dispute, my lords, and when there is a dispute in title, suit for bare injunction is not, my lords, declaration, they should have filed.
That's a matter of evidence. Yes. Even injunction suits, sometimes title can be gone into.
Please, my lords, but over here they derive their title through a partition deed, which is in itself is it is a mistake, my lords. They totally.
No, sir.
Well, the suit schedule property is for 1 acre. 1 acre is 43,500.
711 ಇದ್ರಲ್ಲಿ ಬರೋದೇ ಇಲ್ಲ ಎಲ್ಲ ಮಿಕ್ಸ್ ಕ್ವೆಶ್ಚನ್ ಆಫ್ ಲಾ ಅಂಡ್ ಫ್ಯಾಕ್ಟ್, ನಾಟ್ ಲಿಮಿಟೇಷನ್ ಬಟ್ ಈವನ್ ಅದರ್ ಪ್ಲೀಡಿಂಗ್ಸ್.
Notice may be issued, my lord.
Notice to the respondent, pendency of this petition will not come in the way of further proceedings before the concerned court. Next.
229.
The petitioner in this case, impugned order is my lord,
Waqf
tribunal.
Petitioner to serve on the counsel who represents the first respondent is the contesting respondent.
1 to 8.
Respondents 1 to 8. Counsel for the respondents 1 to 8 before the tribunal. Lest the matter on 11th September. Further proceedings shall remain state till the next date. Yes. 12th, sorry, 12th.
230.
230 mood. 230.
For judgment filed by the respondent.
Tenant.
Not tenant.
Then?
Jural relationship is denied. Jural relationship was disputed. In the earlier round of litigation, the respondents.
Rural relationship.
Jural relationship.
Between landlord and tenant.
Not landlord and tenant. She is a purchaser, the property was a registered sale deed purchased by the petitioner's son, and she is residing with his permission only there. The respondent number who is.
Petitioner to serve on the counsel who represents the respondent in the trial. Idya, caveat idya. No representation behalf the caveator. List the matter on 29th.
No, there is an order.
29th.
Yes. There is an order, my lord. Diction, my lord.
14/11/24 is the order, sir. Illivargu evict agilla.
February itself.
No,
was not
yes.
Listed.
List on 29th. Next.
231.
Same for the caveator, my lord.
No representation behalf the petitioner. List after 2 weeks.
232.
Appear for the petitioner, my lords. Tenants review petition, my lords. 3 months has been granted.
Yeah, ಇನ್ನೆಷ್ಟು ಬೇಕು ನಿಮ್ಗೆ?
6 months ಕೊಟ್ರೆ ಕ್ಲೋಸ್ ಮಾಡ್ಕೊಂಡು ಹೋಗ್ತಾರೆ.
ಆಯ್ತು, affidavit ಹಾಕಿ. Petitioner shall, learned counsel of the petitioner is before the court aggrieved by the grant of only 3 months time to vacate and deliver vacant possession. The learned counsel submits that if 6 months is granted, at least 6 months is granted, it would suffice. Therefore, the petitioner shall file an affidavit that he would vacate the premises within 6 months by the next date. Subject to the aforesaid, the petitioner shall not be evicted from the premises. List on 3rd September. 12th September.
233.
I will accept notice for the respondent, my lords.
Tenant,
I am the landlord, my lords.
our tenant ಅಂತ ಕೇಳಿ. ಗೌತಮ್.
My lord, we are not actually the tenants, my lord.
Then who are you?
My lord, he is a stranger to the property.
Ownership is stranger.
Ownership, yakandre it was declared, it was government land, my lord. We filed a writ petition before.
How are you staying in that property?
My lord, the earlier owner, my lord, not this.
Which earlier owner?
That one Sharadamma, my lord.
Who is the?
He is not related to her at all. He wanted that property standing in a government land. And he.
Then why did you enter into agreement with Sharadamma?
No, my lord, we have no connection to him, my lord. Whatsoever.
Him alla, Sharadamma jothe yak ಮಾಡಿದ್ರಿ? Government land ಅಂತ ಗೊತ್ತಲ್ವಾ?
My lord, even that point, my lord, we have that is disputed, my lord. That aspect also is disputed. We are not agreed to anything. And there was he clandestinely filed one writ petition before this honorable court saying that
clandestine writ petition ಹಾಕಬಹುದಾ?
Without making us as party, he filed one petition saying that this building is in dilapidated position, and then he got an order. We filed, we approached the honorable court, and the order was recalled. Then he filed an injunction suit, not so that we should not construct. That also is pending. In the meanwhile, he files one more ejectment suit. Though the entire title itself is, we are not connected to him at all.
Now, suit,
unregistered will.
Order is against you.
Order is against me, my lord. Unregistered will, my lord. He has created some document and he wants to knock off, and this.
Tenant counsel so undertakes to enter appearance for the respondent registry to print the name of so and so as appearing for the respondent. List on 19th September. Till such time further, the order impugned shall remain stayed.
My lords, one submission, my lords.
They claim that, my lords, it is, I am not the owner of the property. Initially, my lords, the father of the petitioner, my lords, was a tenant under my grandfather, my lords. After the death of my grandfather, my lords, his 3 children, my lords, acquired title to the property by way of inheritance. Now, 2 of the children,
His father and your grandfather.
my grandfather, his father and my
But that
grandfather. There is
person,
a rent
my lord,
bond to
that
that.
We'll
is
hear
not-
it on 19th.
My lords, there is a rent bond to that effect that has been, and he has been paying rents to me
Yes,
regularly.
Yes,
we
yes,
have
list on
not a-
19th.
We don't have any connection to him, my lord, in fact. Obligation.
I'm grateful.
4.
Yes. Yes, Prakash sir. ಬೆಳಗ್ಗೆ ಯಾವ ಕೇಸ್ ಬಂದಿಲ್ಲ?
53, my lord.
234.
Yes.
53 ಯಾವುದು?
My lord, this is a defendant's, my lord, revision under section 18 of Small Causes Court Act. Suit was for recovery of money under a promissory note. My lord, I have produced that also along with the
Petitioner to serve on the counsel who represents the respondent in the trial proceedings. List on 19th September. The order impugned till the next date shall remain stayed.
235.
Lord, I appear for the petitioners. The petitioners are defendant number 4 and 5. Lord, suit for partition filed by the plaintiff and defendant number 1 to 3 after 87 years from the date of
The petitioner shall serve on the counsel who represents the respondent in the trial proceedings. Lest the matter on 19th till such time further proceedings shall remain stayed. 87 ವರ್ಷ ಆಗಿದೆ ಅಂತ ಅಷ್ಟೇ. Yes.
236.
ಗೊತ್ತಾಯ್ತು. Do ಅಷ್ಟೇ. Same order. Stayed. Yes, next.
237.
For petitioner. So for declaration and partition.
ಆಮೇಲೆ
I have filed the IA under R7 Rule 11. It's rejected.
ಕರೆಕ್ಟ್ ಆಗಿದೆ.
Kindly sir, peruse the, we are on page number 125, my lord. Sorry, page number 128 ನಲ್ಲಿ.
ಮೇಡಮ್ ಅದು ಸೇಮ್ ಆರ್ಡರ್
Third
ಗೊತ್ತಾಯ್ತು.
line.
ಸೇಮ್ ಎಂಟ್ರಿ ಆರ್ಡರ್. 120?
128, my lord. Para 8, my lord. I am advised to submit that the suit of the plaintiff and counterclaim of the defendant number 1 to 2 are hopeless, barred by law of limitation, and also barred under the amended provision of the section 6 of Succession Act 2005.
Suit for what?
Suit for declaration and partition.
ಅದಕ್ಕೆ ಹೇಳಿದೆ. Yes, list the matter. Petitioner to serve on the counsel for the respondent.
Either dispense respondent 4 to 7 or not a
Memo.
formal parties.
Memo.
Filed.
Learned counsel of the petitioner files a memo seeking dispensation of issuance of notice.
My lord, one more submission.
Yes,
I have filed one more revision petition, that is 462 of 2025.
Tag the petition along with Barkodi. First memo mail ಮಾಡಿ madam. Learned counsel with the petitioner files a memo seeking dispensation of issuance of notice to the respondent so and so. In the light of the memo, at the risk of the petitioner, notice dispensed with. Tag this petition along with so and so. Petitioner shall serve on the remaining counsel
Respondent number 1 to 3, my lord.
Counsel representing respondents 1 to 3 before the concerned court. Yes, next.
Great.
Tag along with so and so. Yes, next.
Orders on maintainability. 238.
For the petition, the objector application in the execution petition is not rejected. Against which, my lord, I filed this revision petition. Proviso under proviso, my lord, had it been allowed, it would have given finality to the proceedings.
It's a decree by itself. Yes. You are the objector.
Yes, ma'am.
Order 21 Rule 97.
Yes, ma'am.
Yes. Anything else?
Proviso.
No, sir. The petitioner is before this court calling in question. ನೀವೇ ಹಾಕ್ತೀರಾ ಹಂಗೆ? Counsel for the petitioners, the office objections qua maintainability in view of section 115 stands sustained as the order called in question is an order rejecting an application filed by the petitioner under Order 21 Rule 97 of the CPC, which is a decree by itself and appeal would become maintainable. In that light, the petition stands disposed, reserving liberty to the office objection stands sustained. The petitioner is reserved liberty to file an appeal on the same cause of action, on the cause of action. Yes, next.
239.
Same Order 21 Rule 97, same order.
240.
Petitioner, my lord.
What is challenged?
Challenge, my lord. IA order 11, order 7, rule 11, A and D. Partly allowed, partly allowed.
Allowed?
Allowed.
Appeal, yes.
Illa.
The petitioner, what is called in question is an order answering the application, albeit partly, filed under Order 7, Rule 11D of the CPC. In that light, the revision would not become maintainable, and would not be maintainable, as the remedy would be filing an appeal. In that light, the petition stands disposed, reserving
One
liberty.
submission. Dependents filed the CRP, my
ಹ್ಮ್ ನೀವು ಹಾಕಿ
lord.
ಅಪೀಲ್
ಬರಲ್ಲ.
ಯಾಕೆ
Partly
ರಿಜೆಕ್ಟ್
allowed.
ಆಗಿದೆ ತಾನೆ
My lord, registry is
Plaint is
written-
rejected.
Plaint is rejected to file the jurisdictional court. But
ಅದಕ್ಕೆ
barred
ರಿಜೆಕ್ಟ್
by-
ಆಗಿರೋದಾ
barred by limitation is not.
ಅದಕ್ಕೆ ರಿಜೆಕ್ಟ್ ಆಗಿರೋದಾ ಎಸ್ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಓವರ್ ರೂಲ್ಡ್ ಲಿಸ್ಟ್ ದ ಮ್ಯಾಟರ್ ಆನ್ 4th September. ಎಸ್ ನೆಕ್ಸ್ಟ್ ಅಲ್ಲ 1st September in preliminary hearing. Next.
Admission.
For admission on 1st September. Yes.
241.
Appearing for the petition, my lord. Application
Order challenged.
7 rule 11 has been dismissed with respect to rejection of counterclaim have sought. The court holds that it is not applicable with respect to counterclaim.
The office objections que maintainability stands overruled. List on Monday 1st September in admission. Next.
There is a delay, my lord.
ಆಮೇಲೆ ಅವತ್ತು
242.
order challenged.
Please, my lord, the order of the trial court where suit of the plaintiff came to be dismissed.
Suit is rejected. File an
One
appeal.
finding, my lord, which is against me.
File an appeal, sir.
My lord, I filed an appeal. Appeal
ಮತ್ತೆ
came to be
appeal?
dismissed. I filed a second appeal, my lord. In the second appeal, my lords may take.
Second appeal.
Please, my lord. Second appeal, my lord, I was given liberty to file this revision petition. My lords may take page number 133 for a moment. My lord, page 139 is the judgment.
A remedy before appropriate forum
Please,
ಅಂದ್ರೆ
in
ಏನು?
the last line, my lord, the time spent in RA and RSA is excluded in case.
ಆಯ್ತು CRP revision ನಾ?
Please.
File a revision. Office objections que maintainability stands overruled 1st September in preliminary hearing.
Great.
In admission, sorry madam, CRP ಅಲ್ಲ admission ಅಂತ ಮಾಡಿ ನಾನು preliminary ಅಂತ ಹೇಳಿದ್ರು.
243.
Great.
Order ಏನ್ ಚಾಲೆಂಜ್ ಮಾಡಿರತ್ ಸರ್?
Application filed seeking rejection of plaint matter. That application came to be rejected. Therefore, this CRP is maintainable.
Application is 711 rejected.
711, instead of 711, they have filed section 137 of Limitation Act, read with section 151 of CPC. Wrong mentioning of provision.
And the caveat, my lords, the application that they have
First,
filed.
office objections que maintainability stands overruled. List on first.
My lords, there is a connected writ petition between the same parties.
List on first
Second,
and for admission. Adamel node. Yes.
22nd is matter started.
First. Yes.
Appearing for petitioner, praise time, my lord.
Praise time, no grants time. What is the order under challenge?
My lord, senior is not feeling well, my lord.
Ada answer. File ilva?
Objections gide, my lord.
Huh?
Objections gide, my lord.
Objection maintainability. What is under challenge? Order is
Order
passed,
7 rule
allowed,
11
and the
is
plaint is rejected.
Yes, my
The order under challenge is allowing the application under Order 7 Rule 11D and the plaint being rejected. Therefore, it is a decree which has to be challenged in an appeal. In that light, reserving liberty in that light, the office objections que maintainability stands sustained. The petitioner is at liberty to prefer an appeal. Yes.
245. Same logic.
Same order, Order 7 Rule 11D, same order, same counsel also. Yes, same order, same counsel.
246.
What is under challenge?
The dismissal of the RA, my lord.
Dismissal of RA GM, idu CRPL.
I am not the party in the suit. I am also not part in the RA. They have not implemented, my lord. This is the property in
It
question.
is not a revisable order, sir. Yes.
We are not the made party.
File an appeal, sir.
I am not the party in both the courts, my lord.
Order is not revisable. The office objections que maintainability stands sustained. Petitioner is reserved liberty to prefer an appeal against the order which affects him. Reserving such liberty, petition stands disposed.
Business may be directed to be detained.
The registry is directed to hand over the originals appended to the petition forthwith. Yes, next.
247.
What is under challenge? Office objections que maintainability stands overruled. List on first for admission.
248.
Same order.
249.
Petitioner in this case. My lord, the dismissal of final degree petition has been challenged here, my lord.
Appeals.
My lord, the
Not in CRP, sir. Yes.
The FDP is still pending, my lord, in respect of petitioner number 1, my lord.
Yes, the petitioner calls in question the disposal of the final decree proceedings. In the light of the remedy of appeal being filing an appeal being available, as the rejection of the final decree proceedings que the petitioner in itself a decree which can be appealed against. The office objections que maintainability stands sustained, reserving liberty to the petitioner to avail of such remedy as available in law. Petition stands disposed. Next.
250.
Order 7.
What is challenged?
Order 7 Rule 11 A and D.
Allowed.
It is allowed.
Appeal. Yes. The petitioner is before this court calling in question an order which allows the application filed under Order 7 Rule 11D by which the plaint comes to be rejected. In the light of this being a decree, an appeal under Section 96 ought to have been preferred and not the subject writ petition under GMCPC. Reserving such liberty, the petition stands disposed. Same. Appeal.
My lord, in fact, in this matter,
I know.
the judgment debtors and the decree holders have settled the matter, my lord.
Settled.
Please, my lord.
Right.
So it may be disposed of according to this memo.
Body. Learned counsel for the petitioner submits that the decree holders and the judgment debtors have settled the dispute amongst themselves before the before the concerned court by drawing up certain terms of settlement. The memorandum of compromise. Adadmel decree enagide. The memorandum of compromise is filed before the court and the decree of such the compromise is recorded and the execution petition stands disposed by the following order. In that light, the subject petition does not survive for any further consideration. It stands disposed, recording the aforesaid facts.
My lord, the impugned order stands disposed of according to the virtue of said
In the light of
compromise.
the settlement arrived at between the parties as a matter of form, FORM, the impugned order stands quashed.
Please, great.
52.
Hello, ಆಗಿದೆಯಾ?
Dismiss ಆಗಿದೆ.
Order 7 rule ರಿಜೆಕ್ಟ್ ಆಗಿದೆಯಾ?
Reject ಆಗಿದೆ.
ರಿಜೆಕ್ಟ್ ಆಗಿದೆ CRP ನೇ. Office objections que maintainability stands overruled. Stands overruled. List for admission on 1st September. Next.
253 disposed. 254.
What is called in question is an order passed on application filed under Order 39 Rule 1 and 2 after hearing both the parties by a detailed order. The remedy to call that in question is by filing an appeal under Order 43 Rule 1 and not the subject petition. In that light, reserving liberty to the petitioner to avail of such remedy, the petition stands disposed.
255.
Commercial Courts Act. Office objections, quay maintainability stands overruled. List on Monday for preliminary hearing. Next.
256.
Yan challenge?
Seventh rule and application.
Allow ಆಗಿದೆಯಾ?
ಇಲ್ಲ rejected.
Office objections, quay maintainability stands overruled. List on Monday first for admission. GMCPC. GMCPC ಹೆಂಗ್ ಬರುತ್ತೆ?
7 rule.
7 rule 11 allow ಆಗಿದೆಯಾ ರಿಜೆಕ್ಟ್ ಆಗಿದೆಯಾ?
Rejected.
Plaint ರಿಜೆಕ್ಟ್ ಆಗಿದೆಯಾ?
ಇಲ್ಲ ಇಲ್ಲ ಅಯ್ಯೇ rejected.
ಅಪ್ಲಿಕೇಶನ್ ರಿಜೆಕ್ಟ್ ಆಗಿದೆ. ರಿವಿಷನ್ ಹಾಕ್ಬೇಕು. CMCPC ಹೆಂಗ್ ಬರುತ್ತೆ? Office objections, quay maintainability insofar as it concerns filing of the GMCPC petition stands sustained. The petitioner is at liberty to file a revision petition calling in question the rejection of an application under Order 7 Rule 11D, reserving such liberty for statistical purposes. Petitioner is permitted to convert the same to a CRP by taking necessary steps. For statistical reasons, the petition stands disposed. Next.
257.
The petitioner is before this court calling in question the order passed GMCPC in the employees compensation by the Motor Accidents Claim Tribunal. The order is appealable. Madam. Office objections, quay maintainability stands overruled. List the matter on Monday in preliminary hearing. Next.
258.
The petitioner calls in question an order dated 26/2/2024 by which the applications filed by defendants 11 to 20 under Order 7 Rule 11A is allowed and the plaint is rejected and a decree is drawn accordingly. Therefore, the writ petition so filed under Article 227 of the Constitution of India is not maintainable. Reserving liberty to the petitioner to file an appeal, the petition stands disposed.
259.
What is called in question is an order passed by the concerned court allowing the application filed by the petitioner in Order 39 Rule 1 and 2. The order is passed after hearing the parties and is in detail. Therefore, the remedy that is available to the petitioner is to file an appeal before the concerned court and not a petition under Article 227 of the Constitution of India. In the light of the remedy available under Order 43 Rule 1 of the CPC, the petition stands disposed, reserving such liberty. Next.
260.
Same order, madam. Previous annual day, same order.
261.
What is called in question?
More calculation has been rejected by the executing court, my lords. However, the last
Office
sentence
objections,
says,
quay maintainability stands overruled. List on Monday in preliminary hearing.
lords, the last sentence says the petition is hereby closed as fully satisfied.
Execution is satisfied.
That is what it says. my lords.
Then close adre illang barutte.
CRP. I may be permitted to.
The
convert.
madam. The petitioner is before this court calling in question the closure of the execution proceedings by the executing court. Therefore, the petition under Article 227 would not be maintainable as it is a revisable order. Reserving liberty, the The petitioner is permitted to convert the subject petition to a revision petition. For the statistical purposes, it stands disposed. Yes, next.
262,
Petitioner.
Appeal hakilva?
Hakiಲ್ಲ sir.
Hakidira?
ಇನ್ನೇ ಇಲ್ಲ.
Hakbudi. Yes. The petitioner is before this court calling in question an order passed under Order 39 Rule 1 and 2 of the CPC.
39 1 and 2 ಅಲ್ಲ sir.
Huh?
20 rule 3.
22?
LR application.
LR application. Rejected, huh?
Rejected.
Then a petitioner is before this court calling in question an order which rejects the application under Order 22?
Rule 2.
Rule 2. And directing drawing up of a decree accordingly. In that light, the subject petition under Article 227 would not be maintainable in view of the remedy of appeal available. In that light, the petition stands disposed, reserving liberty to call in question the order so and so in an appropriately drawn appeal ordered accordingly. Next.
63,
Petitioner. So suit dispose ಆಗಿದೆ.
ಇದರಲ್ಲೇನು?
2/12/24 ಅಲ್ಲಿ ಡಿಕ್ರಿ ಆಗಿದೆ ಸರ್.
Decreed.
ಸೂಟ್ ಡಿಕ್ರಿ ಆಗಿದೆ. ಸೂಟ್ ಡಿಸ್ಮಿಸ್ ಆಗಿದೆ.
Dismiss ಆಗಿದೆ.
ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಡಿಸ್ಮಿಸ್ ಆಗಿದೆ.
ಅದೇ ಕರೆಕ್ಟ್. ಪ್ಲೇನ್ ರಿಜೆಕ್ಟ್ ಆಗಿದೆ.
ಹೌದು.
The petitioner is before this court calling in question an order dated 4/4/2024 allowing the application filed under Order 7 Rule 11B of the CPC. In the light of the allowing of the application and rejection of the suit, the remedy available is to file an appeal against the said order and not a proceeding under Article 227 of the Constitution of India. In that light, reserving such liberty, the petition stands disposed.
264,
DP 38. Office objections to maintainability stands overruled. Post the overruled alla. FDP alla hakirodu 39 1 and 2. No representation behalf the petitioner. List the matter on 3rd September. Yes, next.
265 disposed. 266,
What is challenged?
Closure of an execution petition in view of the memo filed by the JDR.
CRP hack. Will permit CRP.
Yes. Your lordship may kindly permit me to convert.
Yes. The petition, ಈಗ ಒಂದು execution ಹೇಳಿದ್ನಲ್ಲ madam, ಯಾವುದು? ಶ್ರೀಹರಿ. 261 ಅಲ್ಲಿ ಏನು ಆರ್ಡರ್ ಮಾಡಿದ್ದೀನಿ ಅದೇ ಆರ್ಡರ್. ಸೀರಿಯಲ್ ನಂಬರ್ 261. Yes. Next.
267 adjourned. 268,
Lord, this is on common order I have filed. I had filed 2 IAs before the trial.
On
court.
what, madam? Common order?
One is on 151 application and other one is on order 39 rule 1 and 2. One is to direct and one is to restrain.
Appeal
my
hakilva?
lord. Lord, I have filed MFA for order 39. So 151 will still hold in WP.
ಒಂದೊಂದು ಕಡೆ ಇನ್ನೊಂದು ಕಡೆ ಹಾಕಿ ಅಲ್ಲೇ ಹಾಕಿ. The learned counsel for the petitioner submits that the challenging a part of the order, the petitioner has filed a miscellaneous first appeal. And insofar as the other part of the order wants to pursue the subject petition before in the light of the appeal, remedy of appeal availed off by the petitioner for a part of the order, the petitioner reserved liberty to file an appeal on the other part of the order as well.
Can I connect it to the same appeal?
With the aforesaid observation, petition stands disposed. The petition shall stand connected with number.
I'll give my.
Tag this petition along with so and so for statistical purposes stands disposed. Next.
Much obliged.
269,
My lord, I pray this writ petition to be converted into CRP, my lord. Has my IA under order 7 rule 11 A and D. The application has been rejected, my lord.
Yes. Application is rejected.
Yes, my
711.
Yes, my lord.
Learned counsel for the petitioner
Office objections que maintainability. ಇದು CPC ಮಾಡಿದ್ದೀರಾ?
CRP ಮಾಡ್ಬೇಕು.
The petition calls in question an order on an application, order rejecting an application order 7 rule 11D. The order is revisable and therefore the petition under article 227 would not be maintainable. The petitioner is permitted to convert the subject petition to a CRP, to a revision petition. For statistical purpose, petition stands disposed. Yes, next.
270.
Rule 11 application has been rejected.
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 Same order, madam.
Same order.
Converted,
And,
same order.
Limitation is concerned, whatever it is.
That we'll see when it comes. Yes, next.
271.
The petition is preferred calling in question an order passed allowing an application order 39 rule 1 and 2. After hearing both the parties, the order is in detail and therefore there is no warrant to entertain the subject petition, reserving liberty to the petitioner to file an appeal under order 43 rule 1. The petition stands disposed. Yes, next.
272.
I'm for the petitioner, Lordship.
What is under challenge?
Order 7, Rule 11.
Allowed.
Dismissed. Dismissed.
Dismissed. Madam, same. Gothayte. Order 7, Rule 11. Egon madadwala. The petition calls in question an application, rejection of an application order 7 rule 11D. Therefore, the order would become revisable and not a petition under article 227. In that light, the petitioner is at liberty to convert the same to a revision petition for the statistical purposes stands disposed.
Much.
Next.
273.
Petitioner. Order 7 rule 11E.
Allowed.
Partially rejected.
Appeal, yes. The petitioner is before this court calling in question allowing of an application filed under order 7 rule 11D. D na?
House A and D.
A and D of the CPC. In the light which is a decree or a partial decree by itself. In that light, the petitioner, the remedy available to the petitioner is to file an appeal under section 96 of the CPC and not a petition under article 227 of the Constitution of India. In the reserving such liberty, the petition stands disposed.
274.
9 Rule 13 petition, my lords, has been dismissed. 9 Rule 13 petition has been dismissed, my lords.
The petitioner is before this court calling in question an application, rejection of an application in order 9 Rule 13 of the CPC, to which an appeal under order 43 Rule 1 is the remedy that is available. Learned counsel for the petitioner seeks leave of this court to avail of the said remedy, reserving liberty to avail such remedy. Petition stands disposed.
275.
For petition in this lordship.
39 1 and 2.
Yes, lordship.
Appeal.
By the plaintiff is been dismissed. Filed by the plaintiff is been dismissed, lordship.
Dismissed. Mat appeal hakbaku. The petitioner is before this court calling in question an order rejecting.
Lordship. The counsel on record is an out of station, lordship.
Out
Finding place found victim.
Rejecting an application filed under order 39 rule 1 and D, refusing to grant temporary injunction. The detailed order is called in question without availing of the remedy available under order 43 rule 1 of filing an appeal against the said order. Reserving such liberty of filing an appeal, the petition stands disposed. Yes, next.
76.
What is called in question is rejection of an application under order 7 rule 11D of the CPC. The order is revisable and a revision petition ought to have been preferred and not a petition under Article 227 of the Constitution of India. Therefore, therefore the petitioner is permitted to convert the same as a revision petition. For the statistical purpose, the petition stands disposed.
277.
151 application, wherein
Yeah, no.
151 the suit has been cause of action since there is become infructuous and that has been allowed.
Suit has become infructuous
ಅಂತ ಹೇಳಿ 151 ಅಲ್ಲಿ ಹಾಕಿದ್ದಾರೆ ಸ್ವಾಮಿ. suit no cause of action, suit has become infructuous ಅಂತ.
Revision ಹಾಕಿ.
Revision ಬರೋದಿಲ್ಲ ಸ್ವಾಮಿ.
Yeah, application.
7 rule 11 ಅಲ್ಲಿ ಹಾಕಿಲ್ಲ ಅವರು. It is 151.
Office objections que maintainability stands overruled first
I will serve the
September.
copies.
1st September preliminary
But
hearing.
one submission. My lord, the suit itself is dismissed.
No, no, 1st September preliminary hearing
278. Withdrawn.
in terms of the memo.
279.
Appellant in this case.
What is under challenge?
Kindly see the page.
What
number
is
20.
under challenge?
Order 7 rule 11D.
Rejection.
Rejection.
GMCPC baralla, CRP.
One kind submission. Kindly see the page number 29.
Yeah, GMCPC antu baralla sir. CRP haki.
One kind submission.
ಏನು ಹೇಳಿ?
The application filed by the fourth dependent is rejected. So far as the application with the observation that plaintiff has to pay the court fee. It is a suit for partition filed by the appellant before the trial court.
What are you challenging?
I am challenging only impugned order with regard to the court fee is concerned.
Only court fee.
Only court fee.
Office objections que maintainability stands overruled. List
Hence,
the
section 115
list
is
the
not
matter
applicable.
on first in preliminary hearing.
But the stay may be granted. Since there is an
yes.
yes.
280.
First, next.
I think challenging the issuance of notice, emergent notice without speaking order on the application.
Without speaking order, where is the order?
My lords, may kindly see page number 45. 45 and
Very
46.
emergent notice. Sir.
Very emergent notice.
No injunction is granted.
No, this is 41 rule 5 to stay the operation.
Office objections que maintainability stands overruled. List on Monday for preliminary hearing. Yes. Monday andre first next Monday adene.
281.
Hearing for the petitioner, madam. Advocate on record is out of country, my
Huh?
lord. Kindly- Advocate on record is out of.
What is under challenge? 39 1 and 2.
Kindly,
Interim order is vacated.
yes, my lord. We have
The
challenged.
counsel with the
against order.
petitioner seeks a week's time. List the matter after 1 week. Next.
282.
Withdrawing. In terms of the memo. Files a memo seeking to withdraw the petition.
283.
My lord, IA number 2 is challenged, my lord. A common order came to be passed, my lord, with respect to IA number
39
1
1 and 2.
Please, 39 1 and 2 is already, an MFA is preferred.
ಇದ್ರ
Presently,
ಜೊತೆ ಇದು ಹಾಕ್ಬಿಡಿ.
please.
The petitioner calls in question common orders passed under order 39 rule, under application of order 39 rule 1 and 2 and order 38 rule 5.
Please.
Insofar as the application under order 39 1 and 2, the petitioner has already preferred an appeal, reserving liberty to file an appeal against the order rejection of an application order 38 rule 5 as well. The petition stands disposed.
Great.
Yes.
284.
Challenge final order, my lord.
The petitioner is before this court calling in question a judgment and decree dated 16th February 2022 in a petition under Article 227 of the Constitution of India. The petition, an appeal under Section 96 ought to have been filed before the appellate court. Reserving such liberty, the petition stands disposed.
285.
Same appeal.
My lords, my lords, there was no inquiry which was conducted.
Whatever decree is drawn.
No, my lords.
ಮತ್ತೆ? Execution proceedings are closed.
Delivery warrant is issued. My lords, an inquiry ought to have
Madam,
been
Order
conducted.
21 Rule 97 is called in question.
Yes, my lord.
The petition in question, rejection of an application of an objector under Order 21 Rule 97 of the CPC. It is settled principle of law that rejection of an application under Order 21 Rule 97 is a decree by itself and therefore has to be challenged in an appeal under Section 96 of the CPC. Reserving such liberty to challenge, to raise a challenge, the petition stands disposed.
286.
Appear for the petition, my lord, challenging the order 39 rule 1 and 2 and order 39 rule 4, my lord.
38.5.
Please, my lord.
Same, ಈಗ ಒಂದು ಮಾಡೋದಲ್ಲ ಮೇಡಮ್.
ಅಲ್ಲ ಕನ್ವರ್ಷನ್ ಕೇಳ್ಕೊಳ್ತೀನಿ.
ಕನ್ವರ್ಷನ್
Yeah,
ಕನ್ವರ್ಷನ್ ಅಲ್ಲ ಅಪೀಲ್ ಹಾಕಿಲ್ವಾ ನೀವು?
No, my lord.
Order 39 1 and 2 appeal ಹಾಕ್ಬೇಕು.
Please, my lord.
Yes, the petitioner is before this court calling in question rejection na?
ಇಲ್ಲ, not rejection, allowing
the petitioner is the defendant, calls in question allowing of an application filed by the plaintiff under Order 39 Rule 1 and 2. The remedy available is to prefer an appeal under Order 43 Rule 1 of the CPC and not a petition under Article 227 in the light of the order being in consonance with the procedure as obtaining under Order 39 Rule 3. Reserving such liberty, the petition stands disposed.
My lord, petition may be converted to for MFA, my lord.
MFA?
Order 39 rule 1 and 2 ಅಲ್ಲಿ
ಆಯ್ತು. Order 43 Rule 1 ಅಲ್ಲ, ಕನ್ವರ್ಷನ್ ಯಾಕೆ ಹಾಕಿ? Yes.
Please, my lord.
Next.
Certified copy may be given.
The registry is directed to hand over the originals to the petitioner forthwith. Next.
288.
287, my lord.
What is under challenge?
Order 39 1 and 2.
Allowing of
Order 39 1 and 2. Application and order 39.
Same order. Previous order same, 286. Next.
289.
2197.
No.
Huh?
Order 7 Rule 11.
7 Rule 11 allowed.
Allowed.
Plaint rejected.
Yes.
File an appeal.
No decree is drawn by the trial court.
That's all right. The petitioner is before this court calling in question an order passed by the concerned court rejecting the plaint and orders allowing an application under Order 7 Rule 11 A and D. Therefore, it is a decree by itself, notwithstanding the fact that the decree is yet to be drawn. The reserving such liberty to the petitioner to avail of the remedy of filing an appeal under Section 96 of the CPC, the petition stands disposed.
290.
Certified copy.
The registry is directed to hand over all the originals that are appended to the petition forthwith. Yes. 2.
7 to 11 rejected, my lord. Kindly convert.
The petitioner calls in question rejection of an application under Order 7 Rule 11 CPC. The order is revisable and not to be challenged in a petition under Article 227 of the Constitution. Therefore, the petitioner is permitted to convert the subject proceeding to a revision petition for statistical purposes. Yes, next.
291.
Office objections to a maintainability stands overruled. List the matter on Monday in preliminary hearing. Next.
292.
I appear for petitioner.
What is under challenge?
Rejection of plaint, your lordship.
The petitioner calls in question rejection of an application. Plaint reject ಆಗಿದೆಯಾ?
ಇಲ್ಲ ಇಲ್ಲ.
Rejection of an application seeking application under Order 7 Rule 11 A and D of the CPC. Therefore, a petition under Article 227 would not be maintainable. The petitioner is permitted to convert the subject proceedings to a revision petition for the statistical purposes. The petition stands disposed. Next.
293.
For the petitioner in this case.
Yes.
FTP dismissed on 19/1/2015. After that, we preferred an application before the trial court FTP proceeding, Order 9 Rule 9, and another limitation application also filed.
Order 9 Rule 9 rejected?
Yes, yes.
Appeal.
33 Rule 1C. 1C. 43 rule 1.
But 43 rule 1 will ಬರಲ್ಲ ಅನ್ಸುತ್ತೆ.
ಅದು ಇದೆ ಇದು. Appeal
ಇದೆಯಾ? Learned counsel for the petitioner submits that he
No, only thing is, my lord, there's the independent application was filed before the court, my lord.
whatever that would amount
But
to a
that is not
decree.
a decree which was it's dismissed for non-prosecution before the trial court.
ಮತ್ತೆ ಯಾಕೆ ಅಪೀಲ್ ಇದೆ? ಅದಕ್ಕೂ ಅಪೀಲ್ ಇದೆಯಾ?
ಅಲ್ಲ ಅದಕ್ಕೆ appeal.
ಮತ್ತೆ
ಅಲ್ಲ ಅದಕ್ಕೆ Order 9 Rule 11 because cannot be filed one more
the petition the petition serial number ಏನಿದು?
293.
293. The office objections to maintainability stands overruled. List on Monday in preliminary hearing. Next.
294.
Ex parte interim order against me continuing for 3 years, my lords. No reasoning. I have heard and reheard the matter, my lords. Time barred as well. If I may trouble my lords with just 3 paragraphs of the plaint.
ಇದಕ್ಕೆ ಅಪೀಲ್ ಹಾಕ್ಬೇಕಾಗಿತ್ತು, ಯಾಕೆ ಹಾಕಿಲ್ಲ?
Lords, vacating is there 3 years, my lords. We've heard.
39-4 you have filed?
Please, IA2.
Page, sorry, date?
IA2 is at page 93, my lords.
The
193.
petitioner is before this court. They are calling in
4722.
seeking the following prayer. An ex parte order of injunction is granted in order 39 rule 1 and 2. The learned counsel for the petitioner restricts the prayer to a direction to the concerned court to dispose the application filed under order 39 rule 4 by the petitioner, which is filed on
24/7/22.
24/7/2022.
47, my lords.
4/7/22. The learned counsel submits that the said application is still pending consideration at the hands of the concerned court. Therefore, the concerned court, therefore I deem it appropriate to dispose the subject petition with a direction to the concerned court to dispose the application pending said to have been filed in order 39 rule 4 within an outer limit of 4 weeks from the date of receipt of the copy of this order, if not earlier ordered accordingly.
295.
I appear for the petitioner. The application filed by the defendant, my lordship, not to alienate under Article 39 rule 1 came to be rejected, lordship, page 49. It is before the senior civil judge, your lordship.
Appeal haki.
Lordship,
Oh, it's a detailed order, sir. Yes. The petitioner is before this court calling in question an order dated 28th April 2025 filed rejecting an application filed by the defendant seeking a direction not to direction against the plaintiffs not to alienate the property. The said an appeal, the remedy available to the petitioners to file an appeal under order 43 rule 1 are reserving such liberty to file an appeal. The petition stands disposed.
296.
What is the order under challenge?
11, my lord, 11A and D, it's allowed. But
Allowed,
partially, my lord, partially, my
counsel for
lord,
the
right cannot be rejected in part, my lord.
partially and reject ಮಾಡಿದ್ದಾರೆ.
Suit is dismissed, my lord, against the defendant 14 and 15.
Where is it?
Position, 17.
Where is it? Where is it?
17.
Then file a CRP, not a GMCPC.
It's defendant, it is a plaintiff's writ petition, my lord. On the basis of the application filed by the defendant 7 and 14, my lord.
Suit admittedly cannot be partially rejected.
That's what.
Either full or
that's what I'm before the.
No rejection.
No rejection.
GMCPC.
Our application is being allowed.
Anyway,
and partially.
list the office objections to maintainability stands overruled. List the matter on Monday in preliminary hearing. Next. Avot CRP and CRP ಕಳಿಸ್ತೀನಿ.
297.
The same rejection of plain order 7 rule 11.
ನಿಮ್ದು ಯಾವ್ದು ಇನ್ನೊಂದು ಈಗ ಮಾಡಿದ್ದು 292 ಅಲ್ಲಿ ಏನು ಆರ್ಡರ್ ಮಾಡಿದ್ದೀನಿ ಸೇಮ್ ಆರ್ಡರ್ ಸೀರಿಯಲ್ ನಂಬರ್ 292.
298.
Appear for petitioner, my lord. Pecuniary jurisdiction, my lord. The district courts also appeal. Kindly see page number 83. Valuations.
List the matter on Monday. List the matter on Monday in preliminary hearing. Next.
Much obliged.
299.
Same, my lord.
Same order. Overruled Monday. Sorry. Overruled ಮರೆತುಬಿಟ್ಟೆ ಹೇಳು. Yes.
300.
For the respondent in this case.
For the petitioners, my lords, must kindly grant 2 days time, my lord.
Not s- 2 days time. What is challenge, madam?
My lords, miscellaneous
Section
petition.
24, my lord. Section 24.
Then office objections overruled, list on Monday.
Obliged, my lords.
Preliminary hearing. Next.
301.
Counsel for petitioner is not in station. I will let next.
Not in station. What is under challenge?
Is filed a writ petition against the order 39 rule 112 in execution case. That is under challenge.
Sir, 2197. Yes. The petitioner is before this court calling in question rejection of an application filed by the petitioner under Order 21 Rule 97. It is settled principle of law that rejection of an application under Order 21 Rule 97 is a decree by itself, and therefore the petition will have to avail of a remedy of filing an appeal against the said order. Reserving such liberty, the petition stands disposed. Next.
102.
Order 7, Rule 11B, my lord, rejected. We permitted to convert.
CRP. The petitioner is before this court calling in question a rejection of an application filed under Order 7 Rule 11D B of the CPC. The remedy available is to file a revision petition, not a petition under Article 227. Therefore, the petitioner files a memo seeking conversion. In the light of the memo, the petitioner is permitted to convert the subject proceedings into a revision petition for the statistical purposes. Stands disposed. Next.
303.
I think for the petitioners, my lord, there's a suit challenging the Order 11, Order 7, Rule 11.
Allow ಆಗಿದೆಯಾ?
Allow ಆಗಿದೆ.
Plaint is rejected?
Plaint is rejected.
Then appeal. The petitioner is before this court calling in question an order of the concerned court which allows the application under Order 7 Rule 11D of the CPC, to which an appeal under Section 96 would be maintainable and not a petition under Article 227. In that light, the reserving such liberty, petition stands disposed.
304.
What is challenged?
No, the order that is passed by the court below, directing me to pay the court fees on the non-agricultural value. And what had happened was this, my lord. The defendant files an application under Order 7 Rule 11B. That application came to be rejected. That application came to be rejected. No, I am not challenging that order.
Then?
While rejecting the application.
Court fee pay ಮಾಡಕ್ಕೆ ಹೇಳಿದ್ದಾರೆ.
Court fee ಕೊಡಿ ಅಂತ ಹೇಳಿದ್ದಾರೆ. ಅದನ್ನ ನಾನು ಚಾಲೆಂಜ್ ಮಾಡ್ತೇನೆ.
Office objections square maintainability stands overruled. List on Monday in plenary.
Monday is a non-working day, my lordship may have.
Non-working day?
ಹೌದು.
ಈ ಮಂಡೇ ಅಲ್ಲ, 1st September.
ತುಂಬಾ ಲೇಟ್ ಆಗಿ ಹೋಗುತ್ತೆ.
ಏನು ಲೇಟ್ ಆಗೋದು?
ತೊಂದರೆ ಆಗ್ತದೆ. ಕೋರ್ಟ್ ಅಲ್ಲಿ ಏನಾಗ್ತದೆ ಅಂದ್ರೆ ಟ್ರಯಲ್ ಕೋರ್ಟ್ is insisting that I should pay the court fee.
When is the next date there?
You know, it is tomorrow or day after it is there.
Seek an adjournment saying the matter is listed on
At
first.
least let the trial court not precipitate the matter.
The concerned court shall not precipitate the matter till the next date of hearing.
Much obliged.
Yes. List on first and plenary hearing.
Much obliged.
Next.
305.
23 Rule 3
Huh?
application. 23 Rule 3 application.
Rejected.
No, allowed.
Allowed anyway. 96.
ಲೋಕ ಅದಾಲತಲ್ಲಿ ಸೆಟ್ಲ್ ಮಾಡ್ಕೊಂಡಿದ್ದೀವಿ. They are not made as a party to the proceedings.
ಲೋಕ ಅದಾಲತಲ್ಲಿ ಸೆಟ್ಲ್ ಆಗಿರೋದಾ?
ಲೋಕ ಅದಾಲತಲ್ಲಿ settle.
ಹಾಗಾದ್ರೆ office objections square maintainability stands overruled. List on Monday in preliminary hearing. Next.
306.
Disposal of miscellaneous.
39 1 and 2.
ಅಲ್ಲ ಸರ್. Civil miscellaneous.
ಸಿಮಿಸ್ಗೆ ಅಪೀಲ್ ಬರಲ್ವಾ?
ಅಪೀಲ್
ಬರಲ್ವಾ?
Under Order 202.
Order 202.
It is barred.
Maybe. List the matter on 1st September in plenary hearing. Next.
307.
Petitioner, my lord. Dismissing the interim order, they are challenging.
39 1 and 2. Also failed to take appeal ಹಾಕಿದ್ದೀರಾ? Office objections square maintainability stands overruled. List the matter on Monday in preliminary hearing. Yes, next.
308.
And for the petitioner, my lord.
There is
Order number 1, my lord. Kindly permitted to file wakalat, my lord.
Very good. One niche. What's under challenge? 39, 1 and 2?
No, my lord. Order challenge, temporary injunction order has been challenged, my lord.
What?
Temporary injunction order, my lord. Ex parte entry, my lord.
Ex parte order.
Please, my lord.
Office objections, claim maintainability stands overruled. List on Monday in preliminary hearing. Next.
Please,
309.
Challenging the ex parte order under 39, 1 and 2.
Overruled. Monday preliminary hearing.
My lord, it will be
310.
30 days. We just are requesting the disposal within 30 days.
What the application? You are the defendant.
We are the defendants, my lord.
The petitioner is before this court seeking the following prayer. The learned counsel for the petitioner submits that he has filed an application seeking vacation of the ex parte interim order granted by the concerned court, and said application is said to be pending consideration. In the light of the said submission and the prayer being innocuous, I deem it appropriate to direct the concerned court to dispose the application seeking vacation of the interim order IA-2 of 2025 filed by the present petitioner with an outer limit of 4 weeks from the date of receipt of the copy of the order, if not earlier. Yes, ordered accordingly. Next.
310.
For the defendant petitioner, plaintiff suit for injunction comes to be decree. Against the said decree, the defendant files an application under 114 for review of that decree.
Review is rejected.
Application is rejected.
The office objections claim maintainability stands overruled. List on Monday first in preliminary hearing. Yes.
311.
The petitioner is defendant number 8. The submission is despite the objections. The order is passed allowing an application IA-3 on Order 39 Rule 1 and 2 of the CPC in a regular appeal. Office objections claim maintainability stands overruled. List the matter on Monday in preliminary hearing. First
312.
Ex parte order, my lords, under 39, 1 and 2, my lords, is passed. Challenges, my lords, on the ground that under 39.
Office objections overruled. List on Monday in preliminary hearing. Yes, next.
313.
My lord. Challenging annexure J.
14%.
Yes.
Why?
It is my personal case.
Personal case.
Is the tenant, madam?
You are a tenant.
Yes.
ಬಿಡಲ್ವಾ?
ಅಲ್ಲ ಇವಾಗ ಕಂಟೆಂಪ್ಟ್ ಮಾಡಿದ್ದಾರೆ.
ಹಾ.
ಅದಕ್ಕೆ ಐ ಹಾಕಿ ಮಿಸಲೇ ಕೇಸ್ ಹಾಕಿದ್ದೇನೆ. ಅದಕ್ಕೆ ಇನ್ವಾಲ್ ಡಿಸ್ಪೋಸಲ್ ಆಫ್ OS ದಿಸ್ ಮಿಸಲೇ ಕೇಸ್ ಡಸ್ ನಾಟ್ ಸರ್ವ್ ಕನ್ಸಿಡರ್ ಡಿಸ್ಮಿಸ್ ಮಾಡಿದ್ರು.
ಅಲ್ಲ ಸೂಟ್ ಇಸ್ ಡಿಕ್ರೀಡ್.
It is an
ex parte decree.
No. It is an independent separate proceeding. Miscellaneous order 39 rule 2 CPC. So court has to decide whether contempt is committed during the pendency of case. I filed the application. Court has to decide.
ನೀವು ಎಲ್ಲಿರ ಯಾವುದು ಬಿಲ್ಡಿಂಗ್ ಇದು?
ಅಶ್ವಥ್ ನಗರ.
ಅಶೋಕ್ ನಗರ. ಶ್ಯಾಮ್ ಸುಂದರ್ ಸರ್ ಅಲ್ಲೇ ಇರೋದಾ? ಇಲ್ಲ.
So
ಶೋಕನಗರ.
Writ petition is perfectly maintainable.
Perfectly maintained.
Yes. Because it was not decided on merits.
Yes, madam. Office objections claim maintainability stands overruled. List on Monday in preliminary hearing. Yes.
114.
ನೀವು ಖಾಲಿ ಮಾಡಲ್ವಾ?
Even he has filed the RFI.
ಅಲ್ಲ ಟೆನೆಂಟ್ ತಾನೆ. ನಾನು ಫೈನಲಿ ಕೇಳ್ತಾ ಇರೋದು ಖಾಲಿ ಮಾಡ್ತೀರಾ ಇಲ್ವಾ?
ಖಾಲಿ ಮಾಡಲ್ಲ ಅಂತಲ್ಲ. ಅದರಲ್ಲಿ ಏನಾಗಿದೆ ಅಂತ ತುಂಬಾ ಡ್ಯಾಮೇಜಸ್ ಎಲ್ಲ ಮಾಡಿದ್ದಾರೆ.
ಯಾರು?
ಲ್ಯಾಂಡ್ ಲಾರ್ಡ್ ಡಿಸ್ಕನೆಕ್ಟ್.
ಲ್ಯಾಂಡ್ ಲಾರ್ಡ್ ನಿಮ್ದ್ರಲ್ಲಿ ಡ್ಯಾಮೇಜ್ ಮಾಡಿದ್ರು.
ಅಲ್ಲ ನಾನು ಬೇಕಾ ಫೋಟೋ ಬೇಕಾ ತಮಗೆ ತೋರಿಸ್ತೇನೆ. ಏನೇನು ಮಾಡಿದ್ರು GPS ಮೂಲ ತೆಗೆದಂತ ಫೋಟೋ ಮೈನ್ ಗೇಟ್ಗೆ ಲಾಕ್ ಹಾಕಿ ತುಂಬಾ ಡ್ಯಾಮೇಜ್ ಎಲ್ಲ ಮಾಡಿದ್ದಾರೆ. ಇದು ಅದಕ್ಕಾಗಿ ತಮಗೆ ಬೇಕು ನೆಕ್ಸ್ಟ್ ಇಯರ್ ಇಂದ ಫೋಟೋ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡ್ತೇನೆ.
ಇವಾಗ ರೆಸಿಡೆನ್ಷಿಯಲ್ ಹೌಸ್ ಅಲ್ಲಿ 12 ಗಂಟೆ ಬಂದ್ರೆ ಬೇಗ ಹಾಕ್ತಾರ ಹಾಕಲ್ಲ.
ಒಂದ್ ನಿಮಿಷ 12 ಗಂಟೆಗೆ
12 ಗಂಟೆಗೆ ಇವ್ರ ಆಫೀಸ್ ಮುಗಿಸ್ಕೊಂಡ್ ಬರೋದು 12
ಅಡ್ವೊಕೇಟ್ಸ್ ಏನ್ ಮಾಡಕ್ ಆಗುತ್ತೆ ಮೇಡಮ್?
ಅಲ್ಲ ಈವನ್ ಅವ್ರ ಕೈಯಲ್ಲಿ ಆಕ್ಚುಲಿ ನಾವ್ ಅಲ್ಲಿ ಗೇಟ್ಗೆ ಬೇಗ ಏನೋ
ರೆಸಿಡೆನ್ಷಿಯಲ್ ಪ್ರಿಮೈಸಸ್.
ಹೌದು
ಮೈನ್ ಗೇಟ್ಗೆ ಕೆಳಗಡೆ 4 ಫ್ಲೋರ್ ಉಂಟು, ಅದಕ್ಕೆ ಮೈನ್ ಗೇಟ್ಗೆ ಒಳಗಡೆ ಹೋಗೋದು ಬಿಡ್ತಾ ಮತ್ತೆ ಇಲೆಕ್ಟ್ರಿಸಿಟಿ ವಾಟರ್ 1 ಇಯರ್ ಡಿಸ್ಟೆನ್ಸ್ ಮಾಡಿ.
ವಾಟರ್ ಇಲ್ವಾ?
ಇಲ್ಲ
ಏನ್ ಮಾಡ್ತಾ ಇದ್ದೀರಾ?
ನಾನೀಗ ಬೇರೆ ಕಡೆ ಇದ್ದೇನೆ.
ಬೇರೆ ಕಡೆ ಆಯ್ತು. ಹಿಂಗೆಲ್ಲ ತೊಂದರೆ ಕೊಟ್ರೆ ನಿಮ್ಗೆ ಯಾರು ಬಿಡ್ತಾರೆ?
ಅಲ್ಲ RFA ಕೂಡ ಹಾಕಿದ್ದಾರೆ ಅವರು ನಮ್ಮ ಎವಿಕ್ಟ್ ಮಾಡಿ. ಆಕ್ಚುಲಿ ಅಲ್ಲಿ ಏನು ಪ್ರಾಬ್ಲಮ್ ಇಲ್ಲ.
ಅಲ್ಲ ನಾನು ಫೋಟೋ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿ ವಿತ್ ಡೇಟ್ ಟೈಮಿಂಗ್ಸ್ ಎಲ್ಲ ಫೋಟೋ.
ನೀರಿಲ್ಲ ಅಂತ ಫೋಟೋ ಹೆಂಗ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡ್ತೀರಾ?
ಯಾಕೆಂದ್ರೆ ಡಿಸೊಬೀಡಿಯನ್ಸ್ ಆಗಿದೆ ಅದಕ್ಕಾಗಿ.
Even he has filed an application for claiming compensation of 12 lakhs, my lord.
12 lakhs?
Yes.
ಸ್ವಲ್ಪ ಜಾಸ್ತಿ ಕೇಳ್ಬೇಕಾಗಿದೆ.
ಅಲ್ಲ ಕೇಳ್ಬೇಕಿದೆ, ಕೋರ್ಟ್ ಫೀ ಕೊಡ್ಲಿಕ್ಕೆ ಪೇಮೆಂಟ್ ಕಷ್ಟ ಆಗ್ತದೆ.
ಕೋರ್ಟ್ ಫೀ ನಿಮಗ್ ಕಷ್ಟ ಆಗ್ತದೆ. ಆಯ್ತು. ವೇಟ್ ಸರ್, ಅವ್ರ ಪ್ರಾಬ್ಲಮ್ ಅವ್ರಿಗೆ, ನೀರಿಲ್ಲ ಅಂತ ಇದಾರೆ, ನೀವು ವೇಟ್. ವಿಸಿಲ್ ಬಂದೇನ್ ಪ್ರಾಬ್ಲಮ್? ಎಸ್,
my file.
List on Monday in preliminary hearing. Office objections overruled. Yes.
3-4, my lord.
What is challenge?
My lord, 39 rule 1. I am the petition, my lord. I am permitted to withdraw
hearing both the parties.
appeal, my lord.
Appeal, sir. The petitioner seeks leave of this court to prefer an appeal against the order allowing an seeks leave of this court to withdraw the petition and avail of such remedy as available in law. In the light of the said submission, the petition stands disposed as withdrawn. Next.
315.
Non-grant of an ex parte order, thereafter we seek to advance it, that's also not it.
Office objections overruled Monday.
To alienate ಕೇಳ್ತಾ ಇರೋದು.
Preliminary hearing. ಅಷ್ಟೊಂದು ಎಲಿನೇಟ್ ಮಾಡ್ಬಿಡ್ತಾರ?
ಮಾಡೋದಕ್ಕೆ ಅವಕಾಶ ಇದೆ because there's another writ where there was some protection.
Agar a list office objections overruled, list the matter day after tomorrow and preliminary hearing. Next.
316.
LAC judgment ಆಗಿದೆ. LAC judgment ಆಗಿದೆ ಇದರಲ್ಲಿ.
ಏನಾಗಿದೆ?
LAC ಕೇಸಸ್ ಜಡ್ಜ್ಮೆಂಟ್ ಆಗಿದೆ. ಅದರಲ್ಲಿ
ಅಪೀಲ್ ಹಾಕಿ
ಅಪೀಲ್ ಹಾಕಿದೆ ಸರ್. ರಿಟ್ ಅಲ್ಲೇ ಬರೋದು ಸ್ವಾಮಿ ಅದೆಲ್ಲ.
ಎಲ್ಲೇನಾ?
ಎಲ್ಲಿ
ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಮೇಂಟೈನಬಿಲಿಟಿ ಸ್ಟ್ಯಾಂಡ್ಸ್ ಓವರ್
ಅಲ್ಲ ಸಬ್ಮಿಷನ್ ಇದರಲ್ಲಿ ಡೆಪಾಸಿಟ್ ಮಾಡ್ತೀವಿ ಅಮೌಂಟ್ ಕನೆಕ್ಟೆಡ್ ಮ್ಯಾಟರ್ಸ್ ಇದೆ
ಮಾಡಿ. ಸೊ ವಾಟ್?
ಡೆಪಾಸಿಟ್ ಇಲ್ಲ ಡೆಪಾಸಿಟ್ ಮಾಡ್ತೀವಿ ಸ್ವಾಮಿ. ಕನೆಕ್ಟೆಡ್ ಮ್ಯಾಟರ್ 65,000 ಡೆಪಾಸಿಟ್.
ನಂಬರ್ ಕೊಡಿ.
ಕೊಟ್ಟಿದ್ದೀನಿ ಸ್ವಾಮಿ, ಆರ್ಡರ್ ಕೊಟ್ಟಿದ್ದೀನಿ.
ನಂದೇ ಆರ್ಡರ್ ಇದೆ. ಟ್ಯಾಗ್ ದಿಸ್ ಪೆಟಿಷನ್ ಅಲಾಂಗ್ ವಿತ್ ಸೋ ಅಂಡ್ ಸೋ ಸೇಮ್ ಆರ್ಡರ್.
65,000 ಡೆಪಾಸಿಟ್ ಮಾಡಿ.
ಸೇಮ್ ಆರ್ಡರ್ 65,000 ಡೆಪಾಸಿಟ್ 4 lakhs ಬದಲು 65,000. ನೆಕ್ಸ್ಟ್. ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಓವರ್ರೂಲ್ಡ್ ಅಂತ ಫಸ್ಟ್ ಮಾಡಿ ಆಮೇಲೆ ಆರ್ಡರ್. ನೆಕ್ಸ್ಟ್.
317.
ಎಲ್ಲ ಸೇಮ್ ಆರ್ಡರ್. List on next Tuesday in preliminary hearing.
318.
My lords, the
counsel preferred it here, sir.
My lords, the assessing officer is here, my lords. The notice is issued by a party, by a officer who is not the jurisdictional assessing officer. These are my instructions.
Maintainability stands overruled. List on Thursday in preliminary hearing.
My lord, can it be the following week, my lords? The council is not in town.
No problem. Or list on 28th. Yes.
My lord, 4th, my lords.
Oh, 4th, fine.
Yes. Deeply advised.
Yes, sir.
Hearing on IA 319.
My lords, I appear for the petitioner, my lords, in this case.
Delay.
8 days, my lords.
So what? 1 day idru delay.
Please, my lords. My lords, suit
7 rejected.
Yes, my lords. Partition suit filed by the son. Admittedly, my lords, properties.
Partition ನಾನು ರಿಜೆಕ್ಟ್ ಮಾಡೋದು. No 711 anyway. Notice on IA.
My lords, I may be permitted to
2025. Yes, next.
My lords, I may be permitted to serve the council. My lords, appearing before the
serve is at liberty to serve when the council represents the respondent. Same order 320.
My lords, date may be given. My lords, 390.
Put up immediately after service of notice. Errorlo ade order.
1st September, my lords, if possible.
Yes, next.
My lords, 319 1st September, my lords.
ಇಲ್ಲ ಅದು ಇಲ್ಲ ಸರ್ವಿಸ್ ಆದ್ಮೇಲೆ ಅಲ್ವಾ?
I'll serve by then.
ಸರ್ವ್ ಮಾಡಿ. Yes, 12th September. Next.
Please, grateful.
Orders. Council submissions 321.
Hearing for the petitioner, Lordship. Lordship, this matter is based on the earlier order passed by this honorable court in writ petition.
Office objection stands overruled 1st September in preliminary hearing. Oh, sorry, preliminary hearing. Next.
322.
First respondent ತೀರೋಗಿದ್ದಾರೆ. I will take steps.
Counsel for the petitioner seeks a week's time to do the needful. List the matter. A week's time is granted to do the needful. Next.
323.
Well, 1 week's time to do the needful, my lord. 1 week time, my lord.
A week's time is granted to comply with the office objection. Counsel submission ಯಾಕೆ ಕೊಟ್ಟಿದ್ದೀರಾ ಮತ್ತೆ? Huh? Yes, so next.
324.
Office objections overruled list on 1st September in preliminary hearing.
325.
Defendant's petition, my lords. Order under challenge is in order under 22 rule 5. Hello, order under 22 rule 5 is challenged. There's a dispute in
ಒಂದೇ ಅಲ್ಲ. Objections ತುಂಬಾ ಇದೆ.
There are only 2 objections which are surviving, my lords. One, I've given a counsel submission, my lords. At least those may be considered.
The office objections where counsel submissions are rendered stands overruled. The remaining of the office objections be complied with if the stand complied list on 1st September in the fresh
J and
matters
J1 are
list.
certified copies.
Whatever is
326.
next.
Lords, a copy of the we've served a copy on the
Overruled
Matrimonial.
Monday and the first. Yes, next.
327.
Only one order of this
A week's time is granted to comply with the office.
It has been complied, my lord.
Learned counsel submits office objections have been complied with office to verify. Urgency ಉಂಟಾ? ಏನು?
My lords, we have-
ಈಗಲ್ಲ. ಅರ್ಜೆನ್ಸಿ ಅಂದ ತಕ್ಷಣ ಅವ್ರ ಕಡೆ ನೋಡ್ತಾ ಇದ್ದೀರಾ?
my lords, I have briefed in the matter.
List day urgency ಇದೆ day after tomorrow. ಇಲ್ಲಾಂದ್ರೆ 1st September ಆಗುತ್ತಾ? Day after tomorrow in preliminary hearing. Yes, next.
328.
Which have complied with the office objections.
Counsel for the petitioner submits office objections have been complied with office to verify.
My lords, I've made a counsel submission, only that needs to be accepted.
Insofar as the counsel submissions are rendered, the office objection stands overruled. Next.
Madam, could it be had on Monday?
Monday is
Next Monday.
next Monday raja alla Monday. Next.
329.
Same order.
330.
My lord, seeking mandamus for the
Seeking mandamus.
speedy disposal, my lord.
The petitioner is before this in suit ಯಾವ ವರ್ಷದ?
2015, my.
The petitioner is before this court seeking the following prayer. The petitioner is the plaintiff partition alla tane?
No, my lord. Declaration.
Institutes a suit for declaration which is said to be pending before the declaration in OS 141 of 2015. 10 years have passed by. The counsel for the petitioner submits the trial is not concluded as repeated adjournments are granted. In the light of the said submission is also the prayer being innocuous. I deem it appropriate to direct the concerned court to dispose the suit in OS 141 of 2015 filed 10 years ago with an outer limit of 8 months from the date of receipt of the copy of this order, if not earlier. Ordered accordingly. Next.
331 adjourn. 332.
With a typed copy of manuscript on the typed copy of manuscript on the impugned order.
Manuscript.
Impugned order is in type, my lord. Other
Impugned order is in type. What is in script?
ಆರ್ಡರ್ ಶೀಟ್ ಇದು ಕೆಲವು ಇದು ಪ್ಲಾಂಟ್ ಇದು ಅಮೆಂಡ್ಮೆಂಟ್ ಮಾಡಿದ್ರೆ ಮಾತ್ರ ಇದೆ. ಅದ್ರ ಮೇಲೆ ನಾವೇನು ರಿಲೇ ಆಗ್ತಾ ಇಲ್ಲ. ಓನ್ಲಿ
ಆಗ್ತಾ ಇದೆಯಾ?
ಇಲ್ಲ, ಮೈ ಅಪ್ಲಿಕೇಶನ್ ಫಾರ್ ಪರ್ಮಿಷನ್ ಟು ಫೈಲ್ ದ ರಿಟರ್ನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ದಟ್ ಈಸ್ ರಿಜೆಕ್ಟೆಡ್. ಸೊ ಅದನ್ನ ಮಾತ್ರ ಚಾಲೆಂಜ್ ಮಾಡ್ತಾ ಇದೀನಿ.
Office objections overruled Monday preliminary hearing. Next.
333.
My lord, the trial court has stayed the proceedings of another trial court, my lord, hence this writ petition. The trial court has stayed the proceedings of another trial court.
Another trial court.
Under section 10, which is impermissible, therefore, my lord.
Alla, another trial court.
Please, my lord. FDP has
Office
been
objections overruled. List the matter on Monday in preliminary hearing. Next.
Much obliged.
34.
A week's time is granted to comply with the office objections.
335.
That's the only office objection is the LRs of original plaintiff have been arrayed as R1 to R5.
have tendered a counsel submission to that effect.
Bedwa,
Notes they have been already arrayed as parties. So that's the office objection.
accepting the submissions of the council, office objections overruled. List Monday.
Please, Mr. I may be permitted to serve Mr. Jwala Kumar.
Aವಾಗ fresh matter is preliminary ಬರಲ್ಲ.
The intersuit
Entry
may be-
ಮಾಡಿದ್ರೆ ಕೊಡಲ್ಲ.
ಅಲ್ಲ, the suit may be itself closed. That's why. That's a
Oh.
peculiar scenario.
Then we'll counsel for the petitioner to serve on KDB. ಯಾಕೆ?
Not KDB has already been served. State has already been served.
No,
It
why?
was a-
What's the matter?
Suit was for not seeking a easementary right. Now government has already formed a road.
So what survives?
Exactly, Mr. So if that can be taken on record and positive.
Close, yes.
That is right.
The learned counsel for the petitioner is before this court seeking the following prayer. The learned counsel for the petitioner Sunil S. Rao submits that the claim was for easementary rights quay against the state. The government is said to have already formed the road. Therefore,
It is a plaintiff's claim. So let them, they will have to come and answer to that.
plaintiff,
I am the defendant.
you are the defendant.
The defendant.
So and so. Government, the learned counsel submits the government has already formed the road. Therefore, the said submission be verified by the learned AGA, learned AGA. Learned AGA is directed to accept notice for
R15,
R
R6, R17.
R17.
16 by
List the matter on first for preliminary hearing.
Jwala Kumar, I should serve him by hand. For
Other
the remainder claim.
ಇನ್ಯಾರಿದ್ದಾರೆ?
Mr. Jwala Kumar, advocate, not.
For whom?
R1 to R15.
R1 to learned counsel Jwala Kumar. Learned counsel of the petitioner submits that counsel Jwala Kumar appears for respondents 1 to 15
Before the trial.
before the trial court. Therefore, the petitioner is at liberty to serve on the said counsel. List on first and preliminary hearing.
336.
I appear for the petitioner, my lords. The only office objection, my lords, we have used the highlighter in the annexure D, my lords.
Office objections overruled Monday. Yes, next.
37.
My lords, a week's time may be granted to comply the
Week's time is granted to comply with the office objections. Next.
338.
Kindly have it on Monday, your honors. Monday, petition. Interim.
GMCPC ಹೆಂಗ್ ಬರುತ್ತೆ ಇದು?
It's a compromise petitions, your honors.
Correct. KDB. GM ಹಾಕ್ಬೇಕು.
Senior will convince
The petitioner. What is called in question?
interim compensation distribute mobile.
ಅಲ್ಲ ಸಿವಿಲ್ ಕೋರ್ಟ್ ಆಗಿರೋದ?
Yes.
OS 509 of 24. ಲೋಕ ಅದಾಲತ್ ಎಲ್ಲಿದು?
Lok Adalat, your honors.
Office objections. Accepting the submission of the council office objections overall list on Monday. Preliminary hearing. Next.
339.
For petitioner, my lord, kindly posted to 28th, my lord.
Oi.
Connected matter ಇದೆ ma'am.
Office objections overruled. List the matter on first. Next.
340.
For the petitioner, my lord. That advocate appointed.
Overruled first.
341.
But in this case, my property has been
overruled first.
342.
Date
First.
See, the party's defendant number 2 has died during RFA. This is a matter where RFA, the matter is remanded back. But in OS, he's not been arrayed as a party. They're legal representatives.
Overruled. Monday.
That's day after tomorrow,
Monday. Yes.
September 1st. my lord.
Irada next Monday then. Yes.
It should have been a CRP. I may be
Converted.
I'll convert it.
The learned counsel for the petitioner seeks leave of this court to convert the subject petition as a CRP in the light of the order being revisable. The petition so sought, the permission so sought is granted for the statistical purpose. Petition stands with post. Next.
344.
Here for caveat respondent number 1 in this case.
Overruled Monday.
345.
Subjection is legible copy of annexure A.
Overruled Monday.
346.
Lordship,
Your Lordship, in the lower court of Bin, I filed a suit for declaration and a consequential injunction. Your Lordship, so my ex parte order was rejected,
Ex parte order?
was rejected. So
Rejected or not granted?
it was not granted, my lord.
Not considered?
It was not considered. Emergent notice was issued.
All right.
Your Lordship,
Office objections.
office objection, I will clear it, Your Lord.
If you are going to clear it, we'll hear it after clearing it.
Okay.
Yes. First, learned counsel seeks a week's time to comply with the office objections. In the event the stand complied, list the matter on first and preliminary hearing. Yes.
347.
Happy for the caveat in the matter, my lord.
I'm for the petitioner in this. The office objection is why I have not made all the defendants a party.
Overruled Monday.
Grateful, my lord.
348.
Please, your lordship.
Overruled Monday.
349.
Urgency unta?
We are in possession of the.
Be in possession.
Status quo maybe.
No, Monday, yes. Next.
350.
There is another writ petition.
Copy of the objection filed in the appeal
Overruled.
is sought.
Overruled 1st September. Innondidiya?
Day after, please, 25145.
Tag this petition along with
25145.
25145 of 2025.
Day after.
Why?
Lord, there is a threat of encroachment and
ಅದರಲ್ಲಿ ಎಂಟ್ರಿ ಮಾಡ್ರಿ ಇದೆಯಾ ಬಂದಿಲ್ಲ ಒಂದ್ಸರಿ
the fresh matters ಎರಡು ಕೂಡ.
ಡೇ ಆಫ್ಟರ್ ಟುಮಾರೋ ಎಸ್
Obliged.
ಅಂಡ್ ಪ್ರಿಲಿಮಿನರಿ ಹಿಯರಿಂಗ್ ನೆಕ್ಸ್ಟ್
351.
Appear for the respond number 1, my lords.
ಓವರ್ರೂಲ್ಡ್ 1st September ಎಸ್ ಇದು 351 2nd September ಟ್ಯೂಸ್ಡೇ ಎಸ್ ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ ಅಲ್ವಾ
Fresh matter.
ಮಂಡೇನೆ
First.
ಎಸ್ 1st September 352 overruled 1st
Filed wakalat for R2.
Registry to print the name of PV Chandrasekhar is appearing for the board.
R2 and R3.
R2 and R3.
R4 mystery, Metro Krishna.
One AGA, N issue.
Interest bill answer.
List on the 9th September. Yes, next.
353.
Only copy serving KDB.
Huh?
Copy serving copy KDB.
Copy to be served on the board. That was.
That's the objection. Counsel for the petitioner submits office objections has been complied with. Kodi copy. Complied with. List the matter on 9th. What's the matter?
KDB.
ಅದು
Prior
ಗೊತ್ತು.
notification. Challenging.
Final ಆಗಿಲ್ವಾ?
Interim.
The petitioner, if in possession, shall not be disturbed till the next date. List on 16th September.
355 also the same.
ಬರ್ಲಿ 4 ಇದಾ?
355 ಒಂದಿದೆ.
ಇದು 353 ನಾ?
3.
354 ಮುಗಿಲಿತ್ತು.
Please, sorry.
354.
Overruled 2nd, well, 1st, sorry, preliminary hearing. 355, same order as 353.
Please, Lord.
Huh? ಹೌದಾ? 10 days time is granted to comply with the office objections. ಯಾವ್ದ್ರಲ್ಲಿ 354 ಅಲ್ಲಿ? Yes. 355, same as 353.
356.
A week's time is granted to comply with the office objection.
357.
Mandamus minutes for issuance of compensation minutes mandated in the previous writ. If it could be for first minutes.
Dispose ಮಾಡಲಾ?
Already either writ ಆಗೋಗಿದೆ. Where the court has also said that.
Presentation dated 15/1/25 is pending.
25. ಹಳೇದು 5-6 ರಿಟದ್ ಮರ್ತ್ಬಿಟ್ರಿ ಹೊಸ ರೆಪ್ರೆಸೆಂಟೇಷನ್ ಬಗ್ಗೆ ಮಾತ್ರನಾ?
Contempt ಆಗಿದೆ 2 ಸರಿ.
ಈಗ
Cost was
ಅದೊಂದು
imposed.
Will dispose it or what?
Let them compute the compensation so that they can come back by 7th or 8th.
Irli. The learned AGA is directed to accept notice for the respondent. The representation is submitted on 15/1/2025 in furtherance of 5 orders passed by this court. In the event the respondents would not compute the compensation by the next date, it would fringe on the borders of contempt. List the matter on 9th September. Yes. Office objections overruled anta ಮಾಡಿ ಇದು ಮಾಡಿ.
I have not challenged the acquisition proceedings.
What have you challenged?
I have challenged only payment of interest to the compensation.
ಆಯ್ತು. Office objections overruled. List on 2nd.
And notice may be added to the respondent.
List on
Only
1st.
interest.
Yes, next.
359.
For respondent. Copy has been served to KDB, my lords. And then
ಅಲ್ಲ ಇದರಲ್ಲಿ
ಜನರಲ್ ಅವಾರ್ಡ್ ಅಮೌಂಟ್ ಎಲ್ಲ ಕೊಟ್ಟಿದ್ದೀವಿ, ಇಂಟ್ರೆಸ್ಟ್ ಕಮ್ಮಿ ಕ್ಯಾಲ್ಕುಲೇಟ್ ಮಾಡಿದ್ದಾರೆ ಅಂತ ಓನ್ಲಿ ಸ್ಮಾಲ್.
But the award has been passed over delay of 16 years, my lords.
ಅದು ರೇಟ್ ಇಂಟ್ರೆಸ್ಟ್ ತಗೊಂಡು
Still in
List
possession
on-
of the property.
29th ಜನರಲ್ ಅವಾರ್ಡ್ ಕೊಟ್ಟಿದ್ದೀವಿ.
List on 2nd September. Yes, next. Well, better. Let it come on. Wait, madam.
That's
Next,
first, not
next
because I'm
irade adu. 2nd September. Yes, next.
The office objection may be overruled.
Office objections overruled. Next. Rajeshwar.
360.
My lord, the office objection is that the petitioners 1 P3 to P5 are not a party in our representation.
Overruled first. Next.
Date may be fixed.
361.
361 or the respondent BD.
Overruled first. Typed copy hakilva?
Typed copy hakil maadu. So in earlier in writ
The
petition. not-
petitioner, the office objections, adonde iradu.
Lord, so
The office
only
objections be
some-
complied with by the next date. In the event the stand complied, list the matter on first.
Lord, some manuscripts are.
Manuscripts madad bedva?
Receipts ಇದಾವೆ.
Work madad bedva? Yes, next.
362.
Officer raised objection for non-production of.
Court fee, sir.
Court fee I made good, man.
Learned counsel submits office objections qua court fee, stands complied. Insofar as other objections, they stand overruled. List on Monday.
363.
Lord, connected to serial number 170. It was ordered to list on Friday.
170 tag, list on Friday.
Office objection may be overruled.
Overruled, office objections overruled. Yes, next.
364.
Counsel submission, office objections overruled. List on Thursday in preliminary hearing. Next.
365, my lords.
Ah.
Matter has become infructuous, my lords.
Thank you, sir.
Withdrawing.
Counsel for the petitioner submits that the matter is
But similar, in the identical matter, an order was passed, my lords. My lords can.
the learned counsel for the petitioner submits that covered infructuous.
Identical matter, similar facts, my lords.
ಇದು ಯಾರು ಕಮರ್ಷಿಯಲ್ ಟ್ಯಾಕ್ಸ್ ಮೇಡಮ್ ಬನ್ನಿ ಟ್ಯಾಕ್ಸ್ ಏನ್ ಮೆಕ್ಕಿದೆಲ್ಲ learned HCGP is directed to accept notice for the respondent.
Withdrawing, my lords.
The learned counsel submits in identical circumstances. The coordinate bench has passed the following order permitting the petitioner to withdraw the petition and avail of such remedy as available in law. In writ petition, so and so. In that light, the petition is disposed as withdrawn, reserving liberty to the petitioner as is granted by the coordinate bench. Yes, next.
366.
Well, it's better copy of annexure A2 has been asked. Page 36 is what is unclear and.
Overruled. Urgency?
Thursday.
Thursday, yes. Next.
367.
My lords, the office objection have been complied with. It's an ex parte orders. It has to be remanded back.
Overruled Thursday.
Grateful, my lords.
368.
Yes, Sonamale.
Office
Your Lordship, Dilip will take notice.
Overruled Thursday. EI Sanmati is directed to accept
Your Lordship,
notice.
Dilip Miller, Dilip.
Dilip is directed to accept notice for the respondent. List on
125, my lord. Respondent 125, M. Dilip, my lord.
Yeah.
So for respondent number 6, emergent notice may be issued.
6 emergent notice. Covered?
No, my lord.
Emergent notice returnable by list the matter on 11th September. Next.
369.
Remanded back. Only 3 days time was given, my lord, to reply to the show cause notice, my lord. Annexure H is the show cause notice, my lord. It is 18/2, my lord.
In law, ಎಷ್ಟು ದಿನ ಬೇಕು sir?
7 days, my lord.
ಅಲ್ಲಲ್ಲ ಅವ್ರು ಹೇಳೋದು 3 days time ಕೊಟ್ಟಿದ್ದಾರೆ, minimum 7 days should could have been given. So the show cause notice a very short time was given. Order was passed on 8/3/25. So it may be remanded back to the stage of reply to show cause notice dated 18/2/25.
The petitioner is before this court seeking the following prayer. Heard so and so. The petitioner.
Page 36.
1 minute, sir. A show cause notice comes to be issued against the petitioner on 18/2/2025 under section 148 to submit a reply on or before 21/2/2025, which is barely 3 days after the issuance of show cause notice. Since the reply was not submitted an order comes to be passed on 8/3/2025, it is this that is called in question. The learned counsel appearing for the petitioner submits that in the minimum 7 days notice ought to have been rendered in the show cause notice and not 3 days. In the light of the said submission, 3 days, and therefore the order is passed in violation of principles of natural justice. The learned counsel appearing for the respondent would not dispute the position as is narrated here and above. In that light, the petition deserves to succeed on the sole ground. Yes.
He has also filed an appeal. He will undertake to
withdraw that.
On the sole ground of violation of principles of natural justice. The learned counsel for the respondent, the petitioner now submits that he has preferred an appeal against the said order and would undertake to withdraw the said appeal. In the light of the said circumstance, I deem it appropriate to dispose the petition with remitting the matter back to the hands of the assessment officer. Back to the hands of the assessing officer to consider the issue from the stage of seeking reply to the show cause notice dated 18/2/2025. The petitioner shall now submit his reply to the show cause notice within 1 week from the date of receipt of the copy of this order. In the event the reply is submitted within 1 week from the date of this order, the proceedings, the reply be considered in accordance with law and proceedings regulated thereafter.
There is one problem, Lord. This problem, Lord, is due to the incorrect statement given by the bank, Lord, to the income tax department. And
let the assessing officer verify from the bank.
The learned counsel for the on para hakinde submits that the show cause notice is occasioned on the score that there is incorrect
26A statement.
Incorrect 26A statement rendered by the bank. Therefore, before consideration of the on the reply being submitted, the assessing officer shall verify with the bank with regard to the
Deposits.
correctness
of the bank.
with regard to the correctness of the
cash deposits made in the
1 minute with regard to the correctness of cash deposits made to the bank, and then pass necessary orders and then pass orders in accordance with law. For the aforesaid reasons. Yes, next.
Objection is with regard to production of certified copy.
Overruled Thursday.
371.
My lords, this annexure E, ineligible but not legible, but
Ineligible but not legible.
not legible. My lord, this it has downloaded from the portal. My lord, it has come like that.
Yen madaka. Office objections overruled Thursday.
Just
yes.
372.
No, sir, I was asked to delete a party R2, which is the bank.
Delete madilwa.
I have asked for
Overruled
DSC.
Thursday. Yes.
Next matter, Malas, is covered by decision.
Kudi. Respondent yaar Jeevan Neralge avara? The sweet same.
please. Well, appeal ಅಲ್ಲಿ ಇದಾವ ಸರ್.
ಅದೇ ಇದು ಅಪೀಲ್ಗೆ ಹೋಗಿದ್ಯಾ? ಆಗ್ಲೇ ಹಾಕ್ಬಿಟ್ರಾ?
ಹೌದು, ನೋಟಿಸ್ ಆಗಿ ಇದಲ್ಲ.
The main.
ಮೇನ್ ಮ್ಯಾಟರ್ my lord.
ಇನ್ನು ಆರ್ಡರ್ ಮಾಡೋದು ವಾರ ಆಗಿದೆ. ಆಗ್ಲೇ ರೆವಿನ್ಯೂ has filed an appeal so soon.
That is pending for hearing.
Yeah, yes. The petitioner is before this court seeking the following prayer. The learned counsel for the petitioner submits that the issue in the list stands answered by the said by the so and so orders. In the light of the learned counsel Jeevan Neralge submits that the orders that are quoted in the aforesaid order are all pending in appeal. But however, there is no stay. In the light of the said circumstance, I deem it appropriate to follow the order passed in WP so and so para 3 quote madi. Quote mabitu same order. Yes, disposed.
73.
ವಿಡ್ರಾವಲ್ಸ್ ಇಲ್ವಾ ಅದರಲ್ಲಿ? ಅಲ್ಲ, ಇನ್ನೊಂದು ಸೆಂಚುರಿಗೆ 3 ಬಾಕಿ ಇದೆ. 370?
Three lodge.
Lakshmi madam,
Malaj, we just 373.
same order.
ಅಲ್ಲ, 373.
ಅಲ್ಲ 373 ನೇ ಆಗಿದ್ದೀಗ. 372 overruled Thursday. Yes. ಈಗ ಆರ್ಡರ್ ಮಾಡಿ 373 ಅಲ್ಲಿ ಚೇತನ್. 373.
74.
Lots of certified copies, that may be, it's
Overruled
covered,
Thursday.
covered, my lords. Annexure F, I have produced 109.
Page
109, my lords.
409.
109.
109.
Annexure F, my lords.
Akash, oh, Chinmaya, yes.
No, not Chinmay, my lords.
Then?
This is with regard to supply to BBMP, my lords. Service tax demand on BBMP.
The learned counsel for the petitioner is before this court seeking the following prayer. The learned counsel for the petitioner submits that the issue in the list stands answered by the judgment rendered by the coordinate bench, page 111. The coordinate bench has held as follows. Copied from page 129, para 18 in the end. In the light of the said division bench confirm ಆಗಿದೆಯಾ?
No, my lords.
In the light of the issue standing answered by the coordinate bench which is not disputed by the learned counsel, a full ಬೇಡ, ಅದು beginning order ಮಾಡಿಬಿಟ್ಟು ಆಮೇಲೆ para 30 ಮಾತ್ರ quote ಮಾಡಿ. In the light of the issue standing answered, I deem it appropriate to dispose the petition with the same order that is passed by the coordinate bench. The order for the aforesaid reasons, the following order, page 152 to 154, same order, ordered accordingly. Heard so and so ಅಂತ ಹಾಕಿ ಇಬ್ರದ್ದು.
Matter to be relegated to respond number 1, my lords.
Same ಅಲ್ಲೇನ್ ಮಾಡಿದಾರೆ ಅದು. Yes, next.
375.
Because of the petitioner, all the annexures have been downloaded from the portal.
Overruled Thursday.
Thursday, common show cause notice. Consolidated.
Interim order ಮಾತ್ರ ಅಲ್ವಾ?
I may be given a stay and then
Thursday.
oblige, my lords.
It's number 2. Order still number 1.
Appearing for the petitioner. Memo.
It's number 2.
Writ petition filed against orders of the trial court allowing application under order 6 rule 17 for amendment of written petition, written statement filed by defendant 5 to 7 in on.
ಈ ಆರ್ಡರ್ಸ್ ಅಲ್ಲಿ ಏನ್ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ? ವೆಕೇಟಿಂಗ್ ಸ್ಟೇ. List the matter day after tomorrow under the caption interlocutory applications. Next.
Please, great.
Post immediately after service of notice upon respondents 4 and 5.
Number 3.
Same order, entry ಮಾಡಿದ್ರೆ continue ಮಾಡಿ. ನಿಮ್ದು ಆಯ್ತು? Yes. Next. I've gone to the next 3 matters. Yes.
Serial number 4, my lords, same issue as 202, consolidate, the Chinmay, 202.
Overruled Thursday.
Oblige.
5.
Serial number 5 appear for the petitioners, my lord.
Why
This is the
will
matter we
it-
mentioned.
No time today. Yes, list on Thursday.
Interim order may be extended.
Interim order subsisting will continue to the next date of hearing. Next.
Obliged.
I served the copy, my lord. On 14/8, I served the copy, my lord.
Counsel for the petitioner submits needful has been done. Office to verify. Next.
Respect of
Interim order
compromise
ಇದೆಯಾ?
decrement. No, my lord, that's why, my lord.
List the matter on
Thursday, my lord.
Thursday ಇಲ್ಲ.
My lord,
Friday.
it's a compromise decrement.
Friday.
Fraudulent, please.
Friday.
7.
Petition, my lord. Kindly see the annexure E, my lord. Annexure E, page 38, my lord. I have since 1990, my my death of great grandfather, we are in position, my lord. Annexure E.
ಈಗ ಏನಾಗಿದೆ?
ಅದರಲ್ಲಿ ನಮ್ಗೆ ಅವರು they are if a respondent only our
What
neighbors.
is the order under challenge?
Order, I have implemented file application under order, implementing application, it was rejected, my lord. In the trial court. But we are still, we are since 2019, 2011, 1919, we are in position, my lord.
ನಿಮ್ ಪೊಸಿಷನ್ ಇರಕ್ಕೂ ಆರ್ಡರ್ 1 ರೂಲ್ ಅಂಡ್ ಆರ್ಡರ್ 1 ರೂಲ್ 10 ರಿಜೆಕ್ಟ್ ಆಗಕ್ಕೂ ಏನ್ ಸಂಬಂಧ?
Because we know that, but the one respondent only our neighbors, they are serving with the different serial numbers, they are in acquiring different. They colluded with the government officials, to transfer the khata in the name of this himself, my lord. Kind of annexure.
Please, serve ಮಾಡಿ ಅವ್ರಿಗೆ. Counsel put to serve on the counsel representing the defendants before the concerned court. ಯಾರಲ್ಲ plaintiffs.
Plaintiffs, Shivshankar plaintiffs.
ನೀವು impleading applicants ಆ?
ಹೌದು, please.
ರಿಜೆಕ್ಟ್ ಆಗಿದೆಯಾ?
ರಿಜೆಕ್ಟ್ ಆಗಿದೆ ಅದು.
petitioner to serve on the council representing the respondents before the concerned court and file an acknowledgement of such service, 3rd September.
8,
List the matter on 3rd September in preliminary. Next.
9,
Lords, I appear for the petitioner. Lords, petition seeking direction for speedy disposal.
Thank you, sir. The petitioner is before this court seeking the following prayer. Suit of
Plaintiff.
suit for
A permanent injunction.
the petitioner petitioner is the plaintiff, huh?
Yes, please.
Institutes a suit for permanent injunction in OS 789 of 2020. The allegation is that the suit is still pending without trial is commenced.
Trial is commenced.
Without the conclusion, notwithstanding the fact that the trial has commenced long ago. In the light of the prayer being innocuous and the suit being of permanent injunction, I deem it appropriate to direct the concerned court to dispose the suit with an outer limit of 6 months from the date of receipt of the copy of this order.
4 months, please.
6 months.
Great.
If not earlier, ordered accordingly. Next.
10,
My lords, on 23/2/2025, an interim order came to be passed by the trial court in favor of the petitioner, restraining the respondent defendants from changing the nature of the property. Your lordship will get that order at page 36. Later on, the defendants enter their appearance, file the written statement, also file a memo adopting written statement as their objections to this application. My lords, thereafter, my lords, recently, they tried to change the nature of the property by putting up construction. Annexure E1 series, page 45 onwards, photographs. There, my lords, I get the matter advanced, file an application to
Police protection reject ಆಗಿದೆಯಾ?
seeking for police protection.
Reject ಆಗಿದೆಯಾ?
Nothing. The trial court, without considering the urgency, has posted it for 1/9.
Don't worry, we'll try it. The counsel for the petitioner is a plaintiff, institutes a suit in OS 938 of 2023. He is before this court at this juncture alleging that notwithstanding the grave urgency in the matter, an application filed before the concerned court seeking grant of police protection is adjourned to
1/9.
or 1/9/2025. The counsel for the petitioner submits police protection in the case at hand is imperative to implement the order of injunction that is in his favor. In the light of the application pending consideration at the hands of the concerned court, I deem it appropriate to direct the concerned court to hear the parties and pass necessary orders on the application with an outer limit of 1 week from the date of receipt of the copy of this order. Since the matter is adjourned to 1/9, the petitioner plaintiff is at liberty to file necessary memo seeking advancement of the case after serving the memo on the counsel appearing for the defendant.
In a robust manner, they are undertaking construction, my lords. The police has issued an endorsement in civil dispute.
One minute, so and so.
They'll complete the construction itself.
In
That is
the
urgency.
light of the aforesaid circumstance, and the direction issued to the concerned court to dispose the application, the parties shall not precipitate the matter qua the construction till the concerned court disposes the said application. Yes.
The jurisdictional police, my lords, if we
No,
can.
no, so and so. The one ಕೆಲಸ ಮಾಡು. There shall in the light of so and so, the police shall not precipitate the matter with regard to the construction of the property.
ಅವ್ರಿಗೆ ಅರ್ಥ ಆಗಲ್ಲ precipitate.
ಮತ್ತೆ ಇನ್ನೇನ್ ಮಾಡಕ್ ಸ್ಟೇ ಎಲ್ಲ ಕೊಡಕ
The-
ಅದಕ್ಕೆ
ಅಲ್ಲ,
ಅರ್ಲಿಯರ್
stay
ಆರ್ಡರ್
ಅಲ್ಲ.
ಬೆಟರ್
ಅಲ್ಲ, my lords, ಇದಿರ್ಲಿ. ಇದಿರ್ಲಿ.
ಅರ್ಥ ಮಾಡಿಸ್ತೀರಾ? The aforesaid observation, the petition stands disposed.
Great, my lords.
11,
The decree holder filed an application.
Here for the respondent, my lord.
My lord, for disclosure of assets under 21 rule 41, my lord. Kindly see page 200, my lord. In that, the information which have been sought, which is completely outside the purview, which is been, my lord, fixed in appendix C to form number 16, my lord, which I produced before this honorable.
What is this?
Lord,
Recovery of money?
Yes, my lord. Arbitral award.
Kindly see for a minute 200.
Covered,
Page-
sir.
No, my lord. Kindly see, my lord, the Honorable High Court of Delhi.
ಅಯ್ಯೋ ಸರ್ ನಾನೇ ಬರ್ದಿದ್ದೀನಿ ತಗೊಳ್ಳಿ.
My lord, form number 16, he clearly says what are the information need to be disclosed with respect to recovery of money where, my lord, the decree holder
Anyway,
makes an
office
application.
Office objections ಏನಿದೆ?
Office objection with respect to service of.
ಇದು ಬಂದಿತ್ತಲ್ಲ ಮೊನ್ನೆ?
Yes, my lord, because the
Same.
clear was not present, my lord.
ಹಾ, yes. ಇನ್ನೂ ಕಂಪ್ಲೈ ಮಾಡಿಲ್ವಾ?
No, it's been complied, my lord, they have been served.
Petitioner, office, submits office objections has been complied with. In the event they stand complied, day after tomorrow in preliminary hearing.
Great.
Admission 12.
Appearing for the petitioners, my lord, not petitioners and the respondent number 2 both are present.
Settlement.
Settlement, it's 306 and 498A, my lord.
Oh.
My lord, the second respondent has also.
306 ಯಾರ್ ಮೇಲೆ?
Husband and
Who has
father-in-law.
committed suicide?
Wife. My lord, however, this complainant has also filed an affidavit before the investigating officer, my lord. I have produced that also in the last, in the previous occasion. He's present here before the court, my lord.
So what?
Not on misconception of
ಸೆಟಲ್
facts.
ಮಾಡೋದು ಕಷ್ಟ ಸರ್. You come on merits, it's better.
Even on merits, my lord.
Even on ಅಂದ್ರೆ ಈಗ ಸ್ಟೇಜ್ ಅಲ್ಲ. Settlement ಇದ್ರೆ settlement. You want to come on merits, come on merits.
A date may be fixed, my lord, on any date, my lord.
List the matter on Friday 22nd.
Please.
ಆಗುತ್ತಾ ಜಗದೀಶ್ ಸರ್? Friday 22nd. Come
Grateful,
on
ma'am.
merits, no settlement in 306 case.
Please, grateful, my lord.
Yes.
15.
Appearing for petitioner is, my lord, application under 350, 451, 457 has been rejected, my lordship. On the ground that a trial has to take place, my lord. My money.
Your money.
Please, my lord.
How much money?
52 lakhs was 75 years lady, my lord. Nephew frauds, cheats her, and he takes.
You are the complainant.
I'm the complainant, my lord.
Notice has been served to the accused.
Notice have been served?
To the accused.
Accused can.
Accused,
Let the court is not considered.
They reject that application, the trial has to take place on that. Trial, after trial, it may be reject model.
Well, list on 22nd.
Please, ma'am.
14.
For the petitioner in this case,
My lords, in this case, I'm up here for the respondent number 2, my lords.
there is a stay on the case, my lord. However, the petitioner's passport is due for renewal. So, and it has come for police verification and they're asking for the orders of this honorable court to issue the passport. I'm filing an IA.
File the objections.
Charge sheet ಆಗಿದೆಯಾ?
Charge sheet ಆಗಿದೆ, my lord.
Short validity.
My lord has
passport.
stayed the proceedings.
No problem. Short validity passport.
Charges have been framed.
Charge frame
My
ಆಗಿದೆಯಾ?
lords, already charges already.
But your
framed, my
lordship
lords.
has
One
made
minute.
an observation.
ಯಾವತ್ charge frame ಆಗಿರೋದು?
26.
My lords, in the last date, in this petition, my lords.
26/10.
2023.
Petition filed on?
Petition filed on 17/3/2025.
My lords, may I make one submission, my lords? In the earlier
My
round
lords
of
had made
litigation,
an
my lords.
observation saying that whatever is mentioned in the charge sheet, it is just in minor altercations between husband and wife. So there is no criminal element nor there is any observation made for bringing in section 498A, and your lordships had stayed on the previous occasion.
Passport ಯಾಕೆ ಬೇಕು ನಿಮ್ಗೆ?
Not, it is due for renewal, my lord.
ಪರವಾಗಿಲ್ಲ. No problem. We'll see. List the matter on 12th September. Interim order subsisting will continue till the next date of hearing.
15.
My lord, I appear for the petitioner, my lord. My lord, the senior has underwent with cellulitis surgery, my lord. Therefore, I requested all lordship to have this matter on next Monday, my lord.
Short question involved, you know.
Interim order. may
Regarding a work property, I'm the developer, I was been leased the scheduled property.
Work property.
Work property.
ಏನದು?
One respondent number 1 has raised an alleged complaint before the work board. Based upon the complaint, the board has deemed it as a work property. Challenge is same, the present.
It's not a work property?
It is not a work.
It is a work property.
How
my
did
lord.
it come to your possession?
By petitioner, they are the owner of the property. That was been leased to me to develop the property.
Leased to you?
Yes.
All right. ಆಮೇಲೆ?
My lord.
Wait man.
There's short question involved, you know.
ಆಯ್ತು, leased to you what?
To develop the property. Need
The learned counsel
request to be
appear-
heard. Any date maybe, short date maybe.
Learned counsel appearing for the petitioner seeks time. Learned counsel for the respondent submits what is involved in the case at hand is a short question of law. In that light, list, when do you want, madam?
25th, my lord, Monday.
25th, holiday, madam.
Monday, my lord.
Holiday.
If not 26th.
List the matter on 28th.
Please. Please.
It made clear, since the matter is of the year 2022, no further adjournment would be granted.
My lord, interim order may kindly.
Interim order subsisting.
Has not been served on.
We have.
ನೀವ್ ಯಾರಿಗೆ?
R2.
we have
Interim order subsisting will continue to the next date of hearing. The petitioner to serve complete set of papers upon all the respondents, if not already served. Yes, next.
B group 16.
My lord, writ of mandamus or direction to the respondent to consider the
lords.
representation made by the petitioner.
Copies not served, my lords.
Will be served.
Counsel for the petitioner to serve
My
set
lord,
of
in a
papers
similar-
upon counsel Shri B.S. Sachin list the matter on 2nd September in preliminary hearing. Avata dispose ಮಾಡಿ.
Please, my lords. Obliged.
ಇವತ್ತಿಗಾಗಿದೆಯಲ್ಲ ಸಾಕು.
17.
For respondent number 2 and 3, my lords. My lords, GB Sharad Gowda has to be listed, my lords. TP Vivekananda and Bharti.
Ilva?
Illa.
Counsel GB Sharad Gowda is said to have entered appearance in place of TP Vivekanand. Therefore, registry to print the name of GB Sharad Gowda and delete the name of TP Vivekanand. Yes, next.
18.
Lord, I appear for petitioner.
Lords, this matter, my
My
lord.
lord, and out of an extent of 4 acres, 17 guntas.
List the matter on 2nd September in preliminary hearing.
Like they have included my property.
2nd
though it is not-
September in
it is
preliminary
not
hearing.
acquired, my lord.
2nd September. Nadid. Yes.
Lord.
Next.
19.
I am for the respondent. The copy is now served.
Petitioner to serve set of papers upon the counsel K. Krishna forthwith. Yes, next. 2nd September.
20.
My lord, I appear for
Second,
the
but 9th
petitioner.
September. 20.
Krishna, I have served on Krishna, my lord, if he has instruction.
My lord, they served the copy, my lord. I will get the instruction. It shows that it is a park area, my lord. But they are
List the matter on 2nd. Interim order diya?
Interim order ಕೊಟ್ಟಿದ್ದಾರೆ.
List the matter on 9th September.
ಅಲ್ಲ, interim order, it is a park area, my lord. As per their own document, it shows as a park area.
My lord, in fact, this property was granted to Muni Lakshmamma.
It is not.
They approved the.
Muni Lakshmamma.
She was the owner of the property. my lord.
ಹಂಗೇಳಿ owner of the prop. Muni Lakshmamma ಅಂದ್ಬಿಟ್ರೆ?
ಅಲ್ಲ, this is,
belongs-
my lord, as per the facts of the case, my lord, they mentioned different. As per the document.
2nd September in preliminary hearing.
Please. My lord, interim order.
Hearing on.
Interim order subsisting will continue.
ಅಲ್ಲ, interim order ಇದೆಯಾ? ಇದೆ. Interim order.
If interim order, if any shall continue to
My lord,
the
it is
next.
there.
If any.
Please.
21.
Now for the petitioner, my lords.
See, 10 days time to file objections.
ಏನ್ interim order ಇದೆಯಾ?
Interim order.
List the matter on 12th September. Objections, if any, by then. Interim order subsisting will continue till the next date of hearing.
22.
22, I appear for the petitioner.
I am for respondent, my lords.
Ready, my lord.
You ready?
Please, any date, my lord, subject to my lord.
ಬೆಳಗ್ಗೆ ರೆಡಿ ಇರಲ್ಲ, ಸಾಯಂಕಾಲ 5:30 ಮೇಲೆ ರೆಡಿ. Yes.
My lords, it may be listed on
12th
23rd.
September interim order subsisting will continue to the next date.
May be listed on 23rd, my lord.
Oh, this is ಯಾವ್ದು? CPC.
Yes, my lord.
List the matter on 3rd September. Interim order ಏನಿದೆ? ಒಂದ್ ನಿಮಿಷ. Oh, ಇವ್ರದಾ? Due to positive time. List the matter on 12th September. Next.
Interim order may be
ಬೇರೆ ಕೋರ್ಟ್ ಡೇಟ್ ನಮಗ್ ಕೊಡ್ಬೇಡಿ. Yes, next.
Grateful.
Interim order may be extended.
Interim order subsisting will continue to the next.
23.
Order 12 Rule 6 application was rejected, my lord, despite the only contesting respondents are the ones who are registered vendors who sold the property 31 years ago, my lord. Therefore, there is some urgency. They admit the fact that they
List the
sold the
matter on 12th September.
property. Interim order may be
Interim order
extended.
subsisting will continue.
A
to the
short
next.
date, my lord.
No, sir. You have taken date in the other court. I will not follow that. Yes.
24.
Next.
Can you grant 2 weeks time?
Interim order ಇದೆಯಾ?
Interim order.
ಮತ್ತೆ 2 weeks ಬೇಕು.
Date might be fixed.
ಇವತ್ತು ಏನೋ ಟೈಮ್ ಕೇಳಿದೆ, ಅರ್ಜೆನ್ಸಿ ಇದೆ ಅಂತ ಹೇಳಿದ್ರೆ ಅಲ್ಲಿ.
ಅಲ್ಲ, preliminary hearing ಆಗಿದೆ. IA is not pending. IA ಮೇಲೆ
List the matter after 2 weeks. Interim order subsisting will continue. Next.
Further hearing 25.
25 only, I think that.
in this case.
Who has entered appearance? There. Oh, ನೀವೇ ಇದ್ದೀರಾ? We'll hear your cases separately. Dealing 25 from 25.1 and so. List 25 separately on 22nd. ನಿಮ್ದ್ರಲ್ಲಿ interim order ಇದೆಯಾ?
ಇದೆ madam.
25.1 to 5. Interim order subsisting will continue till the next date of hearing. List on ಅದು next week ಹಾಕಿ ಮೇಡಮ್. List on 29th ನಿಮ್ದು.
Please.
Name to be shown.
Registry to delete Desreddy is still there?
He's not.
ನಿಮ್ಮ ಹೆಸರು ಹಾಕ್ಲಾ?
ಇಲ್ಲ ಮೇಡಮ್ ಆಫೀಸ್ ನೇಮ್ ಇದೆ ದೇಶರೆಡ್ಡಿ ಅಂಡ್ ಅಸೋಸಿಯೇಟ್ಸ್.
Registry to delete the name of Desreddy G and print the name of Desreddy Associates. Yes. 26.
26.
Twenty-six point one and two I appear for the petitioners, my lords.
ಏನಿದು?
My lords, that amendment to registration of birth and death, my lords, that power was taken over from the judicial magistrate to executive magistrate.
Oh, yes, yes. Supreme Court has directed disposal. List the matter on Thursday in preliminary hearing.
Please, my lords.
For further hearing at 2:30 p.m.
Please. Interim order make
Testing will continue to the next.
Most grateful.
27.
This is the contempt matter, my lords. What has happened is that after I receive when my name is shown, my grant is in my name.
19th contempt alla?
Nale Swami, nale ide. I have been summoned, my lords.
Time ಅಲ್ಲಿ ಇದೆ ಆರ್ಡರ್ ಮಾಡಕ್ಕೆ. Interim order ಇದೆಯಲ್ಲ ಇಲ್ಲಿ?
My lords, the difficult, that is the, my lords, what has happened is that.
Achieved it. No, my lords. They have taken the money, my lords, suppressed the interim order, my lords, they received the entire compensation.
You undertake not to precipitate in the contempt, otherwise I will pass an order now.
Actually, they have filed the contempt.
My lords, that is the, I'll explain what is.
They have filed the contempt.
Undertake not to precipitate in the contempt.
Kindly see page 27 of my statement.
In fact, they have filed the contempt petition.
Sir, please allow me.
ನಾ ಹೇಳಿ. ಯಾಕೆ?
ಇಲ್ಲ ಸ್ವಾಮಿ, ಟೈಮ್ ಕಮ್ಮಿ ಇದೆ. He is not allowing.
Time ಇಲ್ವೇ ಇಲ್ಲ.
Time ಇಲ್ವೇ. My lords, I'll explain what. My lords, what has happened is that interim. I had filed a contempt. During the pendency of the contempt, my lords, he's obtained an interim order. My lords, I have come and I have filed wakalat, my lords, not realizing that there's an interim order. My lords, I have received the money on 25th of July 2025, my lords. After I have received the money, he has brought it to the notice of the contempt court. Now, my lords, the contempt court has summoned me for personal appearance tomorrow. Now, the difficulty is this. My lords, I'm in contempt. There's no my lords, I cannot say I don't know all of that irrelevant. My lords, there are 7 suits between the parties. None of the 7 suits, this particular property is there. Suddenly, all of a sudden, an interim order is obtained, my lords. That is the problem. Can something be done, my lords? The matter can be had even tomorrow, my lords.
In the teeth of the interim order, you have.
My lords, I have received.
List tomorrow in preliminary hearing.
Yes.
My lord.
ಆಯ್ತಲ್ಲ ಮೇಡಮ್?
My lord, list 1 serial number 356. Office objection already comply ಆಗಿದೆ, my lord. Council submission ಇದೆ.
ಅದು ಓವರ್ ರೂಲ್ ಆಗಿದೆ ಬಿಡಿ ಸರ್.
ಇಲ್ಲ my lord, 1 week ಅಂತ ಹಾಕ್ಬಿಟ್ಟಿದ್ದಾರೆ my lord. Council submission ಮಾತ್ರ my lord.
ನೀವು ಎಷ್ಟು ಮಾಡ್ತೀರಿ? 400 ಮ್ಯಾಟರ್ ಆದ್ರೆ ನಿಮ್ಗೇನು ಸಮಾಧಾನ?